Okay, that looks like my microphone and my camera are now working. Welcome, everyone. Thank you for joining us today for our Court of Protection training day. Hopefully, you will have seen, certainly in the chat anyway, there's a number of files that you are free to download. And that will include the timetable for the day. I'm very conscious that if we could just have our microphones off, that would be really helpful. Thank you. And I'm conscious that all of you are very busy professionals and that you're probably juggling emails and phone calls throughout the day. That's absolutely fine. I fully expect some of you to be here for specific sessions and then disappear. That's fine. If you want to stay for the whole day, absolutely fine as well. You're very welcome. The reason we're having this today is that it is a repeat of a session we did last year that was very popular and a lot of people were not able to attend. So we thought rather than do something different, we would just repeat it. But also, everything we're talking about today are the most common issues that we get asked about. And I've looked at a number of requests for training and queries that we've had over the past 12 months, and they tend to fit into one of the themes of the sessions for today. You will meet some members of our team today, our COP team. So we are called the COP team. And that could stand for Court of Protection, it could stand for Complex Patient, because the Court of Protection is not the only court that we go to. It is specifically for adults and dealing with issues under the Mental Capacity Act. But there is always a bit of a crossover between those cases and some other cases, for example, for young people, 16, 17-year-olds that may go to the High Court. But as a team, we also advise in relation to lots of different areas of law, but the Court of Protection is the main one. And of course, it encompasses not just the going to court, but dealing with situations that may go to court, but in most cases, working with clinicians and teams, we are able to deal with issues and they may not need to go to court at all. So I'll start with what is the Court of Protection. The Court of Protection covers England and Wales, and it's got a wide range of powers and responsibilities related to the care of people who lack mental capacity. And we're going to talk about mental capacity later, and we're going to look at what that means and how one goes about assessing capacity. I think Iliana's going to cover that later on this afternoon. But the Court of Protection has limited powers. So what does it actually do? The court, it can make decisions on behalf of people who lack capacity. And that could be almost anything in their life. It could be property, finances, or their welfare. And today we're going to be focusing almost exclusively on health and welfare. Managing people's finances is not something that really falls to public bodies. It does come up in some cases that we deal with, but it's more of a local authority responsibility than an NHS responsibility. And there's a whole range of decisions that a court could potentially be asked to make. And you'll see in the breakout rooms that we have this afternoon, we've pulled out some of the key areas that a court is quite often asked to make decisions on in which the NHS is involved. And they are deprivation of liberty, delayed discharges from hospital, where there's a dispute about where the person goes after they're discharged from hospital. And medical or dental cases, if there's some kind of serious medical treatment that is not straightforward, then the court can be asked to make those decisions. But the court's not just limited to making decisions, it can also appoint deputies to make those decisions on behalf of an individual. It doesn't happen often, it's fairly limited circumstances, but we have certainly come across a number of situations where the court has received an application from a family member to become a deputy for somebody, and the health board is usually asked if it has any objections to that. And that's a really important point, because the court is asking the health board for its input to decide whether or not that deputy is an appropriate person. And I've certainly come across situations in the past where the health board did not object. Well, it did object, but it couldn't really articulate its objections, and that led to a very, very prolonged series of court proceedings in which the person who had the deputyship was incredibly challenging, and that led to an appeal case that we had that is now one of the lead authorities about how to have a deputyship revoked by the court. So they are important decisions, and I think Larry's going to talk you through later about the process if you get an application or a court order through, how the health board should deal with that. The court is also quite often asked to review decisions that are being made by other people. So a decision made by a health board, a local authority, a deputy, somebody with a lasting power of attorney. If there's a challenge to those decisions, then the court is asked to review it and potentially make its own decision. In order to do that, the court holds hearings. And that's when the lawyers come in and we go off down to court and we act on behalf of the health board, and we make representations and submissions and argue the bit out. Ultimately, if a judge is being asked to make a decision, the judge wants to ensure that he or she has the best information and the best evidence upon which to make that decision. Therefore, it will often direct, by way of making a court order, it will direct parties, including health boards, to file particular documents or evidence. And if you've been involved in any kind of court of protection case, you will know that that list of demands from the court can be quite extensive and needs to be complied with within a certain amount of time. So we're going to talk through to different parts of the sessions today about what to do when you get that order, how you prepare that evidence, and the standard really that is expected. Ultimately, the court makes the decision. It is the person who is authorizing whatever course of action is being proposed. What the key message I want to get across today is that the Court of Protection isn't really asking of you anything that shouldn't already have been done. I think there is a general thought amongst practitioners that, oh my goodness, I don't know anything about the Court of Protection. I've never been to the Court of Protection. I don't have any Court of Protection training. And what I want to remind everybody is that the Court of Protection doesn't ask for anything different to what you should have done if you're complying with the Mental Capacity Act. It's asking for evidence of whether somebody lacks capacity. It's asking for evidence of what options are on the table for the judge to decide from. It's asking for people's views on what is in the person's best interests. They're all things that would be done day to day for anybody who lacks capacity, or should be done for anybody who lacks capacity. The uncomfortable part of it is the level of scrutiny that those who are making those decisions might be under. But it is scrutiny that is totally justifiable. And it may feel that level of scrutiny is unfair, but it's not unfair. It's completely legitimate. And what we do tend to find is that day-to-day decisions, the level and the standard of evidence, is quite often not quite what the lawyers or those involved in court proceedings would expect. And we are here as a team to help support those in the NHS to ensure that their evidence base, that their decision making is as robust as possible, that it is fully compliant with the Mental Capacity Act, with a view to acting in the best interests of the individual at the heart of those proceedings. So I'm just going to give you an idea of the types of cases that quite often we see going to court. And I imagine whatever role that you have, you may have come across this before, or you may anticipate that you will come across decision-making that sounds a bit familiar, whether or not it has actually gone to court before. The obvious one is healthcare decisions, and that can encompass so many different things. Medical treatment decisions, serious medical treatment decisions might go to the Court of Protection if that decision making is finely balanced, if there's a dispute by the patient or members of his family, for example, or if the amount of restraint that needs to be used in order to do that treatment is more than you're comfortable with. I'll give you a practical example. A classic example is somebody with maybe paranoid schizophrenia who has diabetes, who is recommended to have a leg amputated because they have not managed their diabetes well, and they're at risk of sepsis from their leg. Classic case of having to go to court to get authorization in order to do the amputation if the patient is refusing. And the same challenges are there about identifying what the options are. Is the amputation absolutely needed? Does it need to be toes, a foot, below the knee, above the knee? What are all the options? Or no amputation at all? Does the person have capacity to make that decision? And if they don't, and only if they don't, what is in that patient's best interests, taking into consideration all the relevant circumstances? What the patient wants, their beliefs and values, etc. So that's just one example. A more common case that we see is around where somebody should live and where they should be cared for. And that could be somebody with learning disabilities who's it's recommended they live in a supported living or residential care home, for example. It could be somebody who's in hospital. They've previously lived at home. A classic case is somebody with dementia who's previously lived at home, fallen over, they're injured, fractured neck of femur, for example, they're in hospital, and the clinical team's recommendation is that they don't go home again because they're at high risk of falls. But the patient wants to go home, they don't want to go to a care home, and there's some objection to that plan. If there's an ongoing dispute, that type of decision may need to go to the Court of Protection. And a lot of cases that we see are through the prism of a deprivation of liberty. So the patient might be subject to deprivation of liberty authorization whilst in hospital, and that is then appealed. And quite often, health boards agree that the patient should be in hospital. The real issue is where they go next. Do they go to a care home or do they go home? And one of the sessions this afternoon, we're going to talk about delayed discharges. Naris is going to lead that discussion. And she's going to look at what the common problems are about delayed discharges. And that will include identifying the options, assessing capacity, and working out best interests. So a lot of the themes we'll see throughout the day are the same, no matter what context that the case actually ends up being, medical or welfare. As I said, financial decisions can be an issue, and quite often there's a crossover with our healthcare cases. There may be an issue about finance. For example, somebody had a home, they've come into hospital, a family member has sold the home, that home is no longer available, but there is money. Should the court consider one option of that person buying another home and setting up a care package for them to live in the community rather than in a care home? The health board has no control over that. And quite often there is an issue about who does have control over the individual's finances, if there is an LPA, for example, or if the court needs to appoint somebody else to look after and manage that money. On a number of occasions, we've had cases of individuals who have claimed to have a lasting power of attorney on behalf of a patient. And there may be concerns about the legitimacy of that lasting power of attorney. Did the person have capacity at the time they made the power of attorney? Is the person who's been given the power of attorney acting in the individual's best interests? So there's two things the court can do there. One, the court can make an individual decision to say, no, I don't agree with the person with the power of attorney on this occasion. Or it could set aside the power of attorney if there's reason to believe that power of attorney was not validly registered, or if the donee of the power of attorney is consistently not acting in the patient's best interests, they could revoke the LPA. And of course, the court is there really to resolve disputes. Any form of dispute that falls under that Mental Capacity Act heading can be resolved by the Court of Protection. Now, that does not mean every dispute can or should go to the Court of Protection. It does mean that the court has the ultimate power. And what we want to try and do today is to raise awareness of the issues that come up in the Court of Protection and give you some awareness of how to resolve those issues without ever having to go to court. And I would say the medical treatment cases that we advise on, only a very small percentage of those will actually end up going to court for a final decision. There is usually a process by which we can help ensure that everyone, and by everyone I mean health boards, even family members, are all working to the same agenda, which is to achieve whatever is in the best interest of the person, using the Mental Capacity Act as a guide, ensuring strict adherence to the processes within the Mental Capacity Act. More often than not, agreement can be reached as to what is in the patient's best interests. So it is a very good process. I'm a massive fan of the Mental Capacity Act. It's been around since 2007, so it should be well embedded. But I appreciate if it's not something that you're working with day and daily, it may look a little bit imposing, and the idea of going to the Court of Protection can seem a bit disconcerting. But hopefully today we've got enough resource to help you get through some of these processes, to the very least raise awareness about the types of cases and when you might need to seek some legal advice or some support from within your own health board. And there's plenty of people within each health board who can support without necessarily coming through to us as the legal team. So why might you be involved in the Court of Protection? Well, you may be a care coordinator for someone who's the subject of proceedings. You might be asked to do a capacity assessment. You might be involved in a best interest decision meeting. You may be part of a team who's responsible for commissioning the care of somebody. Or you might be involved in a safeguarding incident. So hopefully today will be of some help. This is a guide. We've given you some guidance documents. Please do not consider them as legal advice. They shouldn't be taken as such. If you need specific legal advice, then within each of your health boards, you should have a process by which you can request a referral to our team, whereupon we can give formal legal advice on a case-by-case basis. So I'm going to hand over now to Larry, who is going to tell you about how we can accommodate the Welsh language into what we do. Larry, over to you.
Thank you, Gavin. Okay, so good morning, everyone. For those of you I haven't already met, I'm Larry and I'm a paralegal in the team, and I'm also a fluent Welsh speaker. So to begin, I'm just going to be speaking about the Welsh language in the Court of Protection and the services we can offer Welsh speakers for a few minutes. I'll then at the end translate for non-Welsh speakers, just in case any of you know Welsh speakers that couldn't attend today. So, bore da pawb, diolch am ymuno efo ni heddiw. Mi oeddwn i'n meddwl bod yn bwysig iawn i gwario ychydig o funudau bore yma i adael i chi gwybod bod yna ychydig ohonom ni sy'n gallu siarad Cymraeg ac yn fodlon iawn i gallu cynnig cymorth i ti yn Gymraeg. So, dwi'n siarad Cymraeg yn bywyd bob dydd ac yn gwaith, a dwi'n sylweddoli bod y gallu trafod rhywbeth yn eich iaith cyntaf yn gallu gwneud i chi teimlo'n mwy cyfforddus mewn rhai sefyllfaoedd. Mae hefyd nifer o fargyfreithwyr, cyfreithwyr ar y ochr arall a barnwyr sy'n gallu siarad Cymraeg yn y Llys Gwarchod. Mae yna adegau pan fydd pob parti yn gallu siarad Cymraeg a chynherir cyfarfodydd yn y Gymraeg. Dwi wedi cael ffeiliau a gweithio ar ffeiliau lle mae gwrandawiadau wedi cael eu cynnal yn y Gymraeg. Dwi hefyd wedi cael ffeiliau lle mae'r claf yn siarad yr Cymraeg ac mae'r barnwr wedi bod yn awyddus iawn i sicrhau bod ei anghenion Cymraeg yn cael ei gwrdd trwy gynnal unrhyw randawiadau neu ymweliadau barnwrol yn y Gymraeg gyda trefniadau wedi gwneud ar gyfer cyfieithu Saesneg, ond os nad yw rhywun sy'n mynychu yn deall Cymraeg. So mae ffurflenni hefyd o'r Llys Gwarchod yn gallu cael yn y Gymraeg hefyd. So just to translate, thank you for joining us today. We thought it would be important to spend a few minutes this morning just to let you know there are a few of us in the team who can speak Welsh, and we would be more than happy and willing to offer you support in Welsh. I speak Welsh in my daily life and in work with colleagues, and I realise that the ability to discuss something in your first language can make you feel more comfortable in certain situations. There are a number of barristers, solicitors on the other side, paralegals and judges who speak Welsh in the Court of Protection. There are times when all the parties in a case may speak Welsh and meetings are held in Welsh. I know I've helped on files where hearings have been held in Welsh. I've also helped on files where the patient is a Welsh speaker and the judge is very adamant to ensure that their Welsh needs are met by holding any hearings or judicial visits in Welsh, with arrangements made for an English translator if someone attending doesn't understand Welsh. And just to confirm, the Court of Protection forms are also available in Welsh. So, now that that's covered, we'll move on to the training, and I'm going to be covering the guidance on understanding a court order and what you can do about it. So as Gavin said, there should be guidance notes which you can follow along with, which are available in the chat.
Larry, I was just going to say before you start, I forgot to say earlier, if you have any questions throughout the day, there is a Q&A button at the top. Please feel free to ask those at any point. I appreciate some people are going to be maybe dipping in and out throughout the day, so please do ask. I will be monitoring that, and I will try and give answers as we go along rather than save it up. But there is a Q&A at 10 to 4 this afternoon. So if you are around for that, or if you want to come back for that, then we'll try and cover a lot of those questions in the Q&A as well. Brilliant. Sorry, Larry, back to you.
That's okay. Thank you. So I'm just going to start off by talking about different types of court protection orders, some of which Gavin did mention, which you might come across in your work. You may be familiar with some or all of these already, but it might be worth just refreshing your memory and going over some in detail. So first, health and welfare orders, which typically covers decisions about medical treatment, where someone lives, day-to-day care, who someone can have contact with. So these orders are only made when someone cannot make decisions for themselves. Secondly, deprivation of liberty orders. These are used when someone lacks capacity to decide where they live. They need to be kept in a place for care and treatment, and this care limits their freedom more than it usually would. And the court is being asked to authorise the deprivation of liberty rather than using a deprivation of liberty safeguard. So these orders make sure that any limits on someone's freedom are legal and in their best interests. In section 21A DoLs appeals, the order will ultimately determine whether each of the requirements, so that's the best interest and capacity requirements, under the deprivation of liberty safeguard is met, although it can alter the condition slightly or duration of the DoLs authorisation. Then we have transparency orders, which most court protection cases will have a transparency order in place because the hearings are usually in open court and accessible by the public, even when they're conducted remotely. So these orders place restrictions on what information about the case can be published. They can vary in scope depending on the specific case, and the main aim is to balance the need for open justice with the privacy of the vulnerable individuals that are included in the case. Remember that as health professionals, you will still have a duty of confidentiality in any event. So it's important that everyone involved in the case is aware of these orders, as any breach is potentially a contempt of court. Allocation orders. So these orders determine which judge or level of judge will hear the case. Some cases can only be heard by High Court judges, while most will be before a district judge or before county court judges. So the distinction is perhaps more important for the lawyers, although there are different procedures for different levels of judges or location of the court. Then we have directions orders. So these orders set out the next steps in the case, essentially. So they might set deadlines for when certain evidence needs to be provided, determine when the next hearing will be listed, specify what issues need to be addressed before the next court date. Then we have finance orders. So whilst they don't directly relate to healthcare decisions, they can be relevant in terms of addressing issues of public funding for the patient's legal representative, for example, legal aid. And then final orders. So at the conclusion of a case, there will be a final order with the ultimate decision of the court. So this may be reached by agreement and endorsed by the court, or it may be that the court has to determine a particular issue based on the evidence or submissions that they've heard. So the court may hand down a judgment separately, but it's the final order that has the legal effect. So now we're just going to cover the anatomy of a court protection order. We're going to look at how it's put together, and I think knowing and understanding the different parts of the order will help you read them correctly and use them properly in your work. So I'm just going to share a sort of template anonymous or draft order. I can just get that for you. Sorry, Gavin, I think I'm not able to access the share button. I might need to be changed to a presenter.
I have no idea how to do that, my friend. You talk us through it and I'll try and sort it out.
Okay, thank you. So let's have a look. So a court protection order usually has the following main parts. We'll have a header, the recitals, the order itself, which is often split into paragraphs and schedules, and then the date. So at the top, the header, you'll see the court's name, so in the court of protection, a case number, which is a unique number for each case, and then what the order is deciding. So, for example, in the matter of the Mental Capacity Act, and then the initials of the person that the order is about. So, and this person is often referred to as P. This information helps you quickly see who the order is about and what the order is about. Oh, thank you, Meg. Okay, moving on, then we'll have the recitals. So the recitals give background to the order. They usually will include when the hearing has happened, who was involved, and their lawyers, what evidence the court has looked at, important facts that the court found, facts of the case, for example, background info and P's story. So recitals are not part of the main order. Recitals should be uncontroversial and the minimum necessary to help set the context of why the court made the particular orders that follow. We do notice sometimes that recitals can become unnecessarily long, so we aim to ensure that they are kept to a minimum and only include the main relevant points. So moving on to the order, this is the main part of the document where the court says what should happen. It's usually written in numbered paragraphs or schedules. So if we just look out for these key parts, we have declarations. So these are statements about what P can and cannot decide for themselves. That a particular course of action, for example, medical treatment is lawful and in P's best interest. And then we may have authorizations. These tend to be permissive and set out things the court would consider lawful in certain circumstances. So, for example, to use restraint or to deprive someone of their liberty, but places no obligation on the health board to do so if they do not consider it necessary at the time. So then looking at directions, these are essentially the next steps ordered by the court. So it'll be instructions to specific parties about what they must do before the next hearing, typically, and include deadlines and statements that they need to provide. And it will also direct for advocates meetings or roundtables meetings where all the parties will gather to discuss the matter, or the parties' legal representatives only meet. Then we'll have a cost section, usually towards the end. The usual situation would be for all parties being responsible for their own costs or publicly funded costs. So, for example, the legal aid for P. In some circumstances, it may say that there is no order of costs, save for an assessment of the patient's publicly funded costs. There can also be cost reserve, meaning that there's no decision has been made as to costs. And the health board can also be responsible for other parties' costs. For example, if there's been a breach of an order and or delays caused. And just to go back as well, disclosure, which gives permission to serve copies of the order on other parties. So, for example, care providers. Then you'll have the seal and date. So the order will typically end with the date that the order was made, and then also the date that the court issued the order, which means you'll have like the court seal on it. This will often include a statement that the order is effective, notwithstanding the order not yet bearing the seal of the court. So this signals that the order is effective immediately once approved by the judge. Also, at the end of an order, you'll typically have a confidential schedule where the court of protection orders will usually be anonymised as they are available to the public, and so they must not identify P and potentially any other parties in accordance with the transparency order. So a separate schedule is often provided with details of anonymised placements and other parties. Remember, obviously be careful if emailing orders to comply with the data protection and the permissions in the order. So that's sort of covered an order, so we can go back to the guidance note if you have it available to you, and we're going to go over understanding, thank you Meg, understanding what an order covers. So when you read a court of protection order, pay close attention to how specific it is. So broad powers might need more thinking about, while narrow ones are usually clearer. Pay close attention to time limits. So do any of parts of the order have an end date? Look at phrases for like until further order or specific dates. Conditions, are there things that must happen before an action is allowed? This might include talking to certain people or doing more assessments. What's not included? The order might say certain decisions are not covered, and also mention of other documents. The order might mention other papers like care plans or capacity assessments that you need to look at too. So tips for reading orders. The biggest thing is just read it all, read the entire thing, not only the parts you think might be applicable to you. Don't just look at that one part. The whole order is important for understanding what you need to do. And then check for responsibilities. Note who is responsible for taking certain actions or making certain decisions. Where certain actions are to be carried out by the health board, decide which individuals are responsible. It's usually helpful for the health board to arrange meetings to discuss and agree these responsibilities well in advance of any deadlines, just so you all know who's responsible for what and by when. Again, like I said, check for deadlines. Know when certain information must be provided or actions must be carried out. And also ask if you're not sure. If you don't understand something in the order, ask your legal team to clarify. It's always better to ask for help and just say you don't understand anything rather than letting an order sit. Yeah, just remember these orders can be complex and obviously contain legal terminology. Read them carefully and use them to help the person that they're about. If you're not sure, always ask. So we're going to look at interpreting specific clauses in court of protection orders. These will not always be exactly the same, depending on the type of order, but these are some examples that I would say typically come up. So we've got capacity declarations. So you'll often see clauses like P lacks capacity to make decision about care and treatment, residence, contact with others, for example. So what this means is the court has decided that P can't make their own decisions in these areas, and the court will make the decisions in P's best interest. But do remember, you still need to provide support to P to help them make their own decisions if at all possible. You still need to involve P in decisions as much as possible. There may be other areas that P is able to make their own decisions. And then another one is best interest decisions. So this is the court making the decision on behalf of P. So examples of this might be, it is lawful, being in P's best interest, to receive the care medical treatment in accordance with the care plan attached. Or it is lawful, being in P's best interest, to reside at and to be deprived of their liberty at X care home. Injunctions, so these order a person not to do something. For example, a family member is not to have contact with P or remove them from a care home. And then we have time limited orders. So an example would be, this order shall remain in force for 12 months from the date of this order. So what this means is that the order will stop working after 12 months. You need to take a note when the 12 months are up. If the order is still needed, someone will need to ask the court to extend it before it runs out. So the order often directs that any new application be submitted no less than 1 month before the expiry. So again, just, yeah, I will nail down on the point that try and deadline and try and diarise the date of when the 12 months is up, and then a month before I would start on the process then of submitting an application. So practical applications in healthcare settings. We're going to see how this applies to your day-to-day work. So firstly, the decision-making process. When you're faced with a decision about a patient who has a court of protection order in place, firstly, check the order. Always start by reading the order and identify the decision. Is it covered? Is the decision you're trying to make covered by the order? If not, you might need to seek further advice. If the order says you need to talk to certain people, make sure you do. Involve P. Even if they lack capacity, you may still want to involve the patient in any decisions. However, it will be down to the specific needs of the patient. And also, huge thing is just document everything. Write down what you did and why, and refer to the order as well. Dealing with conflict, sometimes what the order says might seem to conflict with your clinical judgment. We would say reread the order carefully, consult your colleagues, contact the patient's representative, and then, of course, seek legal advice if you're unsure. So an example may be if the order says no blood transfusions, but you think one is now medically necessary, you'd need to urgently seek legal advice and possibly have a new court order. Communicating with patients and families. So court protection orders can be confusing and, like I said, legal terminology. So it can be very confusing for patients and their families. I would say explain simply. So use clear, non-legal language to explain what the order means. Be patient. Obviously, they might need time to understand and accept the situation. Be consistent. Make sure all staff give the same messages about the order. And know your limits. Don't try to answer questions that you're not sure of the answer of. Always refer the question to the right people who you think are best placed to answer those questions. Record keeping. Good records are important when working with court protection orders. So try and be specific. Note exactly what parts of the order you relied on for decisions. Include timings, so record when you made decisions and took those actions. Note down consultations. Write down who you spoke to and what they said. Document capacity. So regularly assess and record the patient's capacity for certain decisions, and also keep it accessible. So make sure key information about the order is easy for all staff to find. And then ongoing monitoring. So court of protection orders aren't set in stone. So watch out for changes. If the patient's condition or circumstances change, the order might need reviewing. Note the expiry dates, like we talked about time-limited orders. So just be careful of deadlines and when things expire. Prepare for reviews, so gather relevant information ready for when the court reviews the order. And also raise concerns if you think the order isn't working well, and something's not aligning or something doesn't work. Just speak up and make sure you seek help from the right channels. So directions and evidence. It's crucial that health boards and all parties in the case address all elements required comprehensively and accurately. So these directions often come with specific deadlines and requirements, and it's really important that you pay close attention to the details of what evidence is being requested. So if legal representatives are instructed, they typically request the evidence to be provided well in advance of the court deadline. This practice will allow us time then to review the evidence or the documents that you've given, and then we can suggest any necessary amendments, have meetings to review the evidence or the documents and gather more evidence if it's necessary before the deadline. So the review process is crucial as it helps to ensure that the evidence is complete, it's accurate, and presents the party's position clearly and effectively. It's important to remember that the quality and the completeness of the evidence that you're presenting at court can significantly impact the court's decisions. So looking now at some common mistakes people make when dealing with court protection orders, and more importantly, how we can avoid them. So we have already sort of covered some of these, but I'm just going to outline, I'd say, the most important ones. So common mistakes or pitfalls is a big one, I would say, is assuming all orders are the same. So this is a problem because orders are tailored to each person. They are case by case. So assuming they're all the same could lead to a wrong decision. Like I've said, always read each order carefully. That's why it's really important to read the whole order in its entirety. Even if you've dealt with one previously and you think you know what it's going to say, just read it in its completeness, just to make sure. Forgetting to check deadlines. Obviously, you could end up being late submitting evidence or disclosure, which then results being in breach of a court order. So please, as soon as you receive an order, put the reminders in place. diarise them well before the deadlines. Start the process early to give yourself plenty of time to gather everything you need to review it and make sure it's done and complete by the deadline. Another one is not involving the patient as much as you can. So ignoring the patient's views because there's a court protection order. Patients should still be involved in decisions as much as possible. It's their right and often helps with their care. So always try your best to explain the decisions that are being made to P and to try and get their input, even if they can't make the final choice themselves. It's always important to have an up-to-date sort of view of their views and their feelings and wishes. Another one is overstepping the order's authority. So making decisions that aren't covered by the order. This could be legally risky and might not be agreed as being in P's best interest. If you're not sure if a decision is covered or not in the order, check with colleagues or obviously get legal advice to make sure. And then poor record keeping, so not writing down why and how you followed the order and why you've made certain decisions. So good records protect you and P. They're crucial if anyone questions your decisions later on. So please make sure you make detailed notes about your decisions, linking them clearly to the relevant parts of the order, just so you've got a paper trail or a trail of evidence to support why you've done what you've and what you've done. So another one, and the last sort of main mistake I would say we'll talk about, is not agreeing responsibility for addressing each part of the order. So not knowing from the beginning and having a clear view on who is dealing with disclosure, who is drafting witness statements. There might be several needed addressing different issues across different departments. So even though you might feel that there might be different teams who can answer different parts of the statement, that's fine if people across different teams want to, you need their input, but ultimately you need to have clarity on who is going to be providing that statement, signing the statement of truth, and attending the hearing. And then who is attending roundtable meetings and or court hearings. So moving on to best practices, regular training. So make sure you and your team get regular updates on how to handle court protection orders. Obviously, laws and practices can change. Keeping your knowledge up to date will just help you make better decisions. Clear communication, so explain the effects of the order clearly to P, families and other staff who are involved in the care of P. It can reduce confusion and complaints and helps everyone work together better. I think it's very important to have a good team approach, so don't try and interpret difficult parts of the orders on your own, discuss them with colleagues. It can reduce the mistakes and help build a consistent approach across your team. Proactive monitoring, so regularly check if the order is still working well for the patient and you're still complying with the information in the order. So patients' needs can change, so spotting problems early means you can ask for changes to the order if needed. Accessible information, so keep a clear summary of key points from the order where all the relevant staff can easily find it. So, this makes it easier for everyone to follow the order correctly, even in busy or stressful situations. Remember to balance following the order with using your professional judgment. So orders are meant to support good care, not replace your skills and experience. Also seek clarification. If you're unsure about any part of the order, ask for help. Like I've said, this might be from your organisation's legal team, it might be from our legal team. It's just always better to check and make sure you're following and complying properly rather than guessing and then potentially making a mistake. So moving on now to service of court protection documents on health boards. An important aspect of court protection proceedings that healthcare professionals should be aware of is how legal documents are served on health boards. So service is the formal process of delivering court documents to parties involved in a case. So it ensures that all the parties have been properly notified of legal proceedings and have the opportunity to respond. Typical methods of service, you have traditional methods, so personal service or hand-delivered, first-class post or document exchange, but I would say common method now is the modern method, email service. So in recent years, the courts have increasingly accepted service by email, just because it's faster than traditional methods, so it's more cost effective, and it's very useful in urgent cases as well. So your health board should have a designated email address for receiving documents. This is typically managed by in-house legal department or a specific team responsible for court matters. So it's very important that the designated email address must be regularly monitored. So staff responsible for receiving this should be trained to recognise the court documents and understand their urgency. When these documents are received, it's often required to send an acknowledgement of receipt. There should be a clear process for distributing received documents to the relevant departments or individuals within the health board. And an important thing is time sensitivity. So many court documents, especially in the court protection cases, they are time sensitive. So staff, it's really important that staff are aware of the of prompt action when these documents are received. So every health board should have an official address for service. This could be a physical address, but like I said, increasingly it includes an email address. And all relevant staff should know this address and understand its significance. So best practices for service, regular training, ensure that staff who might handle incoming legal documents are trained on the importance of proper service and the procedures to follow. Clear procedures, so have written procedures for handling served documents, including steps for urgent cases. Record keeping, so maintain accurate records of when and how documents were received and distributed. And also IT support, ensure that the email system is reliable and that the designated email address is technically capable of receiving large attachments. And then the legal department involvement. So always involve your legal department or designated legal contact when you receive these court documents. Poor handling of served documents is crucial. Proper handling of served documents is crucial, So mishandling can lead to missed deadlines, which can then have serious consequences for P as well as your organisation. So if you're ever unsure about a document that you've received, just remember, act on it straight away, consult with your legal department immediately. So coming to the end now, just to conclude, I wanted to go over just a few key takeaways. So always, and this is the main one, always read each order carefully. Like I've said, they're tailored to each individual case by case. So just make sure you are reading the order in its entirety. Involve P as much as possible in decisions, even when they lack capacity. Keep clear records of how you followed the order. If you're unsure about anything in an order, ask for help. And regularly review if the order is still meeting the patient's needs. Your role in implementing these orders is crucial. You're the ones ensuring that the court's decisions translate into good person-centred care. So like I said, as soon as you receive an order, don't let it sit, act on it, and start the process straight away. Thank you for listening and your commitment to understanding and properly using court protection orders. It does really make a real difference to patients' lives. Thank you.
Thank you, Larry. I'm just going to pick up on some of Larry's points and maybe give you some practical examples of where health boards or we have run into difficulties on behalf of health boards, perhaps because people haven't really understood what was in front of them or haven't known how to act on that. So a classic example is receiving service of a DoLs appeal. Okay, fairly common scenario where a patient is in hospital, they're on a deprivation of liberty authorization, and somebody on their behalf is challenging or appealing that DoLs. So usually as an advocate for the patient, they'll go to their lawyers and they will prepare all the documents. Now, they prepare those applications based largely on what is in the DoLs assessments and written in the standard authorization itself. They don't really have access to medical records or anything else, so that's what they've got. They'll have gone and seen the patient, and the patient has said, I don't want to be here, I want to go home, for example. So they'll go to their lawyers, they'll draft up an application form, evidence to support that, file that at court. The court issues it, so says, yes, we are accepting this application. They stamp it and issue it. It goes to a judge. A judge will then have a quick look at it and allocate it to another judge, usually. And the next judge then will have a more detailed look at it and say, right, I can see what this is about. Well, I want the health board to do this, the local authority to do this, and just make a list of what they want to happen. Usually that's done on the basis of suggestions made by the applicant. So it's usually disclosure of documents and some initial evidence. There might be a capacity assessment, for example. So when those orders are issued, they go back to the applicant's solicitor, and the applicant solicitor serves it on the health board or local authority. But for this purpose, we're talking about service on the health board. Now, there's a small number of solicitors who work in this area in Wales, and they're pretty familiar with the health boards and how to serve things. But they need to know what is the email address to serve each health board. So as Larry said, you have to have one. Some health boards, it's a chief exec. Some health boards, it's a specific email address at corporate level for any court proceedings. And for some health boards, court of protection, there might be a specific email address for court of protection proceedings. Whatever arrangements, you have to understand that by saying this is the email address for which we want service, as soon as they email that, you're served. The clock is ticking, okay? It is, you know, the court rules are such that when they send that, you've got it. And if there's any time limits in those orders, that clock is now ticking. What we come across now and again is a health board receiving service of those documents and it being missed or not looked at for a few days. And all those timelines are ticking. Those initial orders might say you have to do something within 7 days. That's not a lot of time. You're supposed to file an acknowledgement of service within a certain amount of time. So all these things, quite often there's a court hearing listed potentially in a week. These court protection proceedings can be very fast moving, very fast moving. The judges take these cases very seriously. And we may be all very familiar with DoLs and we may not think, you know, about taking it too seriously. But if you think about it, it is a fundamental human right not to be deprived of one's liberty. Article 5, European Convention of Human Rights. So the judges take it very seriously. And within Article 5 of the European Convention, it says people should have access to a speedy decision by the courts. So I emphasize that word speedy. That's in there. If you want to Google it, you can look it up. It is specifically in there. The courts should have speedy decisions. So the judges are under pressure to make decisions quickly. So whenever they issue orders, the time frames will be small compared to other forms of court proceedings where you may have 28 days to do something or even longer. So very short timescales. And that's why what Larry says is really important. You have to have procedures and processes in place that when these proceedings come in, they get to the right people. A chief executive or whoever opens their email is not going to know anything about this patient. No idea. So you have to have a process of who's looking up who this patient is, what team are they under, who is responsible, who needs to see these court documents and actually make some decisions about what to do. So whenever we get a new case in, when people refer a case to us, we ask usually for two things before we'll do anything. Tell us who's giving us the instructions, who's the decision maker from the health board, and secondly, who's paying the costs, who's the authority for actually incurring costs, because any court of protection proceedings, you're going to incur costs. Court proceedings are such that only certain people, lawyers, can actually appear in front of a judge. They tend to be a bit more relaxed when it comes to unrepresented family members, but strictly speaking, you got to be a lawyer to appear in front of a judge, and that's always going to incur some cost in doing so. So it's really important to identify who are those two people and who is going to act on this order. And as Larry says, quite often we're sent a whole bundle of papers. Tell us what we need to do. And we look at it, and all it says is, well, you just have to disclose 2 documents. That's it. That's all you have to do. You don't really need us to tell you that. But that process of instructing lawyers and getting advice, we're pretty good, we're pretty quick, but we can't guarantee to get back to you within 24 hours. And if it's just to tell you, but you just need to disclose 2 documents. So you need somebody who's at least competent at reading it and at least screening through it and going, is this a really simple one that we can deal with ourselves, or do we actually need legal advice on this? But as Larry said, really important to identify who is making decisions, who is doing the doing. Who's doing the doing? And by that, I mean the disclosure, who's actually getting it together, who's searching for it, who's going to put it all in one place, and who's going to email it to somebody else. Who's actually doing that? And disclosure, of course, is usually fairly loose. It's any relevant records. It might be specific about best interests or mental capacity decisions or capacity assessments. But how does anybody know where to look unless the team involved in that patient actually is involved? Your records could be sitting with community mental health. They could be sitting with inpatient mental health. They could be on a ward. There could be some with a learning disability service. There could be some sitting with a commissioning team. So there's lots of different departments that are often involved in court of protection proceedings. And that's what makes it challenging. That's what makes it different to a lot of other forms of litigation, is the breadth of people and departments that are involved in individual cases, because the health board is playing numerous roles in an individual patient. You might be the ward when they're in hospital. You might be the commissioners if they're going to be discharged from hospital. You might be the district nurses when they're not in hospital. It might be mental health, it might be physical health. So there's lots of different areas, and somebody needs to take responsibility for coordinating that. And it's not us. It can't be us. We are not part of the health board. We are shared services. We do not have access to your medical records. You have to provide it. Somebody needs to identify those records. So somebody needs to be doing the doing, okay? And so it's really important that these orders, especially those new cases that come in, are communicated and decisions are made as to who is taking responsibility. An example fairly recently where we got sent papers the day before a significant event. There was an advocates meeting the next day and a hearing 3 or 4 days later. But we're good, but there's limited, there's a limit to what we can do if we're only sent things a day before a meeting. I don't have time to read anything. I don't have time to take instructions from anybody. I don't even know who's really involved. So if there's a delay And that one, for example, there was, say, 4 or 5 weeks between service on the health board and actually getting it through to me. And the person who was within the health board was the correct person, the person who knew the patient the most, the ward manager, whoever. So it's really important that there are processes to get this through to the right people, and that you have a plan as to who is doing what. I think in all our jobs, we're probably very familiar with people managing and saying, okay, someone else is going to do that. It's very tempting to think somebody else will pick that up. Somebody else will pick that up. But we really have to focus in who is actually doing it, who's going to take this forward, who's taking responsibility for it. And that's not always straightforward. So read it, understand who's doing what, and make sure that that is being done. We, as legal advisors, we are here to support and provide legal advice. We're not line managers, and we have no control over your diaries. We can't put things in people's diaries. And yet, quite often, we are left chasing and chasing and chasing when things are not done and we don't know who is actually doing them. And what happens as a result of that is that the people that we're chasing feel aggrieved that we're chasing them. They feel that we are being demanding. But all we're trying to do is support the health board and the teams who need to do what they have been ordered to do by a court. Okay, that's what we're here for. It's not us telling people what to do. It's a court telling the health board what to do. And we are here to support to make sure that is done. I'm going to emphasize the point Larry made, which is if you can't do it in time, say so. And the reasons why you can't do it and when you can do it by. A lot of these dates are fairly arbitrary. An order will go out, say, do this within 14 days. The judge has no idea how long it takes. He's just going to, he or she will just say, well, 14 days. If you can't do it in 14 days, don't let 14 days go by before you do anything. If after 7 days you realize you can't do it within 14 days, then you tell us and we can help apply for an extension of time. It is one of the judge's greatest irritants is when they make orders and they're not complied with and nobody does anything about it. And then we get to the court hearing and we have to go in front of the judge and say, sorry, judge, health board hasn't done what it was ordered to do. Why not? They just couldn't do it in time. Well, did you make an application? No. Is there any evidence to say why you couldn't do it or how long you would need to do it? No. So somebody needs, again, take control of that situation, make the decisions, organize it, and tell us what you need from us. How can we help? We can do it. We can talk our way out of most situations, but sometimes we can't. And we need the evidence upon which that is based. Okay, so do take responsibility. Alert us if you can't do it in time with the reasons, and we can help you through that process. So things like diarising dates, as Larry said, we can't control your diaries. We assume that people would take responsibility and put things in the diaries and act on it. But in our experience, quite often, it's relatively junior staff who are quite often giving evidence. Might be a care coordinator. Who's managing that? Who's supporting them from within the health board to ensure compliance with these orders? Do they understand what they need to do? Are they being checked up on? So we're here to support, but we need senior people within the health boards to support those who need to do the doing as well and make sure that that is being done. Okay, that's the main sort of barriers, I think, to pushing court protection proceedings forward. We want to do these things quickly. Everyone wants to conclude court protection proceedings quickly. And there's a perception that court protection causes delays, for example, in a discharge of somebody from hospital. Court protection doesn't cause delays. Delays quite often result in the court of protection. So as I said at the outset, a lot of this should be there already. If you're directed to file evidence, well, it should be straightforward because a lot of it should be done already. Okay, you should have your capacity assessments. You should have your best interest minutes. You should have all the records to hand. Okay, but a lot of the time frame to get things done, in our experience, is quite often or internal organization of who's doing what and making sure it's being done. And appreciation has to be given to the fact that those who are doing the doing may not have a lot of time to do it. And that's why if there's any managers here today, they need to understand that these things can be time consuming, and they need to help with diaries and shift things around to support people in order to comply with these orders. One thing that does come up is negotiation of orders. Okay, a lot of these orders, apart from the very first ones, but all the orders after that, if we're in court proceedings, are usually negotiated between the parties. That means we need people to take instructions from within the health board and agree the contents of the order. And quite often what we see is we agree the order with the health board, everything is agreed, and we'll say, great, we'll take this back to the other parties, and it gets approved by the judge. At the point at which we've agreed the order, you should be doing something about it, not waiting for the sealed order to come back from the court. As Larry said, that sealed order can take a while. It might be weeks before you get the sealed version back, but the version that you had and agreed to, work on the basis of that unless you're told otherwise. And then you can get ahead of the game. So we might agree the order a week before hearing. You might not get the sealed order back for 2 weeks after the hearing. So there's 3 weeks gone if you wait for the sealed one. Just crack on. Work on the basis of the one that you've signed off on, you've agreed with us, and we've agreed with the other side. Okay. Very rarely does a judge actually change substantively what is in the order. So there's an opportunity to get ahead and make a start on getting what needs to be done done as quickly as possible. Okay, there is a question in the box. I don't think it's directly relevant for this, so I will have a look at that and I'll pick that up at some stage today. Naomi, thank you. So we're just going to take a quick break. Appreciate it. If you want to get a cup of tea, if there's an email you want to respond to or a telephone call you want to return or make, go ahead, and we'll see you back at 11:20 for Sophie's talk on understanding everyone's role in the Court of Protection. And I may have talked about a few things that she's going to talk about there. So sorry, Sophie, but we'll see you at 11:20. Thank you. Okay, appreciate 5 minutes isn't a long time to make yourself a cup of tea, but I've just about done it. Hopefully, Sophie is here and we're going to hear from her about understanding everyone's role in the Court of Protection proceedings, including IMCAs, RPRs, LPAs, deputies, litigation friends, witnesses, managers, and judges. Sophie, over to you.
I'll just pop myself on the spotlight. There we go. Thank you, Gavin. Hi, everyone. I'm Sophie. I'm a solicitor here at Legal and Risk. I'm going to be discussing the roles and duties of all the individuals in the Court of Protection. Any one case can involve a huge number of people, as I'm sure many of you are aware. It can be quite confusing as to who is who and what their responsibilities are. I thought it'd be useful to first look at the Health Board and their roles in proceedings, because there can be multiple roles when it comes to Court of Protection. The Health Board's roles can be, number one, decision maker in terms of medical treatment, and that can involve medical staff and nursing staff. Sorry, my voice is going. Number two, the managing authority for the DoLs, IFPs and hospital. They can be supervisory body of the DoLs for the DoLs, IFPs and hospital. They can be the provider of mental health services, whether that's an inpatient under the Mental Health Act or in the community. They can act as commissioners for future care and treatment outside of hospital, whether that's CHD or Section 117 aftercare. They have a role as safeguarders. They can be discharge coordinators, care coordinators following discharge, and they can be required to provide reports as well, Section 49 reports, or reports ordered against the NHS body. So therefore, it might be required for the Health Board to provide evidence to support an application to the court. This is usually a statement to be filed, and it can sometimes be required from several different members of staff across several different different departments. So it's so important for there to be good communication between the Health Board, especially when we need information from several departments. So if we start by looking at the role of the RPR, or the relevant person's representative, the supervisory body must appoint a relevant person's representative, an RPR, for every person who is subject to a DoLs. The RPR will consider all of P's circumstances and will usually meet with P on more than one occasion, as well as having discussions with care staff, family and friends, anybody really involved in their care. So the RPR's role is to take all steps to identify whether P wishes to apply to the Court of Protection. If they do, the RPR's duty is to ensure that the application is brought by an instructing solicitor. So the RPR will consider their expressions of emotional state, the frequency with which P might object to their placement or ask to leave, and the consistency of their objections as well. So the RPR is there to support P and represent P when making application to the Court of Protection. And they do that even, they can do that even where the RPR concludes that they might not wish to take that to the court. So there's certain circumstances where P might be exhibiting behaviours that might lead the RPR to think that they would wish to take this to Court of Protection, even if they haven't expressed that in verbally. This is usually based on behaviours such as, are they attempting to leave? Are they trying to find exits? Are they packing their bags, etc.? When supporting P, the RPR must assess whether an application should be made to the court in P's best interests. So even if P does not express a wish to bring court proceedings, they must therefore assess matters such as whether P meets one of the requirements for the DoLs, the period for the standard authorisation to be enforced, the purpose for which the authorisation is given, and the conditions attached to the authorisation as well. So the role of the Section 39D IMCA, Independent Mental Capacity Act advocate, is much more limited than the role of the RPR. Under the Mental Capacity Act, the IMCA is obliged to take steps to help P and the RPR to understand the effect, the purpose, the duration, the conditions and the reasons for the DoLs. They also take steps to help P or the RPR to apply to court if they wish to do so. So the role of the IMCA is much more limited and focuses mainly on the DoLs, but by contrast with the RPR, it's not the role of the IMCA to analyse whether P would wish to go to the Court of Protection or to consider whether there's any other reasons they would need to go to the Court of Protection. That's the role for the RPR. Next, if we look at the litigation friend, under the Court of Protection rules, unless P or the patient has capacity to conduct the proceedings, the patient will only be joined as a party to proceedings if there is an appointment of a litigation friend or if the court directs an appointment of an accredited legal representative, which I'll cover shortly. A litigation friend is essentially P's voice in court proceedings. They play a crucial role in representing those who lack capacity to make decisions for themselves in legal proceedings. Their key responsibilities are representation. They act on behalf of the person lacking capacity, ensuring their interests are represented during court proceedings. Decision making. They often help make decisions about the case, often consulting with P to understand their wishes and feelings. They manage the case, so they're responsible for conducting the case on behalf of P, including filing documents, attending hearings, and communicating with legal professionals. Protecting rights, so they're there to ensure the rights of the individual are protected throughout the whole legal process. And of course, best interests, they must always act in the best interest of the person they represent. There can sometimes be times where they deal with the finances as well. So overall, the Litigation Friends serves as an advocate or protector for those who cannot advocate for themselves, ensuring that their rights and best interests are upheld in legal matters. A litigation friend can be a relative or a close friend. Often we see family members or close friends, sometimes acting as litigation friends, where they're suitable anyway for that role. Otherwise, we see them as a professional litigation friend, which can include an advocate. So sometimes we do see whoever acts as the RPR for an individual will also act as a litigation friend as well. Otherwise, the court-appointed representative can act as a litigation friend. This is usually where there's nobody else available to act as a litigation friend, whether that be family or friends. And this can be the official solicitor who can be formally instructed and can seek funding through legal aid. If there's no person willing or able to act as a litigation friend, this is where an ALR can come into play, an accredited legal representative, which we tend to see on a lot of cases recently. An ALR is usually a solicitor who has undergone specialist accreditation to represent individuals lacking in capacity in court proceedings. So they'll therefore act as P's voice and act in their best interests. It's essentially a fallback option that allows the court to appoint a legal representative directly if there's no litigation friend available. Next, we'll look at individuals who hold LPA or lasting power of attorney. So power of attorney is a way of giving someone you trust the legal authority to make decisions on your behalf if you're no longer able to make them yourself. An LPA must be made whilst the individual still has capacity. So it has to be made before they lose capacity and they're in this situation. There are two types of LPA, one for making financial decisions and one for making health and welfare decisions. The LPA for finances would make decisions such as selling P's home, paying mortgages, paying bills, and potentially paying any contributions to their care as well. Whereas the LPA for health and welfare, which is a separate LPA altogether, that would include making decisions such as where P would live, what care they would receive, and what medical treatment they might receive. So an LPA, again, must act in P's best interests. So if there's a dispute about best interests between parties or someone holding power of attorney, you should consider seeking legal advice on how to resolve that, as court might be required. So next, there's the court-appointed deputy. This varies from the LPA, as a court-appointed deputy is made once you've lost capacity and you no longer have the capacity to make decisions yourself. These are deputies for property and affairs and welfare. Again, they're similar to the powers of the LPA. Welfare deputy can decide where P will live, who they will live with, who will they have contact with, whether or not they should have medical treatments. However, welfare deputies are actually rarely appointed by the court, as it is often considered that these decisions could be made through the court process. Power and affairs deputies are appointed more frequently, and they're there to manage P's finances, again, including decisions regarding his property, about when they should move to full-time care, decisions regarding payment for contributions. If you object to any person being appointed as a deputy, you can seek legal advice on how best to file your objections. Again, if we think that somebody isn't acting in their best interests, it's best to seek legal advice to see what you can do about that. A judge is next. I'm sure we are all familiar with judges, but their role in the Court of Protection can sometimes differ to what you might have seen elsewhere. So a judge's role in the Court of Protection is to case manage and ultimately make decisions about what's in P's best interests. In Court of Protection matters, we usually have a district judge, but sometimes in more serious cases, we can have a circuit judge or even a High Court judge if needed. The judge can make the decision in a case regarding P, but it's sometimes the fact that parties come to an agreement themselves as to what's in P's best interests and ask the judge to approve that. If you've dealt with court of protection proceedings before, you'll note that a lot of the time we have a meeting with all the solicitors involved and we try to agree a way forwards. If we manage to do that, we can agree that in an order, and the order goes to the judge for the judge to approve. So they do have the powers to make decisions in cases, and there are many cases where we go to a judge and ask them to make a final decision. But in some circumstances, they are essentially there to approve the orders that we've agreed as legal professionals. So the judge in court protection proceedings will often wish to include P in proceedings as much as possible. They will tend to consider P's wishes and feelings when determining what's in their best interests. It's quite often the judges will go to visit P, whether that's in their placement or online, to have a discussion with them to obtain their wishes and feelings. The judge also assists in case management and ensures parties are compliant with the directions of the court. Next is witnesses. So health board staff will often be asked to provide written evidence to the court in the form of a witness statement. These statements are usually used to explain whether or not P has capacity or what they think is in P's best interests. So they will need to sign the document, and towards the end is a statement of truth, which states that they might be held in contempt of court if they make a false statement. So it's so important to be accurate in your statements to the best of your knowledge. Sometimes the witnesses who provide these statements might be required to attend court. At court, they can be cross-examined by barristers or the judge in relation to their evidence in their witness statement. Any witnesses that attend court will be supported, of course, by a representative from Legal and Risk or wherever else you're seeking legal advice, and sometimes a barrister as well. Now, that was quite speedy. I think I've covered everybody, Gavin, unless there's somebody else that you'd like me to discuss. Otherwise, I'll pass you back to Gavin.
Hello.
Thanks, Sophie. I think it's probably a good point at which to throw it out to everyone. And if they have any questions on that to understand their own role in court proceedings or anything else that Sophie's talked about,
Martin.
I'm happy to.
I'm very well, thank you. Sorry, yeah, I'm on a call.
I don't know who it is. It's got their microphone
thanks for the prompt.
turned on. If they could turn their microphone off, please, that would be very helpful. Thank you. So one of the confusions quite often is on the dilemmas that those representing P have is that conflict between their role as an advocate for the patient and also their role to act in the person's best interests. And a lot of the court of protection proceedings, although they're in front of a judge, essentially what you should think of it as is a quality assurance exercise. We're trying to persuade the other parties involved and ultimately the judge that what you're proposing is correct. It is the right thing. It is the correct decision for that patient, that they lack capacity and the proposal is in P's best interests. So that's why there's a level of scrutiny about all the evidence, and it is a quality assurance exercise. What that means is those who are representing P may arrive at a point where they agree with the health board's position, but they're left with that dilemma of, well, what do we do with that? Because P doesn't agree. The patient wants to go home rather than the care home, but they themselves may feel, but it is my responsibility to act in the patient's best interests. And that can be difficult for those representing patients. And sometimes that can cause some conflict between them and those who, within the health board or local authorities who are sort of the decision makers. I think some recognition of that is warranted, because it may appear to you that those people who are supposed to be representing the patient are not acting in the patient's best interests. Well, they are striving to do so, but it is also their job to advocate for what P wants. They will ultimately try and arrive at a position of what they consider to be in P's best interests. So in our experience, some of the difficulties or challenges for those who are acting for patients, and some of the frustration that sometimes comes out from clinical teams, is that those representatives are not medical professionals. They're not clinicians. They are not trained to your level in learning disability if the patient has a learning disability, and an acquired brain injury if they have an acquired brain injury. They don't have those clinical specialisms. So they will have lots of individual clients who they go and see that might have a broad range of conditions or disabilities. And I can certainly see, whenever we get evidence from those who are representing patients, that they may be unconsciously biasing what P's views are. As I'm sure we all know, patients with certain conditions have to be communicated with in a certain way. Otherwise, what you get back could be unreliable. They don't have that training or that experience. So I think as long as there's recognition of that, and it's not that they are deliberately trying to push P in a particular direction, it is important for you to try and support the advocate, the RPR, might be a family member, as Sophie said, to be able to understand the patient, to understand their needs and how they work, and to ensure that they can fulfill their role to act and represent the patient in the best way possible. I had a great example years ago where I think it was an RPR and litigation friend, RPR acting as litigation friend, turned up at a care home to see P, who had a severe learning disability and autism. They turned up unannounced. And the manager of the care home said, no, you can't come in. Because if you're going to meet with P, well, you need to plan that. He's not expecting you. If you turn up unannounced, that upsets his plan for the day. And that's going to cause him a lot of distress because he needs to stick to his routine and his structure for the day. And I don't think that the advocate quite understood that initially, because they said, well, he's entitled to see me. I'm his representative in legal proceedings. I think the manager dealt with it very well. He said, yes, that's fine. I understand that. But what you have to understand is what this individual, how they work, what their needs are, and let's rearrange that for another time. And then we can forewarn him that he's going to come. And if you do come, you have to turn up on time. You can't be late. You can't be too early and you can't be too late. So there is, I'm just trying to encourage a recognition amongst clinicians that those who are advocating or representing patients don't necessarily know what you know. But let's try and work collaboratively with them to enlighten them, to ensure that we're all acting in someone's best interests. Another example of somebody who had been through the Court of Protection on numerous occasions, has had numerous mental health tribunal appeals. And on the last occasion he was in court, we got evidence that persuaded the judge that the actual Court of Protection proceedings themselves were detrimental to this person's health. The same issues had come up 3 or 4 times before. On each occasion, the court had come to the same conclusion. And the very fact that he was in court protection proceedings again was detrimental to his mental health. And to be fair to the advocate and the solicitors who were representing him, they accepted that evidence and they agreed to conclude the proceedings very quickly. Even though the patient was adamant they wanted a particular outcome. So that's just a good example there of solicitors or advocates who are acting for patients, and that dichotomy that they have in that dual role of being an advocate and acting in someone's best interests. One of I think I alluded to this earlier, is lasting powers of attorney is something that comes up, we get asked about very regularly. And what powers does that actually give a lasting power of attorney, and what do you do if there's a dispute? And there's particular sections in the Mental Capacity Act that deal with lasting powers of attorney and what they are. It gives them an authority to make a decision. And I think there's a question in the Q&A here, and the question is, on behalf of vaccination team, when attending care homes, what should we do if there's an LPA in place for health and welfare, but they're unable to get hold of them? And there's only a limited window of what to do. So this happens all the time, where a family member may say, I've got an LPA. They haven't produced the document. So you need to be persuaded that there is actually an LPA in place. And don't forget that there's two types of LPA. There's health and welfare and there's finances. People will quite often say they've got power of attorney for health and welfare, but actually they don't. They've only got the finances one. So you have to be alive to that. It is of no authority unless you're holding that and you have it in your hand and you can actually see what the LPA, is it correct? Is it appointing that person? And does it stipulate the powers that it gives the person with the LPA? But any decision, if we think back to what Section 5 of the Mental Capacity Act says, you have a defence when you do something for somebody who lacks capacity, if you have a reasonable belief that they lack capacity and a reasonable belief that you're acting in their best interests. An LPA gives people the authority to make a decision, but it doesn't mean they're the only person who can make a decision. So if you're acting in someone's best interests, for you to have a reasonable belief that you're acting in the best interests, then you have to take certain steps under Section 4, which is to consult with others, in particular those with an LPA. So if you're able to contact the LPA within the time frame that you need to make that specific decision, so if it's 2 weeks, for example, if that is your tight timeline, and you make reasonable attempts to contact the LPA or establish that there's an LPA, and they do not make a decision, they have the power, they have the authority to make a decision, but they have not made a decision, then I don't see why you can't make a decision in Peace Best Interests, remembering that it has to be on the basis that you have a reasonable belief that P lacks capacity and a reasonable belief that what you're doing is in the best interest. A very different story if the LPA said, no, do not give the vaccination. Then we're into a dispute, and there's particular subsections in, I think it's Section 6 of the Mental Capacity Act that deals with when and what circumstances you have to follow an LPA, which is pretty much, yes, you do have to follow an LPA, except in certain circumstances if there's life is at risk whilst you make an application to court, for example. LPAs can be a bit tricky. It can be a bit tricky to understand exactly what powers have been given, especially when it comes to deprivation of liberty authorizations as well, because one of the requirements of a deprivation of liberty authorization is that there is what's called the no refusals requirement, which means that P hasn't refused it, and there isn't an LPA who's refusing it. So if you want to put a DoLs in place for somebody in a care home, there's an LPA and the LPA refuses, then they could potentially block the LPA. When that happens, what I usually say is, well, you've got a conflict there and you've got a dispute about what's in P's best interests. And for an LPA to block an LPA, to block a DoLs, it has to be a valid decision. A valid decision means in compliance with Section 4 of the Mental Capacity Act, it has to be a best interest decision. So if you've got a dispute about best interests, I usually say, well, put the DoLs in place, but as long as you go to court straight away and try and resolve that. Okay. So there's lots of people with various powers. But the court of protection, the important point is the court of protection is the ultimate decision maker. And if there is a dispute with any of these individuals who have powers, then usually it is the court who can override that. We won't get into the complexities of deputies. That is fairly rare. And I would say if you come across somebody who validly has a court-appointed deputyship and there is disputes about what they're doing and whether it's in someone's best interest, then that definitely I would recommend advice on that. We have come across it. We have come across it on a number of occasions, and we've successfully set aside deputyships in the past, but it is not a straightforward process. We finished a little bit earlier than scheduled, so I'm happy to take any questions. It's not easy for me to see if anyone raises a hand because there's 178 people, so I'm not going to see a hand necessarily go up. So feel free to unmute and ask a question if you want to, and I'll just have a quick look through the rest of the questions that we've got. No questions. Okay.
There's one from Josie Davis about LPAs in cases of dispute between relatives where there's no LPA in place. Equally, no concern.
In cases of dispute between relatives where there is no LPA in place, but equally no concern around any said relative acting in peace best interest, nor impacts to any. Josie, if you're there, do you want to explain that? I don't quite follow.
Hi, Gavin. Yeah, it was just sometimes we run into these circumstances in DoLs where there's no appointed LPA. There's several children and there's no evidence to suggest that none of them can act in P's best interests and take that role as RPR. However, there is obviously a negative relationship amongst the siblings. So although that might not directly impact P, sometimes we are at disputes with the managing authorities or sometimes local authorities. It's to who would be the better person to appoint. I've seen both where a relative has been picked as an RPR, which has caused some challenges. However, again, it's never directly affected P, or for assurances, would you advise going directly for a paid RPR to eliminate that?
That's not something that I can sort of give you a definitive answer on. I think it comes down to just a judgment decision. I don't know, Hannah, I mean, can you think of it? Is there any legal barrier to making a decision one way or the other? I don't think there is, but I would have to probably dive very deeply into the schedules of the Medical Capacity Act to look at that. But it seems to me it probably comes down to the professional judgment of, I think it's the best interest assessor, isn't it? Who's the decision maker as to who they recommend the RPR being.
Yeah, I think as well, sorry to jump in, but I think the other thing that I've seen on occasion is where you have relatives who are at odds with each other and they may be perfectly able to make some of the decisions that they or generally oversee what's happening with the patient in terms of their care in hospital. When it comes to external decisions, they can be quite heavily influenced then by their dislike of the other relatives or the disputes that they've got going on between them, or potentially be wanting to limit contact when an independent person may be looking at establishing contact arrangements that are going to sort of suit everybody. And so I think there can sometimes be questions as to suitability in that respect, as to whether they can sort of independently put in place things like contact arrangements or make decisions about, be part of those sort of ongoing discharge discussions or ongoing residence discussions in an impartial way, potentially, would be the only other thing I'd add.
I noticed in the chat a comment about where there's agreement with an LPA, but P is objecting. Does that need to go to court? And it's a very relevant question, I think, especially when it comes to discharge from hospital, where you've got that dilemma of does the person go home or do they go to the care home? the whole point of an LPA, and don't forget an LPA was made by the individual. So the person with capacity has decided, in circumstances where I lack capacity, I would very much like a particular person to make those decisions on my behalf. So that's a recognition that that person might be in a better position to make decisions on their behalf in certain circumstances. So if I get dementia, I would like a family member to make decisions for me, because I may, when I have dementia, I may make decisions that are not in my best interest. I may think I can do things that I simply cannot do. So I'm going to trust my family member to make those decisions for me. So on the face of it, it looks like, well, yes, LPA, if they're making the decision, that's fine. Very difficult when it comes into the context of deprivation of liberty. Because as we've heard today, there are triggers for going to court. That inherent human right of having speedy access to court if somebody wants to challenge their deprivation of liberty. So that's why a lot of these cases, even if there is an LPA in place, quite often end up in court because of that need for public bodies to protect those Article 5 rights of the individual. But does that necessarily mean that the court application needs to be made before that person is discharged for hospital? General principle is no, it doesn't mean you have to go to court before, but there are certain safeguards that need to be in place. So, for example, there needs to be agreement from everybody. The LPA agrees with what you're proposing. There should be a DoLs in place in hospital. There should be a DoLs in place for the place that you're going to go to. If you're going to a care home, get the DoLs in place there. The transition plan of getting the person from A to B. We're going to cover all this in the delayed discharge, so I won't go into too much detail. Getting the person from A to B, as long as that doesn't amount to deprivation of liberty, that to me looks like a safe way for, as long as when the person gets to the care home, the representative of the RPR reflects and says, okay, he's still challenging this. I now need to go to the Court of Protection. So do it, but go to the court once they've moved. Yeah. So I'm not saying that is a one size fits all, and you can do that on every occasion, but there's certainly a way of getting through that process if the LP agrees to it without going to court. And I know there may be disagreements about that on the ground, especially with some local authorities who take the view, no, you need to go to court before you discharge the patient. I get the rationale from that, but I don't necessarily agree you have to do that on every occasion. That's the whole point of LPAs. Any other questions? There's chat and there's question Q&A. Is there anything else in there? There's a question here from J. Ventura Santana about when a person is under court of protection and detained under Section 3, at what point is the court proceedings closed? In the context of what we're talking about, of understanding everyone's role in the court of protection, this is quite an important point, because court of protection jurisdiction stops. Well, the court of protection does not have jurisdiction to make decisions over what happens when a person is detained under the Mental Health Act. It is a specifically excluded decision. The court has no powers to make decisions about treatment under the Mental Health Act. It does have jurisdiction about what happens if the person comes off the Mental Health Act. And of course, if somebody was on a Section 2, for example, well, that's going to expire after 28 days and it has to go to a 3, or they're discharged from the Mental Health Act. So quite often, if somebody is detained under Section 2, the court will retain its role for now and want to know, well, what are we going to do if the patient is discharged from the Section 2? If they go on to a 3, usually the way we approach it is to say, well, get some evidence from the health board. Well, how long do you think that person will be detained? If it's going to be for a month, court protection proceedings may still open. As we've heard earlier, the role of the judge, the court, is to ultimately make a decision and to make directions to ensure that all the evidence is in place for when the court has to make that decision. So If, for example, the person is going to be detained for the next 2 months, the court might say, well, in 2 months, I need to make a decision as to where P goes next. So let's get the evidence together now, schedule a hearing, so that whenever that section 3 goes, we're in a position to make a decision as to where P goes next and whether it needs the DoLs, etc. If the clinical opinion was this person is going to be detained for the next 12 months, it's more likely the court's going to say, well, in that case, I'm not keeping these proceedings open. We'll close them off, but on the understanding that if there's any dispute about where P goes next, then that comes back to court. Okay. So again, no one size fits all, but it's largely in the hands of the health board to evidence how long that person is going to be detained under the Mental Health Act. Okay. I'm going to move on then to an old chestnut, section 49 reports. And if you've got it in the chat at the very start, you've got the materials, and there's one specifically on section 49 reports. So what I'm going to talk about, I'm going to talk about what is a section 49 report. I think all of us in our different fields probably have their abbreviations and lingo, and I quite often get people talking to me about, oh, it's a section 20 or it's a section 47. I think, section 20 of what? What are you actually talking about? So we'll talk about what a section 49 report is. We'll talk through what the court rules are. And there are rules, often not followed, but we'll remind ourselves what the rules are and what that actually means for the health board. And then we're going to think about processes within health boards for dealing with section 49 orders, how to get it to the right people, who's going to deal with it. And I'll deal with some guidance for those who have to draft these reports and what it kind of should look like. And then I'm going to answer a few questions that I would anticipate and I've received on many occasions over the years. Like, do I really have to do this? Really? Or who has to do it? Or how long do we have to do it? Do I get paid to do it? So we'll start with what does section 49 actually say? So it's section 49 of the Mental Capacity Act. So it's right here in the Act. It's not a court rule. It's not in the code of practice. It is actually in the Act. So it's given quite significant prominence in the Act. And I've done some research into this. I've tried to go back to like, what was the point of it? What was the thinking behind including this in the Act? Because what it says is that the court can require a public body, local authority, or a health board to provide a report on pretty much anything it wants that it feels is relevant to the proceedings. And that applies even if the health board isn't a party to that set of proceedings. That is quite a part. That is quite a significant step to allow the court to be able to do that. So I was thinking, well, why? Why is that in there? What is the point of it? The point of it is, in a lot of court of protection proceedings, whether it involves the health board or not, it usually involves some need for evidence from health or social services. These are health and welfare decisions. So necessarily the court's most likely going to need to hear some health evidence or some welfare evidence. And what it doesn't want to do is to have to spend a huge amount of money and time running off to independent experts to provide reports in these cases. If there are people already involved with the patient. So let's just ask those who are directly involved, even if they're not parties to the proceedings. Classic example, and one of the sort of reasons why I think this was included in the Act is, we've had this scenario before, of somebody who the decision is whether they go home or go to a nursing home. And there's issues about capacity and best interest, yes, but the individual has lung cancer. And it would be really helpful whenever weighing up the pros and cons of depriving somebody of their liberty in a care home against their wishes, if you knew, well, what is the impact of the lung cancer? Is it treatable? What treatment are they going to need? And what's the life expectancy? And when we got that evidence back from the oncologist, they said, well, the life expectancy is only a matter of months. So you can see how that might impact a best interest decision as to whether you force somebody who only has a few months left of life to live somewhere that they absolutely do not want to be and will be miserable until the day they die. Whereas they may be more comfortable at home, even if they're not getting the whole of their care needs met. That's their end of life plan. And it could be difficult to challenge that on that basis. So that's an example of where I think it's a very good use of Section 49. But what we are seeing is that health boards are being asked to go beyond that, and it's being used most often for capacity assessments. Capacity assessments potentially for people that nobody from the health board is particularly familiar with, may not know them at all, may not have had any contact whatsoever. I don't agree that that's an appropriate use of Section 49, but I seem to stand pretty lonely on that soapbox, because it is built into the court rules that Section 49, and certainly the court rules and the court guidance and the practice directions that come with the court rules, that Section 49 reports can be used on that basis. So within the guidance document that you've got, there should be links to the Court of Protection practice direction, which forms part of the Court of Protection rules. So court rules usually have the rule and then an associated practice direction, which is a bit looser and a bit more explanatory as to how to apply that rule. The correct process for before a Section 49 order is made is that one of the parties to the proceedings is supposed to contact the person who they want to do the report, a health board, and ask, can you do this report? Is it appropriate for somebody within your organization to do this report? Who could do it? And when could they do it by? They're supposed to ask that in advance of making an application to court for the Section 49 order. In order to ask that, they need to know where can they send that request. So the health board is supposed to have a contact, preferably email, that other organizations or solicitors, etc., know can be contacted for Section 49 requests. And then somebody is supposed to keep an eye out for those Section 49 requests and then act on them. And by act on them, I mean go and find out who's the most appropriate person to do this report and when could they do it by. The general approach, and I say general because some health boards have good processes and some are better than others, but consistently throughout the years, the general feel is, oh God, really, do we have to do this? And trying to identify who is going to do it is quite problematic, especially if the patient is not known to any clinician or they're not currently open to them. Because individual clinicians, and usually when it comes to capacity assessments, there's a specific requirement from the court that it is done by a particular field of expertise. Psychiatry, psychology, maybe there's a specific issue about cancer, it'll be by cancer, or it'll be gastro by gastro. But quite often, if there is a dispute about capacity, then the courts usually feel that they have a need for expertise from a psychiatrist because of the underlying mental disorder in play. I'm not sure if it is in any job description of any psychiatrist acting for any health board to do Section 49 reports, capacity assessments for people who are not their patient. So that can cause difficulty for a health board to identify somebody within its organization to do it. Especially when there is no payment for this report. No one is going to pay for it. The court doesn't pay for it. The parties don't pay for it. There is an expectation that by providing these reports, the health board is just fulfilling its functions as the NHS. That's part of what it does. That may be seen as unfair, but that's the way it is. So think about in your organization, is there somebody who is responsible for Section 49 reports, for identifying who's going to do them, for doing them if the order is received, for asking around, working out who can do it and when they can do it by, and then responding to that, because actually the time frame within the practice direction is very short. I think it's only 7 days. The expectation is that, and the term used is a senior officer in the NHS body, is supposed to identify somebody with appropriate expertise to do the report and then notify the parties within 7 days of who the nominated person is going to be. Usually these orders don't specify an individual, it usually specifies either it's just neutral, just somebody, or it might specify particular expertise. I think it's rare to have a particular individual named, but I think it is within the powers of the court to actually name an individual. And that can be very problematic because then it is the individual who that order is being addressed to, and it has to be a process whereby that order is communicated to that individual urgently so they can consider and respond if they can or cannot do it. So it is important that somebody with the right expertise can do it. Otherwise, if you think these orders are being made for a reason, they're being made for a reason because there isn't sufficient evidence. Court needs the expertise. So if you get somebody to do it who doesn't have the requisite expertise, then the weight to be attached to that report is going to be impaired, limited. Get the right person to do it. What happens if you can't find anyone to do it? That's a tricky one. I know of some organizations, I think, who have set up essentially a rota. We don't seem to get as many Section 49 orders as we used to, for reasons I'll explain. But I think a number of years ago, one health board had a rota of a number of consultant psychiatrists who were willing and able to do Section 49 reports. And there may have been, some element of, including that within their units or their contract or however consultants work. In other organizations that might not be in place, and somebody just has to ring around and try and find somebody as best as possible. So it's up to each health board as to how they want to approach it, but the expectation is you're able to respond within 7 days, and that is not a lot of time in healthcare to respond in. So I've set out on that guidance document just to think about, well, what are your processes. So who's going to receive it? Whose email address does it go to? How are you going to communicate with solicitors that that's the right email address? As I said, there's not many solicitors in Wales that do this, so that's not a problem. If you need any help with that, we can put you in touch so they know the correct address to send them to. When you get it, who's doing what, who's doing the doing, who's circulating it, who's identifying it, who's taking responsibility. Then it's about, if you find somebody who could do it, it's within their area of expertise. But the issue is, well, I don't have time to do it. What can you do about that? Section 49 order. Let me put this. If you don't respond within 7 days, you risk the party going off and getting the order from the court without your input. That's the problem of not responding. So I'd always encourage responding and at least putting a sort of a long deadline on how quickly it would take for you to do it. Because if the applicant goes to court, gets the order, then they'll serve it on the health board and it will say you need to do this within like 3 weeks or something ridiculous, which is just, usually not possible. What I usually say to any parties who are suggesting they need a Section 49 is that they should make the application formally. You should give the health board sufficient notice of what they're asking for, but they should be working on the basis and the expectation that the health board will be unlikely to produce a report, especially a capacity assessment, within anything less than 12 weeks. And I haven't just plucked that figure out of the air. We did an exercise. I think Hannah and I did some training at a health board a few years ago, and we did a bit of a survey of a room full of psychiatrists, and we talked about how long would it take them to do a Section 49 capacity assessment, and the level of detail that is essentially required or expected from the parties and the court. So that they had a discussion amongst themselves, and they thought about, well, okay, so you got to read all the documents, all the instructions that you've been sent. And usually you would get a copy of the order telling you what to do, and a letter of instruction with more detail about the law and how you're supposed to apply it. Then you got to go and find out about pay. As I say, it may not be your patient. So that takes time. You got to find records, and you maybe have to meet some people and chat to them and get an idea of what's the circumstances and why are you being asked to do this, what decisions are you're being asked to assess capacity on. And you got to go and see the patient, probably more than once. That might involve travel. Then you may need to go and find some more documents to read up on. And then you got to write up your report. You got to type it up and check it, think about it, and change it, and edit it, and format it, and all these things. And they came to the conclusion that they thought on average that would take 14 hours worth of work to do all of that. I think people underestimate how long it takes to do these things. So they really tried to drill down into the detail of how long would it take. 14 hours, that's 2 whole working days. I don't think there's many consultants, especially psychiatrists, who have 2 whole working days free in their diary in the next couple of weeks or 3 weeks or 4 weeks or 6 weeks. And my understanding is most appointments are arranged 6 weeks in advance, and they have to give 6 weeks notice to change those appointments. So the first 6 weeks you can almost write off. Nothing's going to happen in 6 weeks. So that's actually giving them 6 weeks to do a report, not 12 weeks, 6 weeks, because they can't do anything in the first 6 weeks. And then they get 6 weeks to read up, go and see the patient, write everything up. So that's, in my view, that's not an unreasonable amount of time to do a capacity assessment. But I can't say that. I can't go back. If we're involved in proceedings, I can't go back to the other parties and say, the health board can do it, but they can only do it within 12 weeks. It's not for me to say that. I say it as a guide to manage expectations, but it's actually for the health board to come back with evidence if they can't do it within a certain time period to say what that is. So I usually advise, find the person who it's within their expertise to do it, and get something directly from them to say, I'm the right person, I can do it, and given my clinical commitments, I've looked through my diary, and the earliest I think I could do it, given the estimate of time I think I would need to do this, would be on whatever weeks they say. Could be 12, could be 6, could be 8, whatever they say, not whatever I say, whatever they say. Because then you are giving an honest, fact-based appraisal of how long you think it would take to do it. Very difficult for anyone to argue with that. Court cannot, should not, be asking a doctor to cancel appointments with other patients to do a Section 49 report. I don't think there's any obligation to do that. I don't think a court can insist that a clinician do that. And I've said to judges on numerous occasions, well, for this to happen, this doctor will have to cancel 12 appointments with mental health patients, and they will not get another appointment for another 12 to 18 weeks. Do you want them to do that? Oh, no, I don't want them to do that. There are other options if for parties to proceedings if they cannot get a Section 49 report. One of which is to get the Section 49 report from what's called a special visitor. That is usually a retired or semi-retired psychiatrist who maybe did NHS work in the past, maybe they're just private, maybe they're still practicing but as private psychiatrists, who sign up to a rota for the Office of Public Guardian, I think, runs it. So they can be allocated to the case, so they're not NHS, but they can still do a similar report. If we go back 6-8 years ago, there weren't very many people doing that, and the standard of the reports that they were providing and the timescales within which they were doing those reports was not great. But that has improved massively over the past few years, and there's some very experienced people who act as special visitors who could do these reports. We find that parties are a lot more amenable to getting those 49 reports from a special visitor rather than insisting it be from the health board. The reason why a request is made for a Section 49 report is because it is part of the court rules that parties cannot get an expert report, an independent expert report, unless they can show that it cannot be obtained by way of a Section 49 report. So whenever you get a Section 49 request, it may not, that the parties may not be insisting that you do it. They're generally asking the question, can you do it? And if you were to say no and give good reasons why you can't do it, they may say, okay, that's fine, we can go and get an expert now. But we have to demonstrate to the court that we can't get that evidence from a Section 49 report first. Okay. A lot of health boards get these orders and think they absolutely have to do it. It's a court order. Of course, you're supposed to do it. But as Larry said earlier, when we get these orders, yes, you have to do what it says in the tin, but there's also scope to apply to amend, vary, or discharge the order that has been made. But in order for us to do that, we have to make a formal court application, and any formal court application must be supported by evidence. And this is why we need the evidence of the person who's been identified to say, yes, I can do it. This is my estimate of how long it would take, and this is how long it would take me to produce the report. If that's okay with you, then I'll do it, but I need that amount of time. And then it may well be the court or the other parties decide to go elsewhere. So that, I think, is the best approach for dealing with Section 49 reports. And if anybody is going to do a Section 49 report, then they are entitled to have very clear guidance as to what it is they're being asked to do. And sometimes that is not forthcoming. And I think you can insist on clear guidance as to what you're expected to do. The difficulty with Section 49 reports is if somebody disagrees with your opinion, what's to be done about it? Can they call you to give evidence? I'm going to ask Hannah here. Hannah, do you have any experience of somebody writing a Section 49 report, actually then being called to give evidence and challenged about the contents of the report? I don't think I have, but
I've got one at the moment, actually, although it hasn't come to, we haven't had the hearing yet, but I've got one at the moment where they're seeking to call the author. At the moment, we're trying to sort of resolve it through further sort of witness statements to answer a few questions to sort of try to avoid the need to call the witness to give evidence, but he's on notice at the moment.
Which is one of the reasons why I do not like Section 49 orders, is because quite often they are sought by local authorities who are, for example, placing somebody in a supported living or a care home or whatever, and their evidence that P lacks capacity is not good enough. And they quite often say, oh, well, we can't assess that capacity. That has to be done by psychiatrists. We don't have any psychiatrists. Therefore, we need a Section 49 report from the health board. And I won't go into detail as to the inaccuracies of a lot of that, but the danger of not responding to Section 49 requests is that they run off to court and they get what they want. Whereas an appropriate response to that would be, it's for the local authority to prove their case. And if they can't prove their case, they shouldn't be proposing something if they can't prove that P lacks capacity. It is their responsibility to come up with the evidence. It's not for us to do their work for them. So why is a psychiatrist being asked to assess capacity of somebody that they don't know? It's not appropriate. But health boards and local authorities are supposed to work collaboratively. There's supposed to be arrangements in place to do so under the Social Services Wellbeing Act. So that may be, that's up to your individual teams as to whether that is a legitimate request to help a local authority out. Some questions that quite often come up. Firstly, just in relation to the contents of the report, there is a format in the practice direction that says what the format should look like. It's not very helpful, to be honest. And I don't think I've ever had anybody take issue with the format of a report. That there's like 4 sections it's supposed to be in. That isn't particularly helpful because the bulk of the report will end up in just one particular section. It would be, I'm not going to stray too much into capacity assessments and how to do capacity assessments. That could be a whole day in itself. And the only thing we're really going to touch on this afternoon, Leanna's going to touch on, is the relevant information part of capacity assessments. But any capacity assessment, I noticed there's a question in the Q&A about capacity assessments and what should they look like and should they follow a particular format. I'll come back to that later during Leanna's talk. But Section 49 reports are essentially a bit of a halfway house between a capacity assessment and a full independent expert report. I think there is an expectation that it's going to be detailed, that you're going to demonstrate an understanding of how to assess capacity, that's going to include a clear expression of what you consider the relevant information to be, and a very well structured rationale as to how you've come to your conclusions. And we know from experience that not everyone is particularly good at that. We've seen some exceptional capacity assessments from some clinicians. We've seen some pretty average or poor capacity assessments. So it is important that somebody who's doing this is familiar with doing these reports. The frequently asked questions that we usually get asked, do I have to do it? And that's not an easy one. If you're named in it, yeah, you got to do it. And unless you provide us with evidence to say why you can't do it, and maybe we can shift it off to someone else. But usually the health board is for the health board to identify. What exactly do you have to do the report on? Well, you should be given guidance on that, so you should be fairly clear. And if you're not clear on what you're doing a report on, then ask. Go back to the person who got the order, the person who gave you the instructions. We may not be involved. This may come directly from solicitor for P or from a local authority solicitor. You, by all means, go back to them and say, I don't know what you're asking me to do here. Please give me better guidance, please. Do you get paid for the report? No, you don't. Well, certainly not by anyone other than the health board. That is an individual arrangement with, each local organisation needs to make whatever arrangements they see fit to ensure that these things get done. And if that means people you get extra units or whatever, how it works on their rota, if there's a payment for it, I don't know. That's up to each individual organisation to sort out. I wouldn't know. But generally speaking, there is no payment by anyone else into the health board to deal with these. Do you need to have experience with medical legal reports? No. And there is, the court have dealt with in a case a few years ago, it said there's an expectation that it falls within the basic levels of competence of any clinician in accordance with their regulatory requirements is to be able to do capacity assessments. So no, you can't get out of a place saying, oh, I don't do expert work, I don't do medical legal reports. That won't cut it. You don't have time to do the report. We've covered that. If you need more time, ask for it. You can't do is do nothing. If you do nothing and the time scale passes, and then you make an application and say, oh, we need another 12 weeks to do this, that just causes all sorts of problems. And you may be facing cost consequences for that, because that sets everybody back. If they'd known it was going to take 12 weeks from the outset, they might have gone somewhere else. But if you wait 6 weeks and then make your application and say it's going to take another 12 weeks or another 6 weeks, then it messes with court timetables. And if you haven't complied with the order, then there's always going to be a risk of costs. Where do you send the report? Technically, it's the court asking for the report, and it should include within the order where you return it to. The rules say you're actually sending it to the court, and then the judge decides whether to share that with the parties. I think in practice, what usually happens is everyone agrees that it just gets sent to the solicitor acting for P, and then they will deal with it. They'll file out of court and they'll disseminate it amongst the other parties. Okay. So like that's an overview. We have helped lots of people with Section 49 reports because they're really, as I say, mostly they are capacity assessments, and we can advise in relation to those, and we can help, especially with what Ileana's going to talk about, what's the relevant information. We can help with what a good one looks like. We've got examples of what good capacity assessments look like. In those materials, I've just put some additional resources. I've put links to Section 49. I've put links to the practice direction. I've put links to some cases about Section 49 reports. Very helpfully, there's been one called Cheshire and Wirral, where the judge has made comment about when it is appropriate to get Section 49 reports. So thankfully, we've got a High Court judge saying what I've been saying for many years, is that it should be in limited circumstances. And I think that has had an impact and effect, and I think we're seeing less of those. But I'm very conscious that a lot of Section 49 orders may not cross our desk, and there may be people on this call today who are responsible for receiving those orders and disseminating them without the need for legal advice, because they rarely need legal advice in interpreting the order, and that there's local arrangements in place for that. Okay, so before we stop for lunch, I'm just going to check if there's anything in the chat or the Q&A. I don't think there is. There's maybe a few questions left, which we'll try and pick up later on today. in a more relevant section. But for now, thank you very much. So we are going to pick it up again at 1:15. Thank you very much. See you then. Hey, welcome back, everyone, for this afternoon's session. We got a couple of talks, and then we're going to have a short break and have some breakout rooms. So have a think now about which breakout room that you'd like to go to. I think any one of those subjects we could probably talk for a whole day on. So they're not about giving you the answers to every possible situation. They're very much about raising awareness of the most common issues and how to deal with them, and when it might be appropriate to seek specific legal advice. I've noticed there's a few questions that we haven't answered yet. I think some of those, I think Steve in particular, I'm sure Hannah will pick up yours during the medical breakout room. If you want that, if you want to attend a different meeting or a different breakout room, that's fine. Come back at the 10 to 4 Q&A and we'll pick that up, because that certainly sounds like a tricky situation. We're not going to be able to advise in individual cases, but we can certainly talk through some of the principles. So this afternoon, I'm going to talk a bit about commissioning decisions in the Court of Protection. What comes first? The sort of chicken egg situation of, is it options and then best interests, or is it best interests and then options? Then Ileana's going to talk about capacity assessments, and in particular, what is the information that's relevant for the purpose of that capacity assessment? There's a whole host of decisions, as I'm sure we all know. Capacity is time and decision specific. And in practice, there may be 2, 3, 4, 5 different decisions that need to be made by P if they have capacity. And therefore, there may need to be a capacity assessment of each of those individual decision-making capacity. Quite often there's an overlap. So Ileana's going to talk you through what is the relevant information for each of those and the potential overlap between some of those different decision-making. We've got, I think, 150 odd people here. You're all coming from a range of different backgrounds and different specialties. Whilst my next talk is geared more towards commissioning teams, so your continuing healthcare teams, but it is helpful for those who are involved in MDTs in a wider sense to understand the process, because quite often it might be you who's going to a commissioning panel with a proposal to seek funding approval of that option. And it's helpful to understand the relationship between the two. Okay, so again, please feel free to put your questions in the Q&A, and we will try and pick all of those up throughout this afternoon. Commissioning decisions. So it's number 5 in the materials. It's called Court of Protection Guidance, Making and Evidencing Commissioning Decisions. In the context of Court of Protection cases, of course, one of the key issues that a court might be asked to decide, or what's in dispute, is what is in the best interests of the individual. And as I've already explained, a lot of those disputes are about where the individual should go when they're discharged from hospital. Should they be in a care home? Should they go home? Should they be in supported living? Those that represent patients tend to see these options through the lens of restrictions. And they consider somebody being in hospital as very restrictive. Then they might consider like an EMI nursing home to be very restrictive. Then maybe an EMI residential, then a general nursing home and a general residential home, and supported living, then maybe some kind of special care facility, and then living independently by themselves. So they tend to view things almost in a hierarchy of restrictions, and they're usually arguing, in a lot of our cases, what's at stake is where they're going to live, and they want to try and argue for the less restrictive option. And the individual at the heart of the proceedings may express that they want to live at home independently, maybe with a package of care, they're happy with that, but they feel able to live by themselves at home. And as I'm sure you all appreciate, there are various risks and benefits to all those options. And the court is being asked to choose which of those options is in the patient's best interests. Now, for a number of years, it was quite unclear as to whether, are we saying the court can choose whatever it thinks is in the best interest of the patient, and then we have to go to the health board, the local authority, the commissioning team, and say, are you willing to commission that? And what happens if they say no? Or is it the other way around, where the commissioning team say, this is what we're willing to commission, and there are one or more options for the court to choose from, and you can go away and choose which option you think is in the best interests? Which way around is it? And this was in dispute and got resolved eventually by the Supreme Court. So it's quite helpful. It went all the way to the Supreme Court, and we now have very clear guidance on which way around it is. And picking it right back to what I said earlier about what the role of the court is and what its powers are, the court can choose, it can make decisions on behalf of P, which means it can only choose from the options that would be available to P if they had capacity to make the decision themselves. And an individual cannot insist on something if a health board or local authority is not willing to provide it. Much in the same way as Hannah will talk about later about medical decision making, a patient cannot insist on an operation or a procedure that is not clinically indicated. So in the same way, an individual cannot insist on something from a public body that is not indicated. And that therefore means that it is up to the health board, and only the health board, who can decide what options are on the table for patient and therefore the court to choose from. So what are the options on the table? There may be theoretically a whole range of options that are potentially viable, but the court can only choose from those that are actually viable, and there is some commissioning approval of. That does make it practically a bit tricky, because my understanding is quite often an MDT will make a decision as to what they think is in someone's best interests. They will put together a proposal. They will go to a commissioning team who will look at the evidence and decide whether or not that meets their criteria and sign off on it, and away you go. Fine. Nothing too wrong with that. Problem is, if there's a dispute about where the patient goes, and there's a range of options of where they could potentially go, then the correct process really is for the commissioning team to say, well, in principle, we would be willing to commission a range of options because we think they could all meet the individual's needs. That might be at home with a particular package of care, or a residential or nursing home. So we then have to look at, well, what dictates how that commissioning team make their decisions. And that decision is being made by a public body, and therefore it must be compliant with public law principles, which means it has to be a logical decision, has to be rational, and has to be lawful. The challenge to those decisions actually doesn't lie in the Court of Protection. The Court of Protection can't overrule a health board that makes a particular decision about what options are on the table. But in practice, what the court can do is ask questions of a health board. It can ask it to make a decision and to explain its reasons for its decision. And there are lots of other jurisdictions that work in the same way. Education Tribunal, for example, works in the same principle. It can't dictate what the health board provides to meet an educational need. It can just ask the question and ask for a decision and the reasons why or why not. The ultimate sanction then, if somebody was to disagree and wishes to challenge a health board decision about what options are on the table, is judicial review. And that's what I mean about decisions by public bodies need to be compliant with public law. It means those decisions would be potentially tested on whether they are logical and rational. And the way health boards deal with that is by having policies. It has policies based on that have been drafted in compliance with the law that sets out how a decision is to be made and what factors are to be taken into consideration. And as long as those procedures are followed and the health board can arrive at a decision that is reasonable and in accordance with the policies, then usually that is sufficient to withstand challenge, and therefore the Court of Protection can only choose from those options that the health board has said it is willing to commission. So how in practice should we do that? And I think the correct process is for an MDT to present to a commissioning panel a range of options that are within within a reasonable sort of spectrum of, well, this is potentially viable. This could work. And that might be 2 or 3 different options, and there might be pros and cons to each of those. But at this stage, we're not making a best interest decision. It's for the commissioning team, on the basis of that evidence of the MDT who knows the patient the best, to then apply their principles and say which of those options it's willing to commission. As I said, it may come back with just one, or it might come back with 2 or more. And if it comes back with 2 or more, then that goes back to the MDT to then comply with the Mental Capacity Act in terms of Section 4 best interests, consulting with P, those who are interested in P's welfare, etc. And that might be wider than the usual sort of clinical MDT, to arrive at a best interest decision. And if there's a dispute on that, then that decision can be made by the court. And then once that decision is reached, it can go back to the panel for final sign-off and approval. So how does one then make that decision of the commissioning panel as robust as possible? And we've set out in the guidance a suggestion, and it is just a suggestion, of how a commissioning panel might want to sort of formulate or document their decisions. I think a lot of panels, in my experience, don't necessarily record in detail their reasons for their decisions. But as a public law principle, any decision being made by a public body should give reasons, and it should be documented. So how does the starting point then is for the usual procurement processes of a health board to be followed. And I know that might be set up in different ways in different health boards and for different areas, mental health, learning disabilities, neuro, rehab, that might all be slightly different processes. But that process will have been established in accordance with the health board's sort of procurement policies to make sure that any potential provider is a suitable provider. And then there's a number of factors that, certainly in my experience, that health boards, commissioning decision makers will take into account. And that might be safety, for example. So safety of P, safety of others, the reliability and the sustainability of the proposal, and affordability. They're the main ones. And I just want to touch on safety for a moment, because safety of who? Can a commissioning panel take into consideration whether something is safe for P? And I think the answer is it can to some extent, but it should not be a decisive factor, because don't forget the court is being asked to make a best interest decision. So it would be somewhat the wrong way around if a commissioning panel was to say we're going to rule out option A because it wouldn't be safe for P. But that is exactly what the Court of Protection is there to decide, and what it can be prepared to decide. It could choose an option that is less safe for P if there are other factors that weigh against it. Good example, with a lady a few years ago, and she was at risk of falls. She had already fallen once or twice, being admitted to hospital. And the question was whether she gets discharged home again. And the health board said, we're not willing to put together a package of care for this person because it would not be safe for them to go home. But all the other factors weren't in play. It was sustainable in the sense that they had enough staff, it was affordable. So it was really only the safety of P that was an issue. And what the health board had to consider is, but that's essentially making a decision of best interest. You shouldn't take that option off the table purely on the safety of P. And ultimately, the court did decide that P should go home. And she went home despite her being at risk of falls. And the health board did provide a package of care to try and support her at home. And she did fall over, and she did die as a result of that fall. But the court had made that decision balancing her safety in terms of risk of falls with lots of other factors. And it considered that going home was, in fact, in her overall holistic best interest. Yes, there was a risk, and yes, the risk did manifest when she was discharged. But in lots of other cases, she may not have fallen over and she may have lived perfectly happy at home. So that's just one example of how the court needs to be given the options and not have options removed from the table purely on the basis of safety to P. Now, of course, quite often it's not just the safety of P. It could be the safety of staff and support staff who are going in to support the individual, and that may be unsafe. There may be a risk to the physical or safety of staff who go in. If you have a particularly aggressive individual, maybe with confusion and dementia living at home, who won't let anybody in, who is aggressive towards them if they do come in. Every time they try and help them with personal care, they're lashing out and hitting out. If that's not manageable in a home environment and it is unsafe for staff, then the health board is entitled to say, we cannot manage the safety of our staff within that environment. We are not willing to commission it. That is a good reason to take an option off the table. That ties in to some extent with the reliability and sustainability of a package. So it may well be, and we see this very regularly, an individual who wants to go home, and the health board's view is, well, we could send her home and she might be fine for a day or 2 days or even a week, but it is inevitable that that will break down. It is inevitable that she will become aggressive or non-compliant, and we will not be able to do anything about it. And therefore, the whole thing will fall apart. The staff who are going in, their agency staff or their commissioned care provider, they are not going to tolerate that. They will just walk away and we will have no care. We will not be able to put the care into that home. We've had a very long-running case where individual was living at home with parents, and every care provider who went in to provide care to that individual, the package broke down. The staff were not willing to tolerate the abuse, the way they were treated by the parents. So after one package breaks down, you try again. Another one breaks down, you try again. And you're getting to the point where it's very difficult to find any care provider who's willing to go into that home. There isn't an endless list of people who are willing to do this. So that's the point at which you're thinking, well, this isn't sustainable. Even if we find somebody who's willing to do it, it's not going to last long. We know from past behavior of the family, parents, whoever, that this package is highly likely to break down. Therefore, that could be a good reason for the health board to say, we're not going to commission a package of care at home because it is unsustainable. We know that, we've got the evidence to back that up, so we're just not going to do it. Let's focus our attention on a different model of care for this person. And that might mean they have to be removed from home and put in a different care environment, which of course is going to be controversial and of course is going to be disputed by the parents. But when it comes to what decision the court has to make, that option of a package of care at home, and realistically the court's wasn't going to send the individual home to the parents without a package of care, then that option is removed from the court to choose from. And legitimately removed, because if it is a decision that has been made in compliance with the health board's practices, procedures, policies, etc., and it's a decision that could withstand that judicial review, it's in compliance with public law responsibilities to make a lawful, rational decision. So in a lot of court of protection cases, what we're trying to do from the outset, before we get to capacity and best interests, is to really narrow down what are the viable options that the court is actually being asked to choose from. In a medical context, that might be use of restraint in order to do a particular procedure. Well, that sounds as if it's doable. In most scenarios, that could be doable, but there may be circumstances where that is not achievable. And quite often I advise, well, you work up a plan as to how you would do it, get everyone to sign up to it, and let me know if you arrive at a point where you could viably do what you're suggesting. And in some situations, health boards might come back and say, no, we can't actually do what we thought we could do because we've taken advice from mental health teams or intensive care teams, and it would be unsafe to do the level of restraint needed in order to do the procedure because they are too unwell. It is highly likely that by using restraint, we would cause significant harm and risk death of the individual. Therefore, it's not clinically appropriate to do that, to propose that as an option. Therefore, that's it off the table. We don't have that as an option anymore, and we have to choose from whatever is left. Of course, those types of decisions, it's always good to have second opinions to back up that plan is a rational decision. That's particularly controversial when we've got end of life cases, when we have maybe decisions to not offer a life-saving treatment or to withdraw a life-sustaining treatment. Affordability. It's often considered that, oh, money isn't a factor, and it's a very difficult thing to talk about openly, especially in public court of protection proceedings, to say we're not doing something because it costs too much. But when we're talking about a range of options and you could achieve the same outcome through a different means that is more affordable, then a health board is entitled to make those decisions, because it is not acting and is not just responsible for one single individual. It is responsible for an entire population, and it has to spend its money in a way that is sustainable for the entire population. There's no point spending £2 million on a package of care for one person. There's no money left for 10 people who are next in line. Whereas if that money could be spent and spread more equally, but the needs met to a similar standard, then a health board is entitled to say, we're not offering this as an option. And this is particularly controversial when it comes to meeting someone's needs locally or further away. If it is simply not affordable to meet the needs locally and there's an alternative option that's a bit further away, then a health board is potentially permitted to say, no, we're not offering this local option because it is just simply unaffordable. Now, they're the sort of headline ones, and of course there are nuances in all of these. But what I've suggested in the guidance document is how to document that panel decision. And if you have it open in front of you, I've suggested documenting a bit of the background and summarizing some of the evidence that's been presented. And then look at the options. Look at each individual option that is potentially viable, and then go through and think about whether each of those meets the health board's criteria. So look at what those options would look like. What would that actually look like? What would it involve? Where would it be? What would the care package consist of? And then going through each one and saying whether you think that would be sufficient, safe, whether it's of sufficient quality, whether it's affordable, reliable enough, and make a decision on each. So make a decision on each option. And document some of those reasons so that by the end of it, the MDT is taking away a decision, a thought out, documented decision from the panel as to which options it has to work with. And if that's more than one, then that goes back to the MDT, who can then focus on, okay, here's the options we've got to work with. Let's now think about what's the information that's relevant to each of those for the purposes of assessing capacity. and then what is the pros and cons of those options for the purposes of making a best interest decision. And as I said, those decisions that you have to cast the net maybe a bit wider than the immediate MDT when it comes to making best interest decisions, because that's going to involve the patient themselves, family members, maybe a deputy or LPA or someone else, that patient who is interested in P's welfare. And then, and only then, really, should you be making a best interest decision. So this is probably a good time then to think about the next stage. So we've got our options by this stage. Then we're thinking about the next step, which is, can P make the decision themselves? Do they have capacity to make that decision themselves? And before we assess capacity, because we know under sections 2 and 3 of the Mental Capacity Act, that what we mean by assessing capacity is, can the person make a decision? Can they understand, retain, and weigh up the relevant information, so that the information that's relevant for making that decision, that's what they're being tested on. They're being tested on whether they understand it, whether they retain it, and whether they can weigh up and use that information. And all too often in court of protection proceedings, what we see is a jump from options to capacity assessment. And I think there's a stage in between, a really important stage in between, which is actually taking stock and identifying what is the information that's relevant for this decision. And I'm not sure it's right that identifying that information should be left to the person assessing capacity, because they might be a psychiatrist. They may have nothing to do with those commissioning decisions, with the normal MDT. They'll know very little about the detail of what these options are that are being proposed. So they need to be provided with that information. A lot of capacity assessments that we see, they read as if it's a test, testing P. Well, how would you look after yourself if you go home? Where would you live if you go home? And that's usually criticised by those representing P, usually not particularly well received by the courts, because capacity assessments are not a test. They're not a memory test. It is questions should not be asked in an open way like that. The information should be provided to P, and then they can be tested on whether they understand and retain and weigh up, yes. But there's an obligation to provide that information in the same way as you would provide the information to somebody who did have capacity. If you had a medical procedure, any clinician, when proposing a medical procedure, is legally obliged to provide the individual with all the material risks and benefits of that procedure or not doing it. So in my view, in the same way, anybody who is being asked to make a decision about two options should be provided with the pros and cons of those options. What are the material risks and benefits of those options? So it necessitates, and potentially, this is an MDT exercise of identifying what is all the information that is relevant for the purpose of that decision. And this is where I'm going to hand over to Ileana, who's going to talk about capacity assessments in different circumstances, different scenarios, and try and highlight what that relevant information is in those different scenarios. And she's probably going to give you some steer towards some of the good guidance that's out there. Okay, over to you, Ileana.
Thank you. Good afternoon, everyone, and thank you for joining us today. My name is Ileana, and I've been a solicitor with Legal and Risk for 3 years, during this time, I've definitely worked with some of the people on this call. As Gavin said, I'm going to spend around 30 minutes talking about the Mental Capacity Act and specifically focusing on Section 3 and what the law means when it refers to relevant information. In the handout notes, you'll find case law and guidelines that underpin the legal decisions made in relation to these assessments. So please have a look through. The relevant information is really important in respect of assessing capacity, because if you don't identify what information is relevant, you can either go too far and declare someone lacks capacity, or too low and assume someone has capacity without being able to test what they really understand. If we first have a look at the legal framework and explore how the relevant information changes depending on the decision, so whether it's about medical treatment, care, residence, or relationships, the aim today is not just to refresh your knowledge of the law, but to give you some practical tools that you might be able to apply in your own practice. The law itself and the Mental Capacity Act Section 3 sets out how you're able to determine whether a patient is able to make a decision. The test is functional rather than diagnostic, which means that having a diagnosis such as dementia, a learning disability, or a brain injury doesn't necessarily mean that the person lacks capacity. And what truly matters is if they can make the specific decision at the specific time. So Section 3 states, a person is unable to make a decision if they cannot do one or more of the following: understand the information relevant to the decision, retain that information for long enough to make the decision, use or weigh that information as part of the decision-making process, and communicate the decision, whether that's verbally through sign language or any other means. The first limb of the test is about understanding the relevant information, and this can be where many assessments either succeed or fail. If you do not define what the relevant information is for the decision to be made, the whole assessment risks being flawed. It's not a tick box exercise. It's about what someone needs to know in order to make the decision both real and informed. The information will always vary depending on the situation, and the law does not define for us because every situation is different. As Gavin mentioned, it's not really down to one individual to determine what is the relevant information. And before carrying out an assessment, professionals should agree collectively what information is relevant, as this can avoid confusion, keep consistency, and potentially avoid further conflict down the line. Also, asking a patient to understand everything about a topic would be completely unrealistic. You need to assess whether the person understands the key points to make the choice in front of them. So I will try and broadly cover some of the different decisions, but again, as mentioned, it will really vary on each individual patient and circumstance. For care decisions, relevant information could include what areas has the patient been assessed as needing support: personal care, feeding, breathing, mobility. What sort of support and how often is it needed? How long is it needed for, and in what form? Who will provide the support? Steps that the patient can take if they have concerns about the support. Why, very generally, why the support is needed and what the risks are. And then if we think about what would not be relevant, is how the care will be funded or managed. The patient doesn't need to necessarily know the ins and outs of the funding. And another example is how staff will be appointed. They don't need to know that. The person basically does not need to understand every single line of the care plan, but they do need to recognise, for example, carers might visit for 2 visits a day and they're going to help me with personal care. Without this support, I might be at risk. And then closely linked but separate, residents' decisions. Questions in respect of care and residents are separate, but sometimes the nature of needs means that they are interrelated. There is a 2021 case in the handout where the judge stated it would be artificial and wrong in this case to not consider residence and care together. It's her, the patient, the fundamental inability to grasp why she needs support and what would happen if she did not have it that underpins my finding that she lacks capacity in both these areas. Some relevant information in terms of residents' decisions can include if there's 2 or more options for living, some broad information about the area, the difference between living somewhere and just visiting it, the activities the person being assessed would be able to do if they lived in each placement, whether they'd be able to see friends and family where they live, the payment of rent and bills generally, any rules or general obligations of a tenancy, who they would be living at each placement, the sort of care they would receive, again, the 2 are closely linked, and the risk that a family member may not be able to see them if they chose to live in a particular placement. Things that are not considered relevant are the cost, and I know I mentioned the payment of rent and bills, but this is more general. They don't need to know the specific cost or the funding agreement, the legal nature of the tenancy, they don't need to understand, and more abstract further down the line scenarios such as what a relationship with someone might be in 10 or 20 years time if they chose this particular placement now. So it's not about understanding details such as staff rotas or the building layout. It's about understanding where they might live and what that means for them in their daily life. And then next, turning to contact decisions. Some broad examples of relevant information could be who the contact will be, the nature of the relationship between the 2, the location of contact, the positive and negative aspects of having contact, any risk such as criminal convictions or past assault, where contact is with a family member, a general understanding of what a family relationship is and how that's different to other forms of relationships. Not so relevant are concepts such as the long-term effects of contact decisions, risks which are not an issue. So, for example, an allegation of financial abuse or assault where there's no indication of likelihood. People don't need to understand every risk in detail, but they need to understand, for example, contact with someone who's harmed them in the past might expose them to being harmed again. The handout also covers contraception, and some of the examples of relevant information given are a rudimentary understanding of the reproductive process. That includes an understanding that pregnancy could be a result, the basic purpose of contraception, basic advantages and disadvantages of each type, possible side effects and how they can be dealt with, and the effectiveness. Not considered relevant is an understanding of what bringing up a child would be like in reality, or opinions of how a woman might get on with child rearing, or even whether the child might be potentially removed from her care. In a general summary, the person does not need to understand every single mechanism of contraception, but they need to understand that without contraception, pregnancy could be a result. In terms of sexual relations, relevant information can include basic mechanics, risk of pregnancy, risk of infection, and that the other person must consent. There's no requirement for someone to understand emotional consequences or long-term relationships. These might be important considerations, but they are not part of the legal assessment. In terms of conducting proceedings, relevant information could include understanding the nature of the proceedings, what they're about generally, the role of the different representatives, such as lawyers or advocates. But again, this is general. They don't need to have a legal degree. They don't need to have an understanding of complex legal arguments. They just need to understand enough to be able to instruct a lawyer and participate in their case. In terms of medical treatment, there is a lot to go into in this respect, and there will be a whole afternoon session with me and Hannah focusing on this. As a little introduction, relevant information can include understanding the nature of the treatment, the purpose of the treatment, the benefits, the risks and side effects, and the alternatives, including what would happen if nothing is done. Capacity assessments here are common. So, for example, think about surgery or refusing medication. They shouldn't be overloaded with medical terms, and relevant information should be explained in a plain language tailored to the person's understanding. Finally, the handout also covers sharing information about health and care. And relevant information here can include who is going to see that information, what kind of information or documents will be shared and why it's being shared, what are the consequences of agreeing and refusing. This is particularly important in the safeguarding arena or multidisciplinary working. So in summary, the Mental Capacity Act Section 3 gives us the legal test, but it does not give us a script. Relevant information is to be entirely tailored based on the decision in front of you. As professionals, your role is to agree what the relevant information for the decision is, communicate it in a way that the person can understand, remembering that the person does not need to understand every detail, and behind it all, the intended empowering principles of the Act. You should always assume capacity unless proven otherwise and support people to make their own decisions. Capacity is decision specific and time specific. What is relevant information today for a decision might not be relevant tomorrow. The ultimate question I would like to leave you with is, what does the person truly need to know here and now to be able to make the decision for themselves? Thank you.
Thank you, Eliana. I just want to pick up on a few of those points and talk about a concept that's been brought up in, I think, some of the questions, which is around fluctuating capacity or people who don't actually engage in capacity assessments. The relevant information will remain the same, but it's quite often a difficulty for people to assess capacity and actually sort of conduct the capacity assessment in those circumstances. And one thing that comes up quite regularly is this idea of fluctuating capacity, and what do you do in those situations? Do they have capacity? Do they not? It changes over time. And I think what's always my advice is usually, well, if you think it's fluctuating capacity, then that must mean at times they have capacity, and sometimes they don't have capacity. So if you think that they have capacity at some point, well, that's your opportunity to do your capacity assessment. And part of the relevant information for the capacity decision might include their understanding that at some point in the future, they're likely to lose capacity. So classic cases, what we see is quite a lot of young people with emotional dysregulation. So they may be considered to have fluctuating capacity. When they're emotionally dysregulated, they cannot, very difficult to control. They're putting themselves at risk, and therefore they need to live in a particular care environment where there is support available to prevent them from self-harming. If a person is fluctuating capacity, then there's no reason why they can't have a conversation. The capacity assessor can't have a conversation at that point in time and include within the relevant information. Do you appreciate that whenever you get emotionally dysregulated, that you are likely to behave in whatever way, and that you are putting yourself at risk? And there may be no mental disorder there that's actually preventing them from being able to understand that. The reason that they're assessed as lacking capacity is because of that emotional dysregulation. There's a mental disorder that contributes to that, and that they're just incapable of thinking in that particular moment and weigh up risks, and that's why they're putting themselves at risk. But at the point they're not emotionally dysregulated, there's no functional disorder there that would preclude them from having capacity. So in terms of the relevant information, you do have that opportunity to talk it through with them and test whether they're able to recognize that they are likely to go through those periods, and make a plan. Make a plan. What do you want us to do in those scenarios? What do you want us to do? Do you want us to prevent you from self-harming? Do you want us to prevent you from running out on the road, or from, putting yourself, taking overdoses, those kinds of things? So there is an opportunity, and I don't think it's always straightforward to understand exactly what's relevant in any particular decision, but being able to sort of see far enough in advance as to how things are playing out, getting people when they're at their best and doing a capacity assessment, but including in that relevant information how things might pan out if they were to lack capacity, if they were to become dysregulated. Very particularly relevant for deprivation of liberty cases. Can the person understand that they may behave in a particular way, or they may fall unconscious, or they may, whatever it may be? We've had a young girl recently who was mismanaging her insulin. She had capacity, but of course there was the potential of her becoming unwell, diabetic ketoacidosis, and there was no reason why they couldn't have a conversation with her. She had capacity, and plan for these circumstances for whenever she wouldn't have capacity, whenever she is unwell and admitted to hospital with ketoacidosis. So it is important to think ahead. It is important to work out what might need to happen. What does that care plan look like? What are we going to need to do in certain situations, and having those conversations. Eliana's talk is not intended to go through all the ins and outs of how best to assess capacity or how best to document capacity. And I think there was a question in the chat earlier in the Q&A about documenting capacity assessments. What's the best way to do that? And the question is it sufficient for somebody a clinician, just to put some notes in the clinical notes about capacity assessment? Or should there be recording a capacity assessment in a proper documented capacity assessment form? Forms, capacity assessment forms, and there's lots of every health board probably has a variation of this, and we've got the proper consent 1 form for medical procedures and consent form 4, etc. They're all designed really to do 2 things. One is to guide people on how to do a capacity assessment properly, and secondly, to document that capacity assessment properly. So if you're not using a well-established form that the health board has probably gone through many hoops to sign off on as being an appropriate way of documenting capacity assessments, then there's always going to be a question over that capacity assessment as to whether the capacity assessor understood what they were supposed to do, and did they have sufficient understanding of what was required of them under the Act and the relevant information, etc. Because in most cases in the Court of Protection, one of the key issues that's in dispute is whether or not the person has capacity. And even in cases where it should be barred or obvious that the person lacks capacity, those representing P will challenge the documentation of that capacity assessment if it is not in accordance with what Ileana has talked about. If that capacity assessment doesn't set out what the relevant information is, they're going to say, well, we've got no reassurance. As I said earlier, this is a quality assurance exercise. We're reassuring people that we know what we're doing and we've done things properly. There's no reassurance there that the conversations that amounted to that capacity assessment between the assessor and the individual, if there's no transparency about what that conversation was and how information was relayed, then there's never really going to be much reassuring value in that capacity assessment. That's just a few lines in medical notes. So whilst I appreciate there's probably lots of decisions that need to be made every day for people who lack capacity, and you can't realistically be filling in these forms for every single capacity decision, there has to be a scale, and there has to be an understanding the more serious the decision, the more robust that capacity assessment needs to be, and more robust evidence of how that capacity decision was reached. Don't forget, Section 5 of the Mental Capacity Act says you have a defence of doing something to somebody who lacks capacity only if you have a reasonable belief that they lack capacity. You're only going to be able to establish you have a reasonable belief that somebody lacks capacity if you're compliant with the Mental Capacity Act, if you're compliant with the expectations of how to go about doing a capacity assessment. And part of that includes understanding, retaining, weighing the information that's relevant to the decision. So any shortcomings in the information that's relevant, if there's any shortcomings in reassurance that that information was correct and that it was actually provided properly to P, that's going to bring into question that capacity assessment, is going to put that Section 5 defence at risk. So anybody who's doing anything for somebody who lacks capacity, they need individually to be reassured that this patient lacks capacity. So I'm not going to say absolutely every capacity assessment needs to be on a properly formatted form. In my experience, if you give somebody a form with 2 lines to fill in, they'll fill in 2 lines. If you give them 2 pages, they'll still fill in 2 lines. So it's really difficult to say the way in which a capacity assessment is recorded makes a difference. I think what is more fundamental is the training and the experience of the people who are doing the capacity assessments. And I know there's a huge amount of work that is being done by the network between all the health boards, and there's probably some people here today that are involved in that, of putting together structured training for people at different levels in order to get them really to really up the MCA compliance and get really good quality capacity assessments across the board. What we do have in Legal and Risk is we have got some anonymized examples of really good capacity assessments. So whenever we're supporting people to do capacity assessments, it's always good to check in with us, have a chat through it. We can show you some examples, maybe in similar situations, we can find assessments that have been done. We had a case recently for a young person, and it was they weren't eating, and the initial capacity assessments that were done by a different hospital in England were really poor, really poor. So, but whenever the health board got involved, they were asked to do a Section 49 report on capacity assessment, and the doctor, the psychiatrist who did the capacity assessment, their report was immaculate. It was textbook, and those representing the patient and the judge, whenever they read it, just went, great, thank you. And there was no questions asked at all about capacity, because it was a reassuring report. It was reassuring that the person understood what the relevant information was. They made a particular effort for each decision that needed to be made. They set out what they considered to be the relevant information and why, and then went on to explain how that was presented to the patient, how they tested whether the person was able to understand, retain, and weigh up, and then an opinion as to why they came to their conclusion. So it was a really well structured and well thought out report that gave a lot of reassurance to anybody reading it that this person really knows what they're talking about. So that issue of capacity is done. That's it. Park that. Everyone's happy. They lack capacity. No need for second opinions, etc. And a really good capacity assessment will do that. It will have that impact of just, let's just shut the door on that and move on. And a lot of court of protection proceedings are about that. It's about shutting the door, about giving sufficient reassurance to those that represent P and to the judge that everything has been done properly and everything's been thought through properly. So we're looking to close those doors, offer that reassurance, and move on to the next issue. So we've talked about commissioning decisions. We've thought through the process. We've made a logical decision. That door is closed. These are the options we're working from. We've thought through the relevant information. We've done it comprehensively. We've provided the reassurance. We know what information we're using, and we've done the capacity assessment. Let's move on. Best interests, the same. Going through that process, ensuring we've identified all the pros and cons, reassuring people that everyone's been involved, processes have been followed, and we've arrived at the correct decision.
Right, we'll make a start, I think. And I've started the recording as well for any colleagues who may not be able to attend the session today. So my name's Hannah Watkins-Pine. I'm a senior solicitor in the COP team, specialising in a range of things, court of protection and mental capacity and mental health related as the same as the rest of the team. I'll just check if that's, there we go. That may be a little bit better. So the agenda for today, of course, it would be quite difficult to cover everything that encapsulates medical treatment decisions. But broadly speaking, the aim of the talk today is to consider what sorts of decisions can or may need to be put to the court of protection, and in particular, the clarity that may be needed in separating best interest decision making from clinical decision making. We'll also cover when to approach the legal team, when we might need to approach the court, and where we do need to approach the court, what's involved in the process of applying. And then at the end, hopefully we'll have time for a short question and answer session around medical treatment decisions specifically, before we move back then into the other room for the more general Q&A session at the end of the day. I'm hoping you can all hear me, but please shout if not. So the notes for this discussion can be found in Guidance Note 8, which is the one labelled medical and dental treatment cases. And the talk will sort of generally follow the same sort of structure and order. So if you want to sort of follow along with any case law quotes and things like that, it should follow a fairly similar pattern if you want to follow along using that. So when we approach best interest decision making for medical decisions, we always suggest that approach needs to be done in a certain way, which is that the first step is to consider what is the medical decision and the options, what options are clinically available. then moving down to whether the person has capacity to decide between those options or to choose none of those options at all. And then whether it is in their best, which of those options is in their best interests. And then lastly, considering whether an application to court might be needed, either because there's a dispute about which of those options is best for the person, or because there is something within the plan that might require you to get the authorization of the court in order to undertake it. So it needs to be approached in that sort of four-pronged approach, similar to the discussions that Gavin's had earlier, really around sort of commissioning decisions. It's about establishing those options before you move on to anything else, including the capacity assessment. So how do we establish the clinical options? The sort of key case for this is the case of Burke, which wasn't actually somebody who lacked capacity at that time, but the approach that's taken there really sort of encapsulates the approach that needs to be taken in general, which is a sort of mirror really of how you would approach consenting a capacitous patient, which is, as you'll see from the notes, that the doctor decides what the options are clinically indicated and clinically available. He then offers those treatment options to the patient, explains the risks and the benefits, the disbenefits, the side effects, what the overall plan would be for that. The patient then chooses whether they want to accept one of those options, and if so, which one they want to choose, and the doctor then provides it. If, however, the patient doesn't want to choose any of those treatment options and instead requests a different form of treatment, which the doctor is not offering, then the doctor might discuss the form of those options and other, variations of it that may be available. But ultimately, if the doctor concludes that that treatment is not clinically indicated, he's not required, i.e. he has no legal obligation to provide it to the patient, although he should offer to arrange a second opinion. And that sort of form takes the same sort of form in considering your options for a patient who is thought may lack capacity. You still need to establish what all of those options are. And one of those options may be not pursuing any particular treatment at all, but all of those things need to be on the table to then have those discussions with the person. And if they lack capacity, then follow your sort of best interest decision-making consultations as well. But it is really key to start with those options. And actually, I think in these cases, that's where we can sometimes see people kind of getting a bit tied up in knots, particularly when things sort of reach court, that actually it may be that they're sort of leading people down a path that they would never actually be willing to offer. And so having real clarity at the outset of what is or isn't on the table for that person is really important to avoid the sort of waters becoming quite muddied, and to provide really clear lines for everybody about what, in giving their opinion on best interest, what they can choose for that person. So a few sort of key things to note really is that firstly, the Court of Protection can't go behind clinical decision making and seek to put pressure on clinicians to provide something that they don't consider to be clinically appropriate. The court can only ever choose between the available options. So if no clinician will provide the treatment, then the court can't force anyone to provide that treatment. The court essentially sort of stands in the person's shoes, and so they can only choose from what that person would be able to choose if they had capacity. Being under the MCA, being under the Court of Protection, doesn't suddenly require you, doesn't suddenly provide you with options that wouldn't have been available to you if you didn't fall within the MCA. That being said, it is important that inquiries are made sort of generally as to what those options are. So it may be that inquiries need to be made outside of the health board. I suppose it's situation specific as to the reasons why a particular treatment option isn't on the table. But if that's because that can't be offered sort of locally and inquiries need to be made elsewhere as to whether that may be an option with a bit of outside thinking, that's one thing. And certainly the court can sort of probe to an extent and ask why not, or could it be facilitated somewhere else in slightly different circumstances. But what the court can't do is tell you have to do this if clinically that is something that you feel you should not do, and that it's clinically inappropriate for you to do that. So you'll see quoted within the notes the case of Envy ACCG. And the sort of key quote from that is, "It does not follow that the court is obliged to hold a hearing to resolve every dispute where it will serve no useful purpose to do so." And so what the court is really expecting, and what sort of MCA decision making expects of us, is that those options will be clear at the outset, because if there is only one option, because nobody is willing to offer the one treatment option that might be that could potentially have been offered, but actually the view is, I think a key one is things like sort of clinically assisted nutrition and hydration. If nobody is willing to offer that, then it can't be an issue that the court is considering and that you're sort of debating about, really. And so, if that's not to say that sort of all health board decisions are entirely finite, there is potentially an avenue of challenge for a judicial review, but that's not something we see huge amounts of. And typically, I think those tend to flow more from where something is declined on the basis of funding, rather than because a decision is considered to be clinically inappropriate, particularly where you've sort of followed the protocols of getting second opinions and things, and that is a universal view of the clinicians involved in the case, and perhaps an external second opinion as well, that actually that would be clinically inappropriate to provide. That then sets out the sort of parameters of the options that everybody is discussing when they move on to their capacity assessments and their best interest discussions. The only thing I would say in relation to that is being mindful to consider options in the widest sense. I have known of sort of cases before where a view was, well, that would have been a treatment option, but the best interest decision's been made that the person's at home, that's where they want to be, so we can't offer that because they would need to be in hospital for that. But actually, with the sort of removal of that sort of but for, that would be an option. And so moving them to hospital to provide that treatment would potentially be on the table. Now, it may be that nobody particularly thinks that's a good idea and it's not a hugely palatable option, but nonetheless, there's a need to look outside of just the established situation as it is now, but also whether other best interests decisions in other sort of areas, for example, around residence and care, might open up other avenues for treatment that, as in the sort of status quo of things, can't be offered at the present time. So it does need a bit of thinking about to really establish what those options are. So having established your options, you're then moving on to assessing the capacity of the person to make those decisions. My colleague Ileana's covered a lot of that in terms of the relevant information that needs to be provided in those decisions. And so this talk isn't designed to sort of cover all aspects of assessing capacity on that, but just sort of a couple of points to note really is that your sort of relevant information will largely come from your options. So having done that, those options considerations, what is then going to be relevant for the person to understand? And it's going to be the usual things that you would need a patient to understand when you are consenting them for a particular form of treatment. So what are the risks, the benefits, the disbenefits, and also considering, and again, this is somewhere that sometimes the information is not always there at the right time, which is what is exactly the whole plan from beginning to end? What is the pre and post-operative care if it's an operation? Or generally speaking, how would the person be moved to hospital to have that treatment? How long would they need to be there? When would they go again? What does the whole picture look like of that option, not just the specific risks on the day that's, for example, the surgery is undertaken, but actually looking at it in the round and what it means for the person. And that will largely give you then your relevant information. The next thing then is considering who is best placed to discuss that relevant information with the person. Now, if you've got a patient who has fairly good retention of information, it might be that you would get somebody from the surgical team, for example, or whoever it is that would be carrying out this treatment, who is best placed to describe, to explain to them what would be involved and what the risks are and the benefits and the disbenefits. It might be that they could speak to them one day, and then somebody else can consider their understanding of that the next. But actually, if you've got somebody with a fairly sort of short memory, or who may have trouble retaining that information, as we've sort of touched on earlier, it's not a test of how long people can remember these things. That information should be provided to somebody in a way that is workable and meaningful for them. And then you're considering whether they understand that information and whether they can retain it and weigh it. And in retaining it, they only need to retain it for long enough to actually be able to weigh it up. So I'm quite a big fan of joint assessments, particularly if you've got somebody where the options are quite complex, or their presentation or their sort of cognitive presentation is sort of complex, because what you may find is that you have for example, a psychiatrist who knows them incredibly well and would really understand the best way to put this information to them to avoid them becoming sort of dysregulated and give them the best chance to engage in those discussions and the best chance at being able to understand and to weigh that information. It might be that there's a speech and language therapist who's been involved, who again could assist with similar sort of lines of thinking about the best approach. And it may be that there's somebody that the person is particularly comfortable with who could get the best out of them. And that person may not be the same as the person who is going to be best placed to describe all of those risks and benefits and so on to the person, explain the plan to them. They may not all sit within the same person, probably quite unlikely that they would. So in those circumstances, it's thinking about how all of that information is going to get to the person, and then who is going to be best placed to analyse the responses and the discussions that are had there. And I'm quite a big fan of joint assessments, really, where you've got those sorts of situations, because then you can have the input of somebody there and then explaining the risks and benefits, whilst you've also got somebody who knows them well and understands sort of communication strategies with that person, who can then really consider those discussions and the person's responses to being told that information, to consider whether they have capacity to make those decisions. So really something to think about. The only other thing I wanted to touch upon, because as I say, capacity has been covered previously, is just to remember that the test is now sort of flipped. So unlike with the what's written in the Code of Practice currently, the functional test should come first. So you should be considering whether there is an inability to decide on the treatment plan, and then be thinking about whether that inability to decide comes from an impairment of the mind or brain. So the diagnostic test after that. So can they understand, retain, weigh, and communicate a decision on it? If not, is that because of an impairment, or is it because of some other factor? For example, potentially undue influence that's coming from a family member who might be pressurizing them in a certain direction. But it's important to approach it in that way. So having established then whether you consider the person has capacity, if the view is that they don't, you're then moving on to your best interest decision making. So the relevant legislation is set out within the notes. So I won't repeat it all, but just to touch on a few of the sort of key points. Section 1.5, which says that an act or a decision made under this act or on behalf of the person who lacks capacity must be done or made in their best interests. And before it's done, regard must be had to whether the purpose for which it's needed can be effectively achieved in a way that's less restrictive of their rights and freedoms. Then section 4 gives us the guidance about how we should make those best interest decisions, including considering whether it's likely that the person will at some time have capacity in relation to the matter in question, i.e., will they improve to the point that they can make the decision, and can it wait for them to do so? And then permitting and encouraging the person to participate or to improve their ability to participate, which again goes back to who is going to get the best person, who's going to get the best out of that person, and what is needed for them to be able to participate in those discussions about their care, what support they need, whether that be a translator or SALT input. How can you best help them to be a part of those discussions? Then subsection 5 covers that where the determination relates to life-sustaining treatment, he must not, in considering whether the treatment is in the best interest of the person concerned, be motivated by a desire to bring about his death. And I think that can sometimes stick a little bit and make you sort of balk in that you would hope that nobody is motivated by a desire to bring about the death. But what they mean by that wording really is that what you're considering in terms of life-sustaining treatment is is it in the best interest of this person to die, but actually, is it in the best interest of this person to continue to prolong their life using whatever treatment that might be? You know, quite often we're talking about things like nutrition and hydration. So it brings it back more to the sort of specific question, as opposed to considerations of whether of sort of bringing about the death of a person. Then subsection 6 states that we must consider the person's past and present wishes and feelings, beliefs and values that they would be likely to influence their decision, and other factors that he would be likely to consider if he were able to do so. So a few things to touch upon within that. Firstly, in relation to the person's past and present wishes and feelings, just a bit of a reminder really about sometimes thinking a little bit outside the box about who can give you that information, particularly if you've got somebody who doesn't have close family visiting, but actually do they have friends? And in a recent case that I've had, actually it was the carers who were best able to provide that information. They'd been caring for the gentleman for a really long time. He'd been in a residential home for a number of years before then a sudden deterioration in his health. And actually everyone was proceeding along the lines of, in the absence of knowing much about him, that probably he would want this treatment because that would be the recommended treatment in order to prolong his life. And actually what the carers were saying, what they were able to give quite detailed evidence on, is that isn't at all what he would want, they'd had a lot of those discussions with him just in the natural course of things, talking about the news or a newspaper, you know, and actually they'd had a lot of those kinds of conversations with him, and their view is that what was being proposed was the polar opposite to what he would want, and they were able to provide some very detailed witness evidence as to those conversations that was really helpful for the parties and ultimately then the judge to really understand what it is he might have wanted, and that was hugely influential then. So important to consider who it is that you need to consult with outside of perhaps sometimes the sort of usual sort of family members who may be able to advise. And similarly, considering the factors that individual might be considering. So, you know, certain procedures for one person that may not be a huge deal for somebody else could be really significant. You know, I think the example that we sort of tend to go back to is about a procedure that could cause some issues with movement in the hand, maybe just quite mild, you know, problems with that, which to an average person may not be a huge factor. To a concert pianist is going to be hugely important. And so really thinking about what sort of putting yourself in that person's shoes as to what would be important to them. And then coming on then to taking into account the views of anybody who's named as being consulting. And again, coming back to those points about who is best to consult. Gavin's spoken a fair bit about the sort of Section 5 MCA defence, being a defence where you're providing treatment where you reasonably believe that the person lacks capacity and that what you're doing is in their best interests. But important to just reiterate again that to be able to say that you had reason to believe those things and that it was in the person's best interests, you do need to be adhering to everything in Section 4 and consulting and all of those other steps that you need to take to be able to say that you genuinely have a reasonable belief that what you're doing is in the person's best interests. So in terms of best interest discussions, and I tend to prefer the term best interest discussions because I think there's often a lot of heavy focus on best interest meetings, which can be hugely valuable because it allows everyone to get the information all at the same time. Everyone hears everybody else's point of views. But I think on occasion, it can be difficult to find, and particularly with those very time restricted decisions, it can be difficult to get everybody together in exactly the same place at exactly the same time. And actually sort of don't rule out being able to kind of reach out to that best interest meeting as well, to have discussions with anyone who you need to. Ideally, that happens before so that they can feed in, and then you go back to them afterwards so that you can sort of feed back the outcomes of that. So again, it's more considering whether everybody has heard what everybody else has heard and understands what everybody else understands. Does everybody understand that sort of relevant information? And does everybody understand what all of this means for the person? And have they heard what other people have to say? And thinking about how that needs to be facilitated. In terms of how you'd approach the best interest meeting, you know, it's going to need to cover things like the confirmation of the diagnosis, the prognosis, history and presentation. Detailing then, as you've already identified, what are each of those available options for the person. And as you've already established, what are the factors around those decisions? What are the pros and cons? What are the risks and the benefits? But in your best interests analysis, it should be just that, really. It should be an analysis, not simply a list of pros and cons for each choice, because within that, there are going to be other factors that need to be considered. So, for example, what is the relative seriousness of each of the pros and cons? Which is how likely is each of those to occur? So, for example, a risk of death during the procedure, obviously very, very serious. But then is the likelihood of that incredibly low? And so it really needs to go into that sort of analysis of what all of those things mean for the person. How much weight do you think that should be attached to some of those pros and cons, knowing what you know about the person? What do the people that you've consulted say? How do they think you should weigh all of that? How much weight should you assign to different risks and different benefits? And then hopefully your best interest discussions then will lead to a conclusion as to the way forward and the decision on the best interest. And it's important to document that and give the reasons that includes that sort of analysis of how you've got there and how you've applied all of those sort of pros and cons in a way that isn't just sort of list heavy. If we're talking about a situation where withdrawal of treatment is one of the options that's being considered, you need to be considering what the plan would be for that withdrawal and how that would be implemented. But probably that goes to most of the things that you're discussing. What you're discussing, what is the overall plan? Because sometimes what can happen is that there's a general feeling that it would be in the best interest of the person to have this treatment, but the person is at home, and has the thought been given to how you're going to get them into hospital to get that treatment? And does looking at that plan in the whole, looking wider than just the day that you do it, or just the principle of doing it, does that actually change your overall thinking about whether that whole plan is in their best interest? Because it would mean that you go into their house and you restrain them to bring them to hospital, or because the aftercare is going to be incredibly difficult to get them to comply with, and it's going to involve a very high level of restriction to enable that aftercare to take place. So looking around just the treatment as in terms of which treatment plan is in their best interest, I think is really key, because otherwise what you can find is you sort of get down the road of having thought you were in agreement about a plan, and then when it comes to actually trying to piece it all together, it all becomes a bit unstuck because people are a bit uncomfortable with what's going to be involved. So really early thinking about the plans, whether that's a sort of planned withdrawal of treatment or a plan for treatment, what exactly is going to be encapsulated within that. And then lastly, just another thing that I would suggest from trying to record the outcomes of those best interest meetings and discussions is to note down what's agreed, but to also make a record of what's not agreed, to really establish where everybody stands on all of these things. And it's really helpful if it's a case that you need to contact legal and risk about. So, for example, clinicians think we should go in one direction, family think that we should go in another. If it's really clear about what exactly is agreed and what exactly isn't agreed, it can really help to narrow the discussions. And if you move towards mediation and things like that, it helps to kind of keep that within the parameters of what actually needs to be discussed. But also looking forward then to if it's a case that needs to go to court, there's already a very clear guide for the judge about what it is that you're asking them to adjudicate on. These are the decisions you need to make, judge. these are the things that we've all sort of settled upon, but actually it's these sticking points here. This is where there isn't agreement, and it just makes life a lot easier for judges, with a view then hopefully that it tries to keep the proceedings on track and contained to what actually needs to be looked at as well, particularly again in those sort of time pressured cases. So following on from that then to the consideration of whether a matter needs to go to court, we start first again coming back to whether this is a best interest decision that is disputed, or is it a clinical decision that's disputed. And again, that's the real importance of establishing those options first, is that you understand which of those categories that there is. I don't pretend that all decisions fit sort of very cleanly within that. I appreciate that there can be grey areas, and those are areas that we can sort of help to try to unpick. But generally speaking, if the sort of foundations of that are set, it's really helpful. There's a couple of reasons why the law in relation to these types of cases is a bit messy at the moment. One is that the code of practice is still sort of due an update, really, that would be quite helpful, and that's still a work in progress. And the other then is the recent case of GUP, which I'll come to in a moment. It's typically not been necessary to bring cases to court where the treatment can't be given, either because it's impossible or because clinicians aren't willing to do so. And the courts have made clear, as we've already discussed, that cases about best interests can't seek to put treatment options on the table which have been ruled out as inappropriate by clinicians. And there's a quote there from the case of AVS: to use a declaration of the court to twist the arm of some other clinician as yet identified to carry out these procedures, or to put pressure upon the Secretary of State to provide a hospital where procedures may be undertaken, is an abusive process of the court and should not be tolerated. And similarly, other cases have dealt with sort of similar. So there's a few quoted there within the guidance, L and another. Medical professionals cannot be required to provide treatment contrary to their professional judgment. And then going on to say, does the evidence establish that there are treatment options? If it does not, I question whether the court is entitled to assume that there are, talking there more about sort of withdrawal of treatment cases or the withholding of treatment. But there has been a more recent case, which is the case of GUP, which just slightly muddies the waters. So the facts of the case are that EUP, because the case was brought by her son, who was the G, she was a lady in her 80s with a history of strokes. She underwent stenting of the internal carotid artery, but her neurological recovery was poor and she suffered further strokes. She was discharged from ICU to a ward with an NG tube in place. The tube was displaced, removed, and then reinsertion was attempted but was impossible. Though no safe and appropriate feeding route could be secured, a gastrostomy and TPN having been discounted due to the risks with insertion, risk of skin breakdown, distress of insertion, and issues around post-insertion monitoring. The neurological picture meant that it was considered that there was no prospect of meaningful recovery or ultimately, sadly, survival. The application was brought by the lady's son, and actually in that case then the court was critical of the trust for putting in place a palliative care plan against the family's wishes and for not bringing the matter to court. The judge noted the likely reasoning behind this is that the trust considered that there's no ethical route to provide nutrition to EUP. The family disagreed and saw this as passivity with profound consequences. They perceived an important decision having been taken, even though the decision was to take no action. They considered that the court ought to be able to review that decision-making process and identify its own evaluation of where EUP's best interests lay. I agree with the family. A decision not to provide nutrition is every bit as serious as a decision to withdraw nutrition. Where there's conflict, these cases must be resolved by the court. And the judge then concluded, where there is conflict in these serious medical treatment cases, it's in everybody's best interest, but most importantly, P's, to bring an application to court. That will be most efficiently achieved where it's driven by the trust's application. There are many and obvious reasons why it's also to the trust's advantage to have their treatment plans in cases such as these scrutinised by the court. Now, general thinking on this case is that it does cause some concerns, and it does really sit at odds with those other cases that we've just mentioned and quoted there, in that it talks about bringing in application in a case when really nobody was willing to offer that clinically assisted nutrition and hydration. So in terms of that, sort of where that kind of leaves us, then I think general sort of wisdom is that there are some concerns about the applicability of this, but it does sort of still sit there as case law at the moment to be kind of considered alongside the other established cases that we've looked at as well. The first thing to consider is that within this case, what was quoted was the court's guide on serious medical treatment, and looking at whether those sorts of decisions are finely balanced and therefore an application should be made. But actually, I think the concern with this case is that actually these were probably clinical decisions ultimately, rather than needing to be considered as best interest ones. What's always difficult with reading judgments is how you've sort of quite got to that point. That judgment doesn't necessarily always give you the kind of full picture of everything that was discussed. And sometimes what you can see, I wouldn't know whether it happened in this case, but sometimes what you can see is, again, that failure to establish the options at the outset and to be very clear as to what is an established clinical option or not, actually then can muddy the waters down the way, where you're already in sort of best interest type of language before you've considered what the options are, and it can be quite hard then to sort of unmuddy those waters. So I think it's probably serves as a bit of a cautionary tale in that respect, albeit that I'm not quite sure if that's precisely what happened in this case, because it's, of course, we've only got the judgment to look at. And I think the other consideration from this is ultimately, if the judge had said that the decision that they should provide that, the court couldn't possibly choose that option in reality. And a decision doesn't stop being a clinical decision and become best interests just by virtue of the fact that the person is somebody who falls under the Mental Capacity Act, or because they have family who perhaps disagree with the clinical decisions that are being taken. But it does all come back to the establishment of those options at the outset. So what does all of this sort of mean for us really in terms of the practical applications? And do we need to consider court in these cases? So cases where there's a dispute about which of two or more options are in the person's best interests are inevitably going to be candidates for needing to go to court if they can't be resolved. But to take a case to court where the judge can only choose one option, I think sort of general wisdom is that can't really be correct. But we do await some further case law that grapples with that a little bit more. And until now, I think we're probably going to have to live in the slightly muddy waters and do the best that we can, as I say, to unmuddy those waters by being clear on the options at the outset. There will also then be some circumstances where the line between best interests and clinical decision making is a bit blurred. It's not always easy to think of sort of specific examples of that, but it may be things like disputes about whether a treatment truly is futile. That might be a good example of the kind of case that has a little bit of both mixed in there. Again, just the importance of those clear options, and actually having established that that is the limit of what would be provided, or that is the limit of the options. So things like second opinions, including getting an opinion from outside of the health board if that's appropriate. And I think, as well as being generally appropriate in a lot of circumstances to potentially resolve disputes, they also clarify whether the decision that's being taken is a sort of universal clinical decision, that is not something that clinicians in general will provide, as opposed to a best interest decision being taken by one clinician, or those who are sort of most directly involved, making a sort of call about those best interests. So in short, is the consensus that the option is off the table, such that it's not an option that anyone can choose? Also then consider whether this is a circumstance that you need to take legal advice, and probably there's a little bit of extra caution needed following that case of EUP, albeit that, as I say, the sort of jury is still out on whether it is sort of good law, because it sort of sits next to all these other cases that really don't agree with it. And And there's always the option of considering seeking declarations of lawfulness from the court. So essentially sort of rubber stamping the approval of the way forward where there are concerns about whether what you would want to be doing falls within the sort of parameters of lawfulness. And we'll come on in a minute to the court's guidance about which cases might fall within those categories of being sort of sufficiently uncomfortable for clinicians that they should be going to the court to consider. So we'll come to that in a moment. I'd also suggest that this is the sort of case where these are the sorts of cases where medical mediation can be a really useful tool where the time allows it. So potentially looking at having those mediation sessions where you have somebody to support in the discussion of those established options. And actually the sort of courts in a lot of medical treatment cases now really sort of urge consideration of mediation in the first instance where the time allows. But what we do take away from the case that I just mentioned of GUP, and one comment that was made by the judge in that is that because the family had been so adverse to the way forward suggested by the clinicians, and because they very much wanted hydration and nutrition to continue, a compromise essentially had been reached whereby the health board continued to provide that, the hydration at least. And actually, when you sort of dug into the evidence on it, everybody was actually uncomfortable and didn't feel that they should be doing that. But it had been done as a compromise, really, to sort of help relations with the family and give them something towards what they wanted. But actually, what this case tells us is that that's not what we should be doing. The quote from the judge is that the treatment plan has an air of compromise about it, a negotiation between the family and the medical team. There may sometimes be a place for that, but not if the person at the centre of it becomes marginalised. P, the protected party, must always be afforded care which is identifiably in her own best interests. The family's views are relevant only insofar as they provide a conduit for P's own wishes and feelings. Families, however loving and well-meaning, gain no dominion over their dying and incapacitous relatives. Family's role, which is crucial, is to promote and not subvert P's autonomy. So just a helpful bit of guidance there from the judge about about the approach that should be taken to compromise, which is cautiously. If you feel that you shouldn't be doing something, that is the clinical view, then just sort of bending to the will of the family will often not be appropriate where that's not in the person's best interests. So we move then to consideration of whether these matters need to go to court. And I mentioned earlier that the court has set out its own guidance as to what should go in that. There is the Serious Medical Treatment Guidance 2020, which is hyperlinked in the notes. And this is applicable for serious medical treatment decisions. I emphasize the serious because, again, I've had a few cases recently where people are referring to this. And actually, I would query whether the treatment that we're talking about is serious. Serious is given a sort of fairly ordinary meaning, really, within the legislation. And so it is going to be things that have an impact on the person in the sort of longer term or a sort of serious impact in the short term. So possibly, things like life sustaining, but also things that might interfere with sort of reproductive rights and things like that. There's more sort of detailed guidance within that guidance note. It is non-binding, but it sets out the best practice. And certainly when you come to court, you'll hear all of the barristers referring to it and the judge referring to it. So I think we would deviate from that at our peril, really. It's a pretty fair guide, and it really it's echoed then in a lot of the case law that's followed as well. So it's fairly sort of established as your starting point for thinking about whether you need to go to court. And the key questions that come from that are, is the best interest decision finally balanced? Is there a difference of medical opinion? Is there disagreement on best interest between those with a right to be consulted? And is there a potential conflict of interests? If the answer to any of those is yes, then it's probable that an application is needed, or at least must be considered. If the answer to any of those is yes, and the decision relates to life-sustaining treatment, then an application must be made. This specifically includes the withdrawal or withholding of clinically assisted nutrition and hydration. And it's worth considering then that as part of these decisions, you're also considering whether there are things that you need the court to declare as being a lawful way forward. Those are often so situation specific that it's quite hard to generalise, but the court does have powers to make declarations that an act that's either done or is about to be done or is going to be done that relates to the person, and to declare that as being a sort of lawful way forward. And so they can rule on the lawfulness of a plan to withdraw or withhold life-sustaining treatment. So, as I say, the sort of circumstances in which you need to do that are very sort of fact-specific, but it's where what you are trying to do is going to need to go outside of what your DoLs standard authorization would essentially let you do within that. So if you contact us about a case which is going to need to go to court, what's going to be needed? Firstly, clarity of what we're actually asking the court to do. What is the dispute, or what do you want the judge to sign off as lawful? So this comes back then to your best interest discussions. What are the agreed things and what are the disagreed things too? Because it's those disagreed things that you will want the court to make a decision on. And similarly, if you're talking about wanting the court to declare that you would be lawful in pursuing a particular option, what exactly is the plan? Because that's how the courts will authorize these, is in direct consideration of and direct reference to a plan. The judge will say, this plan dated this that I have seen, that is what you can do. And anything above that, you would need to go back to court again. So it needs real careful thought at a very early stage, really, because it's going to be what you're putting into the court to say, we want to do this. Please, can you make an order to say that that's a lawful way to proceed? And it's not wasted time, because you would need to do that plan anyway. Those plans should be done anyway. And really, what that then provides is the sort of ceiling of actions that you're taking, that you're asking the court to authorize, or ceiling of restriction that you'll be doing. So what you can do within those plans is have a sort of plan A and a plan B and a plan C, and that's absolutely fine. It needs to just be clear what would move you from plan A, which might be sort of least restrictive, that you would attempt to persuade the person to have this surgery, for example, and you might give them a sort of low dose of sedative that would help to relax them, and hopefully you'd be able to proceed with that. Your plan B, if they wouldn't let you do that, is that you are going to do, and then whatever sort of plan B is. So you can stage it in that way. It just needs to be clear what would be the sort of triggers that would move you to try plan B instead. Is this going to be one try of A and then you move on, or are you going to try A again on a different day? But it's just helpful if that plan kind of encapsulates everything that you think, with sort of reasonable amount of foresight, you might need to do. That's going to be really, really vital. The other thing that we need in order to proceed with an application to the court is for those MCA processes that we've discussed to have already been followed. So establishing the options, assessing capacity, having those best interest discussions. And actually all of those steps need to be taken before you're in a position to go to court, because otherwise the judge will be saying, where's your capacity evidence? What are the options? What does everyone think about this? What are the best interest discussions? Have you had a second opinion? So they're only things that you're going to have to do within proceedings anyway. And actually, it's quite hard to even get over the line to get your application in without those things. The very, very urgent cases, I think the courts are very appreciative of the fact that may all have to just be done a bit on the hop. Those real sort of same day urgency type cases. The courts appreciate that you're just going to have to put in the best evidence that you can on that in a short space of time, but you do still need to have something that sets out those things. And actually, in cases where you've got a bit more time, those should be sufficiently detailed as to comply with the Mental Capacity Act. So hopefully by the time you're going to court, you're well set up to go through the proceedings, really, and you can really sort of front load your application with all the information that the judge needs, so that really all you're waiting on is for the representatives for the person to then consider it and ask any questions they might have. The other things we need to put in then are the court application forms. You'll be pleased to hear that we prepare those, But what we do need is things like names and contact details of family, GP, the IMCA, the IMHA. So there'll be information that we need for those. The other thing that needs to be put in is where the application is going to the Court of Protection, a COP3 form, which will accompany the capacity assessment. Now, perfectly fine for that capacity assessment to be done just on a separate document, and then on your form you can just say, please see attached, please see attached. But what it does need to cover is whether that person can litigate the proceedings. Are they able to instruct solicitors to represent them on this matter? Now, general case law says that it would be a very unusual circumstance where somebody could lack capacity to make the decision about that the court is being asked to make, but has capacity then to instruct their solicitors all about it. That's quite unusual. But you do have to address that about whether that person could instruct solicitors, because then what will happen is we go to court and somebody is appointed on their behalf to represent them. And we can provide guidance on all of these things about, because litigation capacity assessment, probably not something that you're doing every day. So we've got plenty of guidance that we can provide about how you'd need to approach that. And we've talked already a bit about how to sort of get the best out of the patient and evidence that for the purposes of evidencing then that you've made sufficient efforts to help them to engage with the capacity assessment. Then the other thing that we'll need is that best interest evidence. And again, if that best interest analysis that you've done as part of your best interest discussions is good, then that's 90% of the work really, because you've got that set out. If it hasn't got that sort of analytical element to it, that needs to be done as well. And that can be done either in a witness statement or from the minutes of those discussions. But that will need to be in there as well to explain to the court why it is that the health board's position is you should do such and such a step, and really make that clear for the judge. The next thing that we'll need then is medical evidence. So written statements from key clinicians, copies of the scans, records. As Gavin's already mentioned earlier, important to note that we don't have access to any health board record systems. So if you haven't sent it to us, we can't see it, we haven't got it. So there will need to be somebody that sends us all of these things, particularly the information about diagnosis, prognosis, what the current position is and what the proposed care plan is. Evidence of second opinions as well. Then also within the evidence, we'll need to note what the views of the person are. So potentially if there's been an IMCA report, and with the really sort of serious medical treatment cases, you should be looking at an IMCA involvement for them, particularly where the person doesn't have family, but really considering whether that's something that you need in those cases. But some evidence of consultation with the family and with the person so that their views are also reflected in the application. It might be that they would want to put forward their own, as more information as well, but you should at least be covering the basis of what it is that they think and why they think that and what contribution they've made to those discussions, so that that's all fairly reflected. Then the views of anybody else. The other thing that we'll need to make the application is authorization of things like court fees. So there needs to be somebody with the authority to sign those sorts of things off. And also with the sort of serious medical treatment cases, there is a sort of precedent that the official solicitor will act for the person, and that they will usually expect that authority is given to pay 50% of their costs. That is the sort of established practice now, that the person or the body making the application would cover 50% of their fees. So they will be asking for that before they'll act. And actually a delay in getting them on board can really mean a delay in getting a decision from the judge. So it's important that all those things are sort of ready to go at the point of the application. As to when to approach us, we can help on a sort of myriad of things, but the sort of most likely candidates are going to be disputes about best interests in relation to sort of serious medical treatment, and how quickly you should contact us is sort of situation specific, which I appreciate isn't always a helpful term, but it should be brought as urgently. The guidance is that it should be brought as urgently as the circumstances require. It's worth bearing in mind that it's not just about getting the application to courts, but it's the time that's needed to go through all of those proceedings. And so you do have to sort of allow time for example, the person to get representation. They may need to get legal aid. That person representing them will probably want to go and see them. They will then need to read the papers. They may have some questions. They might want an expert report. They might feel that there's further things that need to be explored. And so it's worth bearing in mind that that can take time, and also about the availability of a judge, a senior judge, to hear these kind of matters. Where the courts are excellent actually is on the very, very urgent cases, where often, you know, it's sort of same day treatment, and often you can get before a judge within potentially a few hours. And if you've got everything lined up ready for them to so that they can immediately see the situation, and they can, you know, someone on the phone who can, clinicians that can explain to them, you can potentially get decisions quite quickly from there. Where it can be a bit more difficult is with the sort of quite urgent decisions. And so that call about when to make the application can be tricky, but sort of general wisdom is the earlier the better, because the courts are very critical where there's delays, which brings with it then a risk of adverse publicity, costs orders. We're seeing an increase now of sort of bloggers and journalists attending these cases and then doing a write-up after. And whilst they will, in most circumstances, need to keep the person's details anonymised, it would be very unusual for them to have to keep the name of the public bodies anonymised, and actually often clinicians too. So it is really important that we're thinking about trying to avoid those sorts of adverse publicity, and also for the patient too. There can be huge disadvantages in delaying and bringing these things to court. So that does need to be done as early as is appropriate, but we need all of that sort of information in place to make the applications, really. So if it's one that you think legal probably needs to be involved in, earlier is usually better, even if it's not quite at the stage where you feel you've exhausted all avenues of sort of discussion yet. But actually we can help to shape the paperwork that you're doing along the way, and sort of preparing it as though you might need to go to court. And if you find that you don't, great, because what you then have is very good and clear documentation evidencing your compliance with the Mental Capacity Act and the lawfulness in how you proceeded. And then if that's required, for example, at an inquest, there it all is, ready bundled up, clearly showing how you've complied with the IMCA in coming to the conclusions that you have and in proceeding the way that you have. So it's never sort of wasted time, you know, to be getting all of these things together, and that's something that we can help with. And then if we need to go to court, we can act quickly. If we don't, then lovely, that's great. But you've got your paperwork then, should you need it, to refer back to an evidence compliance. A question we're asked quite a lot is about how quickly the court will hear an application. For incredibly urgent matters, as I've said, sometimes we can have a judge on the phone within hours. They do also have an out of hours service, and weekends and nights. But I would really stress that these are for the most serious, the very imminent risk of serious harm or death, those types of cases. No judge is going to thank you for phoning them at midnight on a Friday night about something that you could have approached them with at 9 a.m. So they will look back at why it is only coming to them at that point. Sometimes that is unavoidable. I've had cases that have been heard late into the evening and into the night, just by virtue of the urgency with which they presented, or because somebody's had a change of opinion, if a parent has withdrawn their consent, or those kind of things that were unforeseen, and suddenly you need an adjudication on it, pretty much immediately. But again, you do have to have at least something to show the judge and tell the judge. You have to have an aim for what you want them to do. It's not enough to just sort of say, we've got this really tricky situation. Actually, you're asking them to do something, to approve something. You're suggesting a way forward and asking them to approve that. Or you're putting a decision to them and saying what your position is. So that's the thing that has to be really, really clear. But where they need to, they can be hugely quick. So I've had a case that I think we put the application in working on it the evening before, put it in at 9 a.m. The court issued it, which means they sort of accepted the application at 10:30, and we were in front of a judge by 2 p.m. on the same day. And actually, we probably could have had an earlier slot, but we needed a bit of time to get the family together and get them available for a hearing too. But as I say, those are the very, very urgent cases. What can sometimes be a bit tricky is the sort of quite urgent cases. And it's something that's come up recently at sort of court user meetings, is about so I think it's a commonly established difficulty really about those sort of, we need a decision within the week or within a couple of weeks. That can be quite tricky, but they are trying to put in place processes to make that a bit better. And actually, again, it just emphasises that really the sooner the better that you bring these cases to the judge's attention and to the court's attention, because then we can always push for a hearing if we need one earlier. But at least you've sort of got through the door. Some of the common blocks to us being able to get a case to court quickly is things like no capacity evidence, or very poor capacity evidence that we know will be sort of pulled apart the moment that we make the application, where there haven't been the best interest discussions taking place yet, or there have been, but they haven't been documented, or they're not documented well. The absence perhaps of that sort of analysis, as I've said, of the sort of pros and cons. Cases where the person's views haven't been represented, so they haven't consulted with a family member or an IMCA, someone that can represent the patient in all of that. Things like delays with witness statements, treatment plans, and the plan can be a really tricky one because often it does involve, depending perhaps where the person is, but it can involve multiple teams across multiple organisations, potentially transport or arrangements and things like that. And so, as I say, the earlier that you start on these plans, actually it should be forming part of your sort of options and best interest discussions before you're getting to the point of needing to go to court for an approval of a finalised version. So the sort of early starting of those can be really helpful. And then occasionally delays can be caused where there's a sort of lack of a final position from the health board as a whole. For example, you have a clinical team who feel that one way is the best way forward, or another clinical team who feel another way is, which isn't to say that you couldn't then put that to the court, but it does just become a bit difficult as to what the health board is saying. And so that is where really you're likely to need the involvement of sort of very senior management to consider what the overall position and what the overall request made of the court should be. A few sort of tips to end on then about avoiding or trying to avoid litigation in serious medical treatment cases, because I think that's always our starting point as a team, actually, is whether there is a way to resolve these things without going to court, because it's hugely expensive, it's time consuming or can be time consuming, and actually in some circumstances it can cause kind of ill feeling and make things quite difficult for ongoing work with the family or with the patient. So considering other ways to avoid kind of getting to that point, really, where that can be avoided. So things like advanced care planning. Gavin touched on earlier about fluctuating capacity, or where somebody has perhaps a progressive illness where you know they will come to the point where they lose capacity, or they have an acute problem that is going to result in them losing consciousness. But whilst they have capacity and they can tell you what to do, plan it all out, because then what you don't have is a situation where you've not treated them because that was in line with their capacities, wishes and feelings. Then they lose capacity, and then you kind of think, oh, what do we do now? Because we were not treating them, but now that they've lost capacity, are we now going to start, even though we know their view was not to, but now their view is only one element of our best interest decision making. So rather than sort of come to that point, if they've got capacity and they can be involved in that care planning to make those sort of onward decisions, do that ideally. It's not going to work in every case, but for those types of scenarios, that's really, really helpful. The other thing then is looking at where your second or your sort of maybe third opinion would come from, and considering whether it's appropriate for the family to be involved in the obtaining of a further opinion from somewhere. I think often there can be within court, but also probably within sort of healthcare settings, a sort of perception of a power imbalance and a view that patients might have of sort of, well, you doctors, you'll all club together and you'll all say the same thing, back each other up. Yes, they're from a different health board, but I bet you know them and they'll just say what you say. But actually sort of empowering them to be a part of choosing somebody, obviously somebody appropriate, but you know, you can perhaps give them a few options of people and suggest that they are part of what questions, you know, are going to be asked of that person. Can this independent second opinion speak to them too? Can they be a part of it all? And sometimes that can help to just take the heat out of things and address that sort of perceived power imbalance, to help to sort of just take some of the heat out of things, and for everybody to feel a little bit more heard. On a similar vein, I've already mentioned about mediation, but again, that sort of that need for people to feel heard, and mediation just provides a bit of a structure for that, sort of led by an independent person. And there's some good mediators around now who can firstly cut to the heart of the issues. There's also some mediators who are either established medical law practitioners or some who are themselves clinicians. So there are people with that sort of medical expertise as well who can kind of lend themselves to mediation. The other thing that potentially can help is about having direct communication for families where there are other teams involved. So again, avoiding that sort of perception of, well, you're all in it together, that if you've had a report from the surgical team and the surgical team have said not a candidate for surgery, can that be, or is it better for that to be conveyed directly to the family so that they can ask those questions directly of the team who are perhaps saying no, rather than that all coming from one team, and it seems like that's all just being sort of led by a path that people may feel the sort of clinicians have set upon. And actually to understand and be able to ask those questions of the person who's taking that decision to say no can be really helpful. And similarly, considering about openness with the documentation that you have. If the person lacks capacity, is it in their best interest to share the information, the documentation that you have with the family? It's probably quite likely to often be appropriate because it's part of the relevant information to making that decision. So in consulting with the family, are you sharing what you have and what you know and the reports that you have? It might be that they need those explained. I'm not saying, but in general terms, considering whether there are documents that can be shared, again, to avoid any feelings that things are a bit secretive or one-sided, which isn't to suggest that they are, but I think those can be quite common perceptions. And then lastly, considering whether the involvement of an IMCA would be helpful, firstly to advocate for the person, but also as a sort of extra voice in amongst all of this. And because it may well be that the family are very sort of heavily involved in it and have their own feelings about it, the IMCA is potentially slightly more neutral and might be able to advocate, or may feel that they should advocate a little bit differently. So that's another helpful point for consideration as well. So that brings me to the end of the discussion. We've got about 10 minutes before we're due back in the other room for sort of general questions and answers. But I just wondered if there's any questions in relation to sort of medical treatment cases, particularly, that I might be able to answer now. And if we don't get to them all, I can sort of take them through. Rachel?
I'm happy to go last. It's an observation, really.
No, please do.
Just to say, obviously, I'm from Hywel, and if you're in Hywel, please give us time. If you've got an application, although the court does try to hear things as an emergency, it's like ED. Sometimes it's really busy, sometimes it's not, but they will see you as soon as they can. And there is a lot of work to be done. So although, like Hannah was saying, legal and risk, they go really, really quick. Perhaps I go a little slower, but it does take time. It's not instant. It's not like the doctor can say, just take this to court, we can get it there instantly. So that would be my observation. In line with the case that you were referring to, we actually had a meeting about it with the IMCA capacity consent group as to how, as a health board, we were going to approach medical decision making in light of that decision. Because it does say you should be making applications more often, and we just didn't feel that that was sustainable. You had to take things individually.
Yeah.
Rachel, I think in our experience, the courts necessarily will say, please bring applications at the earliest opportunity, because there's procedural issues once you go to court. P needs to be represented. There's very sort of legal rights and obligations on everybody involved that need to be followed, and they necessarily take time. And to get a court order, I always say, I could phone a judge now. What are you going to tell them? There's various hoops that we have to go through. How can you justify them making a decision today, and what evidence are you going to give? So in our experience, whilst we recognize that there's a need to go to court at the earliest opportunity, actually, I'd say in well over 95% of the issues that come to us don't end up in court, because actually some advice and support around good MCA compliance usually results in agreement as to what needs to be done. And then there's only a limited circumstances, as Hannah, I'm sure, has covered, where you have to go to court even if you are agreed. But even when withdrawing treatment from somebody that's going to result in their death, that doesn't need to go to court if that's agreed. If it's not finally balanced, if there's no dispute, that doesn't need to go to court. So there is really only a fairly narrow number of cases, types of cases that actually have to go to court. And by really focusing in on the issues and working collaboratively and really getting that good MCA compliance, getting your capacity assessments really good, really identifying the options and justifying the options that are on the table, like we've talked about today, and really getting that best interest consultation done and evidence properly. As long as there's good, logical, reasonable thinking throughout the entire process, usually you don't have to go to court. The urgency comes through quite often lack of clinical time to actually think through all this stuff. They're really busy people, everyone's really busy, and to carve out significant time of your day to deal with a complex factual scenario is really quite difficult. And that's where the likes of us in Legal Risk and Rachel and Helva, that's what we can do. We can support with that. We can help with a lot of the thinking. We can help with the communication. I had a case years ago. I went down to an ITU in a hospital, and it was an urgent situation. And actually, by the end of the day, all I had done was facilitate communication between, I think it was 7 different consultants who, they're not realistically ever going to be in hospital at the same time. And this was a Sunday as well. So we've got 7 different disciplines all needing to communicate their information and get it comprehensively discussed and facilitate that discussion, that best interest decision. So all I did was help facilitate that. I wasn't making a decision. There wasn't really that much law involved. And at the end of that, they were comfortable that they were going to meet the next morning and were able to make a decision. And part of that process, I identified that some of the information that they were working off was incorrect. So it was factually incorrect information, and correcting that made a big difference to the options that they were considering, or it certainly made a big difference to the risk attached to some of those options. So that support to be able to help clinicians find the time to have those types of discussions is usually really, really helpful. And the number of applications that do need to be made are fairly limited. But when they do happen, there's usually a hell of a lot of work that needs to be done. And clinicians, and it's not something that lawyers can do. It's the clinicians that need to do it. They need to write their witness statements. They need to come up with clinical options. They need to do the capacity assessments. We can support that, but we can't write the witness statements for them. So it does need to be a team effort to get it across the line.
Yep, absolutely. Steve, I think you're next.
Hi, thanks for let me put this to you. I don't really want to obviously I can't discuss the individual case, so just the general principles. This gentleman with the hernia that I wrote about in the chat, it's taken a long time to arrive at the point where we feel that on balance he doesn't have sorry, he does have capacity. For a long time, I just had a gut feeling that he didn't have capacity, but couldn't get any evidence because he wouldn't engage with assessments. We finally managed to get him to engage to a degree, and we feel that on balance, he does have capacity now. So my question really is, my original plan was to have even if we could show that he lacked capacity, I wasn't going to sort of recommend that he goes to hospital, against his will, because that would be really traumatic for him. And it's not, at this point, it's not a serious enough, it's not life-threatening. Often when people go to surgeons say, yes, we can do an operation, but the other option is watchful waiting. So if he had capacity, which we now think he does, that would be his choice. He could say, well, I don't want anything done. I'll live with it, and it would only become a problem when if he started to get any pain, then he would obviously go and seek treatment. But my concern is that even if he gets pain, he won't seek treatment, and it will need to get really serious before, he would then submit to surgery, and he might not do that at all. And I wanted to put a plan together.
Steve, yeah, I've got some thoughts on that, and you know what? I think it'd be really good if I bring that back into the main room.
Yeah.
Because I suspect this is going to cross over between, I'm not sure what exactly your role is, but I think it's a really good example of how there needs to be collaboration between different people, and really clear thinking about the relevant information for capacity assessment and how that might change over time. And if you arrive at a point where that we just, he's got capacity, then what do you do if somebody does have capacity? And then it becomes support, and you really focus on the efforts in supporting the individual as opposed to. So I'm going to bring that back into the main room, if that's okay. Because it's a really good one to sort of base a lot of the discussion. So it touches on a lot of the key areas we've dealt with today.
Yeah, and I think there's quite a lot of cases coming in now as well about sort of self-neglect at home, and there's probably a lot of crossover there as well. It's 10:02 now, so we're due back in the main room. Sarah, if that's okay with you, if we could also take your question in the main room as well, and then again everyone can have the benefit of hearing the answers. All right, so we'll see you all back in the main room in a moment.
COP 11 is 31 pages long. And within it, there are annexes to be completed to evidence consultation with P and those interested in P's welfare. But there's a lot of evidence required to support a RE-X application. Medical evidence of unsound mind, which has to be dated within the last 12 months. Evidence that P lacks the capacity to consent to the care arrangements on Form COP 3. A statement confirming why it's said that the care arrangements are necessary and proportionate in P's best interest. Also P's care plans. And the relevant practice direction says, to bring proceedings, the applicant must file an application form COP 11, verified by a statement of truth and accompanied by all attachments and evidence required by that form and its annexes. The application form and accompanying annexes and attachments are specifically designed to ensure that the applicant provides the court with essential information and evidence as to the proposed measures, on the basis of which the court may adjudicate as to the appropriateness of authorising a deprivation of liberty, and in particular, identify whether a case is suitable for consideration without an oral hearing. The use of the form and its annexes is mandatory, and they must be provided fully completed and verified by the required statements of truth. So it is a lot to do, but it's not optional, it's mandatory. And without a sufficiently evidenced application and proper supporting documentation, the court will simply return the application or alternatively list the matter for a hearing. The streamlined procedure is not appropriate in every case. There are triggers that would indicate to the court that the application is not suitable for the streamlined procedure, and which would result in an oral hearing being listed. P being added as a party to the proceedings and a litigation friend needing to be appointed. So those triggers include a contest to any part of the application, failure to comply with the requirements to consult with P and with those interested in P's welfare, or any concerns the judge may have arising out of any of the evidence that's been filed. What I want to do now is explore a bit further the process of identifying where there is a deprivation of liberty. So the acid test confirms that where P lacks capacity to consent to their care and where they are under continuous supervision and control and not free to leave, then they're deprived of their liberty. What is continuous supervision and control? In the case of Stanov v Bulgaria, Mr. Stanov was able to leave the building where he resided and go to the nearest village, and indeed he'd been encouraged to work in the restaurant in the village where his care home was located to the best of his abilities, and he'd also been on leaves of absence. However, he needed to have permission to leave the care home, and his visits outside were subject to controls and restrictions. His leaves of absence were entirely at the discretion of the home's management, who kept his identity papers and administered his finances. When he did not return from a leave of absence, the home asked the police to search for him and return him, and he was returned to the home against his wishes. He was in consequence, the European courts held, under constant supervision and was not free to leave the home whenever he wished, and he was therefore deprived of his liberty. A pragmatic way of answering the question of whether P is under continuous supervision and control is to ask whether the public body responsible for the individual has a plan in place, which means that they always broadly know where that individual is and what they're doing at any one time. If the answer to both questions is yes, then there's a strong pointer that the individual is under continuous supervision and control. What is then freedom to leave? It's vitally important not to conflate freedom to leave with ability to leave or attempts to leave. The focus should be upon the actions or the potential actions of those around the individual rather than on the individual themselves. The question may well be a hypothetical one, but if the person manifested a desire to leave or a family member or someone else properly interested in their case sought to assist them to leave, what would happen? If the answer is that steps would be taken to prevent them from leaving, then this points to P not being free to leave. And crucially, it doesn't matter if the steps to prevent P from leaving are said to be in their best interests, because best interest does not stop the potential for a deprivation of liberty. I wanted to talk a bit about the Law Society guidance. So the Law Society has produced guidance, the purpose of which is to provide practical assistance in identifying whether P is or may be deprived of their liberty, which can then enable practitioners to ensure that the appropriate steps can be taken to secure P's rights under Article 5. So the first step being identifying the deprivation of liberty. Now, while the guidance can be seen as an informal update to the statutory DoLs code, guidance which has been approved by Parliament, the Law Society guidance doesn't have a statutory basis, and professionals therefore do not need to have regard to it in the same way as they do the DoLs code. But it's helpful to assist those who need to be able to weigh whether an individual they're concerned with may be deprived of their liberty in order for them to be able to take the appropriate action. So the Law Society's guidance applies legal frameworks to different settings, including supported living, shared lives, extra care placements, and the family home. For each setting, a list of potentially liberty restricting factors are given that may indicate that a deprivation of liberty is occurring. Scenarios are also given which illustrate a deprivation of liberty, a potential deprivation of liberty, and a situation unlikely to amount to a deprivation of liberty. I find the guidance helpful as each chapter concludes with a list of questions that professionals can ask themselves whenever they're confronted with a situation which may amount to a deprivation of liberty. And that guidance can be found on the Law Society website, and I can share the link in the chat. So I wanted just to spend a few minutes looking at the potentially liberty restricting factors and the scenarios provided in respect of some of the community settings. Okay, so considering supported living, the Law Society provides a long list of potentially liberty restricting measures, which include, in a supported living setting, decision on where to live being taken by others, decision on contact with others not being taken by the individual, doors of the property locked, access to the community being limited by staff availability, a member or members of staff accompanying a resident to access the community and meet their care needs, any mechanical restraints such as wheelchairs with a lap strap or harness, reinforced glass in mobility vehicles, protective helmets, varying levels of staffing and frequency of observation by staff, restricted access to finance, with money being controlled by staff or welfare benefits appointee, restricted access to personal items to prevent harm, chemical restraints such as medication with a sedative or tranquilizing effect, physical restraints or interventions such as with personal tasks, breakaway or block techniques, distraction methods, staff withdrawing, physical touches or holds, positive behavioural reward systems to reward good behaviour, and lack of flexibility in terms of having activities timetables, set meal times, expected sleep times. So that guidance goes on to provide a scenario which the writers suggest is likely to amount to a deprivation of liberty. So I'll just go through that. So Gordon's 30 years old and has autism, cerebral palsy, hearing and visual impairments, and a learning disability. He resides in a one-bedroom flat with one-to-one staffing at all times. He requires a second member of staff to access the community, who's available 35 hours per week. The front door is locked for his safety. He cannot weight bear and pulls himself around inside and requires a wheelchair outside. Due to a history of attempting to grab members of the public, a harness is used to strap his torso to the wheelchair, allowing free movement of his arms. And the guidance suggests the key factors there pointing to a deprivation of liberty is that Gordon's under continuous supervision and control and on a one-to-one basis at all times. Another scenario was given, which the writers say may give rise to a deprivation of liberty. Max is 24 years old and has a mild learning disability and lives with two other residents who receive 24-hour shared staff support. Owing to his agitation and anxiety, Matt is prescribed medication with a calming effect. He is employed from 9 a.m. to 4 p.m. 5 days per week in the local garden centre, which he's able to get to and from independently. He has a tenancy for his bedroom and can call upon staff members for assistance in the morning and evening if he requires it. If he wishes to see his family at weekends, a member of staff will take him and be there throughout the contact session owing to previous incidents of aggression from his brother. And the Law Society says in that scenario, the key factors pointing to a potential deprivation of liberty are the extent of the supervision and control inherent in the support provided to Max at the placement, and suggests that a careful assessment would be required of whether he's free to leave in circumstances where he can come and go to the garden centre. And the guidance goes on to suggest it's important to consider the steps that would be taken if he did not return. There's another scenario provided in which it's said the circumstances are unlikely to amount to a deprivation of liberty. So John, aged 42, was badly assaulted during a night out and sustained an acquired brain injury. The frontal lobe damage makes processing information difficult, and he's had some left-sided weakness or mobility issues. He lives in a flat and twice a day receives 2-hour visits from support workers. He can dress and wash himself, but they prompt him with medication, take him to the shops and support him to pay bills. He chooses how to spend the remainder of his day. Often he attends day services without the need for support, and sometimes he meets with friends in the local pub. So the factors pointing away from a deprivation of liberty in that scenario are the limited nature of the control and supervision to which John is subject, and the limited nature of the restrictions placed upon his ability to come and go from his flat as he pleases. Just wanted to have a look at similar liberty restricting measures and some scenarios in relation, just bear with me a second, in relation to the home environment. So the Law Society's guidance suggests the following features may constitute liberty-restricting measures in the home environment. The prescription and administration of medication to control the individual's behaviour, including on a PRN basis, the provision of physical support with a majority of aspects of daily living, especially where that support is provided according to a timetable set not by the individual but by others. The use of real-time monitoring within the home environment, for example, CCTV or other assistive technology. The regular use of restraint by family members and professional carers. The door being locked, and where the individual does not have the key and is unable to come and go as they please, that will strongly suggest they're not free to leave. The individual regularly being locked in their room or another area of the house to prevent them moving freely around the house, and the use of medications to sedate or manage behaviour, including PRN. So again, there are some scenarios, and the measures in the following scenario, the Law Society suggests, are likely to amount to a deprivation of liberty. So Veronica is a widow of 75. She has a history of mental illness going back to her 30s. A current diagnosis of schizoaffective disorder. She has a number of admissions to hospital under the Mental Health Act. She's not been in hospital for some years, but sees a psychiatrist fairly regularly and attends regular 117 aftercare reviews. More recently, Veronica's been showing signs of short memory loss. She lives alone in the home she shared with her husband. She's very independent, but recently her daughter has become concerned that Veronica's leaving pans on the stove unattended and is becoming erratic in compliance with the medication, and she's visibly lost weight. Veronica's psychiatrist is also concerned, and Veronica agrees to an informal admission to allow her psychiatrist to assess her. During her stay, Veronica has an activities of daily living assessment and is noted to be unsafe in the kitchen. An MRI scan suggests some damage. Veronica's psychiatrist assesses her capacity and reaches the conclusion that Veronica lacks capacity to make decisions around her care need, mainly because she's unable to recognise that her ability to look after herself is impaired. The clinical team consider that Veronica needs 24-hour care, and the question is where should be provided. A Section 117 meeting takes place, and Veronica attends the meeting and pleads not to go to a care home. The Health Board and local authority agree to fund 24-hour care in Veronica's home for a trial period. A care provider is sourced when Veronica goes home. Her care plan is that she'll have one carer at home at all times. A spare room is made available for the carer, as it's not considered that waking nights are required. The agency will have access to a key safe and will be able to enter Veronica's home even if she doesn't want them to come in. Veronica will be supervised in the kitchen. She will be supported by the carer in arranging to go out when she wants to, which will include family visits, shopping and visits to galleries and museums, which she likes, but the carer will dissuade her from leaving unaccompanied. The psychiatrist specifies that Veronica must attend a day centre where she's well known at least once a week to facilitate ongoing monitoring of her mental state. And the key factors there pointing to a deprivation, so say the Law Society, are the continuous presence of the carer in the home 24/7, and Veronica never being left by those carers, the supervision of activities while in the home, and that Veronica's not able to come and go unaccompanied. There is another scenario that may give rise to a deprivation of liberty in the home. So Gordon's 80 years old with early onset dementia. He lives in his own home and is believed to have now lost the mental capacity to make decisions as to residence and care. His care package provides for carers to attend 4 hours a day with personal care, cooking and cleaning tasks. He has door sensors to alert his family when he leaves the property both day and night, and is required to wear an alarm device at all times for his safety. Carers check after each visit that he's wearing the pendant, and they put it on if he's taken it off. Once he left the home at midnight, and his daughter, who lives nearby, was alerted by the sensor, and she immediately went to look for her father and guided him back home. So key factors in that scenario pointing to a potential deprivation of liberty are the restrictions upon his freedom to leave his home, and the Law Society suggests careful examination would be required as to the extent to which the remote monitoring, together with the direct support of local authority arranged carers, cumulatively amounts to a sufficiently continuous, complete supervision and control to satisfy the acid test. The fact that, for example, carers gently enforce the requirement to wear the pendant is what they suggest is a relevant factor. And then lastly, the measures in the following scenario are unlikely to amount to a deprivation of liberty. So Susan and Jim are married, both have significant histories of alcohol abuse, and they met when they were both receiving treatment at a hostel. Although they've been together for a long time, the relationship between them can be volatile. They've been homeless in the past, but now have a joint tenancy of a housing association flat. 2 years ago, Susan walked in front of a car and was knocked over. She suffered a brain injury. She's made a reasonable recovery, but has impaired cognitive abilities, and clinical professionals consider that further improvement is unlikely. Her neuropsychiatrist assesses her capacity, finds that she's unable to make decisions about whom she should see, but not about her residence and care arrangements. Jim and Susan were very keen for her to return home. Susan will need some support. For example, it would not be safe for her to prepare a meal unsupervised. She's able to go out alone for short periods of time in the local area, but she gets anxious about being alone and encourages Jim to accompany her as much as possible. And Jim's willing to take on the majority of Susan's care. Staff feel that he will need some respite, and his own lifestyle can sometimes be chaotic. Susan's care plan provides for carers to visit for 2 hours daily to supervise and support her in cooking and ensure she maintains reasonable nutrition. The rest of the time there's no involvement by public bodies. So factors pointing away from a deprivation of liberty. Susan's able to access the community on her own, and so she's not subject to continuous supervision and control. Her whereabouts are not known at all times. And as I've said, I find that to be a really useful document. There's a lot more information in there over various different settings, and there are further examples. And yeah, I will share on that link that the laws where you can find the guidance if you've not already done so. So I wanted to move on now to consequences for breach. If the health board deprives an individual of their liberty without the authority to do so, they're acting unlawfully. And unlawful deprivations of liberty, as I mentioned earlier, can attract claims for damages and cost. Now, there's no fixed rate for damages for unlawful deprivations of liberty, and compensations assessed on a case-by-case basis. The amount of compensation depends on the specific circumstances, including the length of the detention, the severity of the harm caused, and the conduct of the responsible authority. In London Borough of Hillingdon v Neary, a period of a year's detention resulted in an award of £35,000 to Stephen Neary. In a local authority v Mr and Mrs D, an award of £15,000 plus costs was awarded to Mrs D for a period of 4 months unlawful detention. And in Esagbona v King's College Hospital NHS Trust, the court awarded damages at a rate of £130 per day. So case law does suggest there's likely to be a difference between a procedural breach, where there's a failure to secure authorisation or provide a review of the detention, but that would have made no difference to P's living or care arrangements, and a substantive breach that occurs where P would not have been detained if the authority had acted lawfully. So the test for considering whether authorisation is required is never whether the professional is certain that there's a deprivation of liberty, but whether there's a risk, whether there may be a deprivation of liberty. When considering if there's a deprivation of liberty, remember the comment of Lady Hale. Because of the extreme vulnerability of people, we should err on the side of caution in deciding what constitutes a deprivation of liberty in their cases. So ultimately, the court can decide whether there's a deprivation of liberty. In one of my recent cases, we were unsure as to whether the care arrangements would give rise to a deprivation of liberty. And in that case, I advised that based on the information that my contact had provided, given staffing levels, unlocked doors, and unescorted community access, it could have been considered that P wasn't under constant supervision and control. And on that basis, there was no deprivation of liberty, which would need to be authorised. However, on the other hand, P was going to be supported with activities of daily living. He's always subject to state control, requiring his return to the placement, should he be otherwise unwilling to do so, and his movements are always known and noted. And that led us to believe that P was under constant supervision and control, as well as not being free to leave. Which that means the acid test is met, and there is a deprivation of liberty, which would then need to be authorised by the Court of Protection. But when looking at these matters, it's essential to consider the circumstances in the round and to ask whether, in all the circumstances that actually prevail or might reasonably come about, the arrangements amount to a deprivation of liberty. And it's not always an easy task. So if there's any doubt as to whether there's a deprivation of liberty, the court can't be asked to make a determination. And if it determines that there is a deprivation of liberty, it can be asked to authorise that so as to make it lawful. It's also important to emphasise identifying a deprivation of liberty and understanding that steps need to be taken to make that lawful. It's not a reflection that anything's being done wrong by professionals in terms of the delivery of care or treatment, but rather the proper operation of the law. And I thought I would end with just a few of the issues that we see in the cases that I've dealt with in my experience. One of the things that I've noted is that often when we're instructed to make an application, we don't get the right documentation. So we don't get the capacity and best interest documentation very early on, which really should be available prior to our instruction. I've also noted that on occasions, health boards can be very slow to provide supporting documentation. So if I've mentioned earlier, there has to be a lot of supporting documentation, without which the court simply isn't going to consider the application, and certainly not on the papers using the streamlined procedure. And so it's really, it has to be done. We have to fill out that COP 11 to the best of our ability, and we have to provide all relevant and signed supporting documentation. So it can cause delay if we're instructed, but then when we ask for the documentation, that isn't, it doesn't come to us, or it doesn't come very quickly. That can cause a delay. And if we look back at that case where every day this could potentially be £130 per day, then the risk to the health board is ever increasing if there's a deprivation of liberty that's unauthorised. The other thing is outdated documentation, and it can be a bit of a pain, because documentation that we've received, which is perfectly sufficient, can become outdated during the process. So we just got to make sure that we've got all updating documents, so when it comes to the time of filing, there is nothing at that stage that's out of date. And I just wanted to note that we can support and advise, but we cannot progress a matter or submit an application without the documents that we need. And I think sometimes there's a misunderstanding that it's on instruction that court of protection application has been made, which simply isn't the case. We can, as I've said, support and advise to health boards to get an application ready. So, so we've got all the documents and they're of sufficient quality, but it's not until that application is lodged and not until we've got an order that we've got an order. There may be some protection for health boards in lodging an application, but you're certainly not protected by instructing us to proceed with an application, not at that stage. And I think, I think that's all I wanted to cover today. I don't know if there was anything Gavin has said, or he's popped into one of the other breakout rooms. I can't see him where he was. Does anybody want to ask any questions? I can't see anything in the chat. Any questions at all? No?
Hello. Hi. Yeah. No, I just it's this isn't really my line of work. I'm a psychiatrist. So I might get asked about capacity stuff, but I'm not in the mainstream of it. But I just wondered. I mean, a lot of how do the responsibilities share out between the local authority and the health board? Because most people living in supported living settings are either solely funded by social care, or perhaps rarely there's some kind of joint funding, but there might be health professionals going involved in aspects of the care.
Yeah, and I think it's usually the public body that is commissioning the care and has created the care plan, that then once that care plan is implemented, it will give rise to a deprivation of liberty. I think it's usually the responsibility of that public body to make the application. If there's a joint funding, I would suggest that whoever is the care coordinator, but usually by the time it comes to us, there's been some agreement as to who is going to progress the application. I would say the responsibility lies with the public body who is commissioning the care. So in a CHC case, it's not going to be the local authority, because it's going to be the health board that commissions P's care.
Yeah, and if as a health worker you're involved in a case that is commissioned by social care, but you're involved in the case and you're concerned that there might be a deprivation of liberty, what's the I mean, and perhaps you've discussed it with the case manager, and it doesn't seem like the local authority are sharing your concerns. What's the way to go then?
I think really what I would say there is the risk will lie with the local authority, because if there's the local authority who funds the care, they're the public body with who the risk sits if there is an unlawful deprivation of liberty. So there will be no risk to the health board because there is somebody involved. So I would just say in those cases to kind of reiterate concerns and the basis on which that's individual believes that there may well be a deprivation of liberty. and why, maybe explore why the local authority doesn't share that view. I think if the local authority commissioned the care, I think it would be on them to bring the application. You didn't ask this, but if there's somebody involved, but the local authority are going to make the application, it may well be that that person, that health, clinician, may be somebody who will be consulted on one of the annexes in the COP 11, so they may have a part to play.
Yeah, I suppose it might be something that we could discuss with our own legal. The health board's legal department, just to. Yeah.
It's it definitely is. I don't know if the health board, it could be that there could be correspondence between the health board and the local authority, even the health board legal and local authority legal, but I can't see that the health board would bring that application in circumstances with the local authority commissioning. Yeah, but to express concern, I do take that point.
Yeah.
Harry?
Hiya, yeah, I've got it's more of a curious question, really. When I'm just more curious about the level of evidence that you need for a community DoLs, and apologies if I've missed something fundamental here. When somebody's in a hospital and you are looking at DoLs, the evidence that's used is just listed, but you don't have to submit the evidence alongside it. So why is it different in a community setting?
Just so I understand it correctly, why would we be requesting that level of evidence?
Yeah, because you don't actually have to provide the evidence in a community hospital to get the DoLs. So why is it in a community different?
Yeah, and I think if LPS was implemented as it should have been, or we were expecting it to be, it wouldn't have been different, because community settings would have been under the same kind of DoLs. But the deprivation of liberty safeguards are in place, and they're just under a different framework. So this falls outside of those, and you've got the judge then, the authorization having to go before the judge, and for the judge to consider it. The COP 11 is quite prescriptive in what has to be to be lodged at court and filed alongside the application, in order for the judge to properly consider, capacity assessment on COP 3, which you'd have a capacity assessment in with DoLs, but different forms, different procedure. A best interest statement. So I think the things are the ideas are the same, but it may just be different forms and different documents that need to be lodged at court when you're looking for the judge to scrutinize the arrangements and to make an order. And I think the judges, we're finding the judges, there's increased scrutiny. So the applications that I'm lodging, just say in the last 2 months, compared to the applications that I was lodging in the last 12 months, I think the judges are increasingly coming back. And it's not a rubber stamping exercise. I think the judge are really considering all the documents that are being filed, the application form, and then coming back with any queries or to raise anything that doesn't quite match up. What we are having is, where there are queries, the judge doesn't just automatically list it for a hearing and make P a party and appoint a litigation friend. We're having an opportunity really to rectify. So the judge will say, I'm not really clear on PRN medication. Can you give me the following information? And a long list and a number of queries. And then once that is provided, the judge will then consider the application and consider whether, in light of the original documentation filed and that updating information / documentation, the order sought can be made or should be made.
Thank you.
Jill?
Yeah, sorry if I'm misunderstanding, so I'm just trying to get clarity in my mind over like the threshold for people who need the DoLs. So, for example, you mentioned about telecare and alarm systems that for people who exit the property when they lack capacity, and then someone could go and get them and bring them back safe into a place of safety. Is everybody who that is in situ, should they all have DoLs?
No, I don't think it's as simple as that. So I think it's the assessment of a person who lacks capacity in respect of their care arrangements, and then a person who is deprived of their liberty, and then we're talking about in the community, then an application will need to be made. So I think it is the deprivation of, because the application is to authorize the deprivation of, the application is to authorize the deprivation of liberty. So it's an assessment, is this person deprived of their liberty? And I don't think that could be, I suppose, the unhelpful part of the Law Society guidance. It's not if there's one of these is ticked that person's deprived of their liberty. And I think that's what the scenarios we're trying to get across, is that there has to be an analysis of what the care arrangements are, how restrictive they are. And when you look at all that together, is it a clear deprivation of liberty? Is it, it might be a deprivation of liberty, or is it, it's not a deprivation of liberty? And that's not a clear-cut question. You know, so I think that there will be cases, I had one recently, where even when you look at the care plan and you consider the the Law Society guidance, you may say, I'm just not sure whether it amounts to a deprivation of liberty. Now, if it does, then you need to make the application if they're residing in the community, because that deprivation of liberty is unlawful until authorised. But it's I think the difficulty comes in when you say, well, what is this a deprivation of liberty? And in those cases, an application, I think Lady Hale says, err on the side of caution. Make the application to court and say, firstly, Judge, do you consider these arrangements to be a deprivation of liberty? And secondly, if you do, will you authorise?
Yeah, it's really
so, yeah,
difficult.
I don't think it's every part of the guidance or every restrictive thing requires it. I think there needs to be an assessment of whether the arrangements in their totality look like they deprive a person of their liberty.
Yeah. So it's really difficult to know what is a deprivation of liberty and what's not. I mean, we've been doing this stuff for years. You could give me a dozen different scenarios and ask a dozen solicitors what's a DoL, what's deprivation of liberty and what's not, and you probably get different answers. And I mean, there was a Judge Mostyn a few years ago. He had a series of cases, and he was really challenging the idea that all these things are deprivations of liberty. And his view was, look, if it looks like a duck, it quacks like a duck, it probably is. So if it sort of looks like a deprivation of liberty, yeah, it probably is. The problem is he was very focused. He's one of the few judges who was really focused on, hold on, we're authorizing a deprivation of liberty. I need to be satisfied that there is a deprivation of liberty before I can authorize it. But in practice, I think a lot of practitioners and judges have kind of gone beyond that a bit, and they're more interested in using deprivation of liberty as a sort of hook to attach on to whenever. But actually, we're really more concerned about, is the entire package for in P's best interests? That's the more important issue. Is the entirety of this care plan and proposed package and any restrictions that are part of it in P's best interests? Whether or not that technically amounts to deprivation of liberty or not, there is very little litigation, case law in the past, certainly not in the past 5 years, probably going back longer than that, maybe right back to sort of 2016, 17, about what is actually, is this a deprivation of liberty or not? And the reason for that is it's expensive. It is expensive to run litigation to say whether or not something is a deprivation of liberty. I remember Liverpool County Council, they ran a series of cases years ago saying none of this is deprivation of liberty, and they got absolutely torn to shreds and got awarded costs and all sorts. So there isn't a lot of appetite for anybody to sort of challenge, is this a DoLs or not? Instead, people are encouraged just to embrace that, let's just look at it from a best interest point of view. But the technical legal sort of test as to whether somebody's deprived of their liberty is, are they free to leave and are they under constant supervision and control? But when you break that down into, well, what does that actually mean in practice? What am I looking for to decide whether or not somebody's deprived of their liberty or not? We're encouraged to look at the concrete situation on the ground, consider a range of factors, but as Aaron says, there isn't like a tick list where if you get 3 out of 10 and it's a DoLs and 2 it's not. It doesn't quite work like that. As Aaron says, err on the side of caution. But if we put in applications to court, there's very few judges coming back saying, I don't think this is a DoLs, away you go. They're saying, because what we're authorizing, don't forget, we're asking for permission to authorize a care plan, and within the care plan, usually it will include things that you want to do in certain circumstances, but wouldn't actually necessarily be there every day. So somebody who is largely manageable in their placement, but there are risks attached, and in certain circumstances you would want to prevent them from running out onto a road or doing various things. So, but on a day-to-day basis, you very rarely ever have to do that. And deprivation of liberty, don't forget, is for more than a negligible period of time. So you could be deprived of your liberty if you're just locked in a room for a couple of minutes. So it may not be happening all the time. A person may not actually day-to-day be deprived of their liberty, but what you're asking for is an authorization to be allowed to deprive them of their liberty in certain circumstances. And that makes it even more difficult to go, well, is this as DoLs or not? So look at what you're, what's the level of restriction? What's the level that you would want to do in the care plan, and think more about at its height would amount to deprivation of liberty. And for anybody who's in living in a sort of community placement, and there is significant control over what they're doing on a day-to-day basis, then I'd say I would probably go with that. That's your supervision and control. If somebody is with carers all the time, if there's staff available, if the staff are there all the time, and their day-to-day, how they sort of structure their day, that's seen as a significant control over their day. And then all it takes then is, are they restricted to a particular place for a more than negligible period of time? And that it doesn't take a lot for that. That's a locked door. That's no, we can't go out because but we don't have the support staff to take you out. And I find it really difficult to differentiate between what's a deprivation of liberty and what is support. So somebody who has 3-to-1, is that a restriction, or is that like an extra high level of support, and how does one view it? Those representing patients will say, well, that's a restriction. You've got 3-to-1, it's an invasion of privacy, and you get 3 people controlling what the person does. A clinician or a professional might say, well, but that's 3 people who you're supporting. They're not restricting their liberty, they're enhancing their liberty through that additional support. So it's not straightforward, and I think generally speaking, as Aaron says, we are on the side of recommending just making the application, because we're lawyers. It's very difficult for us to say don't do something and recommend a path that would, on the face of it, would be unlawful. But we fully accept that there is perhaps a balancing exercise to be struck by health boards, by decision makers. How many of these do you make? Where do you draw the line? And that has to be decisions made by people with some decision-making authority as to what the overall health board risk appetite is for that. Because if you get it wrong and people are deprived of their liberty unlawfully, well, that's potentially a regulatory matter. You could be talking about fines or costs or damages and all sorts of things. So it's a bit of a balance. If you're confident, and you'll hear me say this time and time again, MCA compliance, good MCA compliance, underpinning everything that is done, that is one of your best defenses. So if it turns out a DoLs was, oh, that's actually a DoLs and you haven't got it authorized, so it's technically unlawful, well, if you've ticked all the boxes and you've got robust evidence that you're MCA compliant, then you could say, well, no harm done. Okay, it's technically unlawful, but if we had gone through the court process, if we got this authorized, it wouldn't have made a blind bit of difference. It would have been authorized. The difficulty there is it doesn't take a huge amount, and anybody who's acting for pay in the circumstances, they'll always look for something different. They're always looking for, well, let's make something different. Let's reduce a restriction. Let's see if we can get them in somewhere else. And it doesn't take a huge amount to say, well, we've made a difference, we've lessened the restrictions. And as soon as you're in that arena, then you're potentially in the realm of damages for unlawful deprivation of liberty. And if you add it up, I don't know what the going rate is these days, £150 a day. when community patients who could be in a placement for a year, 2 years, 3 years, 5 years. If you do the maths on that, that starts to add up to a significant amount of money. If you multiply that up by 10 people, 20 people, 50 people in your service who are all unlawfully deprived of their liberty, you're potentially sitting at quite a significant risk in terms of financial risk if we're getting these things wrong. So, it's not our call as to whether to make an application or not. We'd probably, as lawyers, we'd probably defer to default to yes, just make it. It's better, safer to do that. But if there's someone else who wants to make a sort of riskier decision on that, then that's up to each individual health board as to how to do that. Bill, did you have a question? Did I see a hand up? Bill Thompson?
Well, yeah, I think you more or less said it really. It's just I put my hand up halfway through your spiel really, and it's so hard to judge, and I mean, if it's hard for the lawyers, for us mental sort of health practitioners, it's really difficult, and I work in learning disabilities, and your comment about is it support or is it control was exactly what I was thinking really, because if you interpret it as control, which is it doesn't take a great leap of imagination to do that, and if you do, then suddenly half your perhaps most of the caseload starts to look like a deprivation of liberty.
Well, if I give you a counter example of somebody who's not deprived of their liberty, so somebody who's in a persistent vegetative state simply cannot conceive of being anywhere else. So they can't be deprived of their liberty because their concept of liberty is, well, they don't have one. They can't conceive of being anywhere else. So in my view, if somebody can conceive of being somewhere else and they're in some way prevented from doing that, they could be prevented from doing it by the care arrangements that are in place, so that they don't have immediate access to going wherever they want, because of, and if they're able-bodied but they're not allowed to go out unsupervised, that's a deprivation of liberty. Where you run into it's a bit trickier is if somebody is physically disabled, so and they're not able to mobilize by themselves and are reliant on support in order to go out and do whatever that they want to do, then is that a deprivation of liberty if they're not able to access the community on a regular basis? And there's certainly case law that swings both ways. There's one particular judge who's a bit more lenient when it comes to interpretation of deprivation of liberty, and would say if somebody is so physically disabled they can't do things by themselves, then how are they deprived of their liberty? I think there is probably a halfway house there, and I think if somebody is intellectually capable of saying I wanted to be somewhere else, and conceiving of being somewhere else, and there isn't a reasonable care plan around them that enables them to do that in order to meet their needs, then that's where you're straying into deprivation of liberty. So I would look at anybody's care plan and think, what are the restrictions here? What are we preventing them from doing? And certainly Judge Hilder in London, and a lot of these community cases go through her or colleagues, and they look through it, and they are the ones who will pull it, as Ernest probably explained. They'll pull it out of the system and say, no, I want a court hearing. And what she's looking for is, what are the restrictions? What are you asking me to approve? And if you list all the restrictions, all the things that are being controlled around that person's care, and you make a big list and look at it and go, right, well, there's really not much to it there. She's not actually being restricted to do anything. Then you might think, okay. But if you look through a PBS plan, for example, you'll probably find there's lots of plans to use restrictions in certain scenarios. And any type of use of restraint, for example, is going to amount to deprivation of liberty. Realistically, I know restraint is permitted under Section 6 of the Medical Capacity Act, and how does one differentiate between restraint and deprivation of liberty? Again, it's one of those grey areas. It's when does one flow into the other? But if you've got a PBS plan that is planning for use of restraint in certain scenarios, and that is a long-term sort of plan for them, I think that's you're probably thinking that errs towards a deprivation of liberty. But no, unfortunately, the government decided not to define deprivation of liberty in the legislation. They deliberately decided not to do that and leave it up to the case law. And we've got the Supreme Court decision that says not free to leave and under constant supervision and control. I'll just give you another example of a case I have at the minute where it's gone in as a DoLs appeal. The person is living in some kind of care home. He has no curfew. He goes out every day, unsupervised, and he comes back. I don't consider that to be a deprivation of liberty. He is free to go as he pleases, and he's got no curfew. So the case really is about he wants to move to a different area. He wants to live independently, not in a care home. He wants to have his own property. He doesn't have his own property, and the only way he'll get his own property is through local authority housing. So for me, that's not a deprivation of liberty. He's free to go. Is he free to leave? Yes. Is he under constant supervision and control? No. So he's not deprived of his liberty. And yet we're dealing with it as a DoLs appeal. People tend to just sort of turn a blind eye to whether it's a DoLs or not, because there's legal aid funding, etc. And there's a DoLs in place. So somebody somewhere has decided that is a deprivation of liberty and has put a standard authorization in place, whereas I could easily support if the supervisory body in that situation had said he's not deprived of his liberty. The real issue is that that's more a sort of judicial review type decision of can he get access to another service, but that's not really a border protection case. And funnily enough, the case is really about trying to get him another option. It's not really about capacity or deprivation of liberty at all. It's just about finding him somewhere else to live. So not straightforward, I'm afraid. Jill, yes.
So just another question around it. So what if somebody is living at home? So I work with people with dementia. So we've got people that live in the community. They have unpaid carers. So it's normally their husband, wife, and say they don't recognise their surroundings, and they trying to leave the property to try and find their mum's house, or because of their cognitive issues. Would those kind of situations, when they are seeking to leave frequently, or we might use medication to help, would those kind of situations, would they need to have DoLs?
I think that falls very squarely into the technically yes, but realistically,
pragmatic.
As a lawyer, I can't tell you no. But I'm saying technically yes, but what you do about that, and in terms of priority, the important legal principle there is, if it is a deprivation of liberty, are they free to leave? In some occasions, no, they're not free to leave, and they are under constant supervision and control of the carers who are with them. They're prevented from leaving. The best interest part is immaterial. The purpose behind it is irrelevant, and therefore it needs to be authorized. But the fact that it's family doing it, once that is known, if those arrangements are part of a plan endorsed by a public body, or if it's an arrangement that comes to the knowledge of a public body, and there's certainly case law from over 10 years ago establishing this, that once it's within the knowledge of the public body, there is a public law duty on public bodies to protect individuals' rights, because it's the state's responsibilities to uphold and protect people's rights under the Human Rights Act. Therefore, if there is known to be a potential infringement of Article 5, then they should be doing something about it. So technically, yes, a health board or local authority should be taking steps. But of course, the first port of call is not to run off the court. It's to review the care plan and say, right, hold on, is there anything here that could be less restrictive, could be done in a less restrictive way? Could we get it below the threshold for what is a deprivation of liberty? And maybe it's just a restraint or a restriction without amounting to deprivation of liberty. And this is where I find it difficult, because you could reduce restrictions right down to the point of, well, actually they are free to leave. They've got enough support. If they wanted to go out, people could go with them, but they would just make sure they don't walk into the road and get themselves into trouble. I don't think anyone would say that's deprivation of liberty. That's a restriction just for their safety. That's not a problem. If it's difficult to manage and actually you're locking the front door, you're locking the doors, you wouldn't be able to manage the person if they left the property, and therefore you're restricting them because you can't manage it, and you're locking the doors to prevent them from getting out. So there's the confining them to a particular place, then that's heading then towards a deprivation of liberty. Technically it needs authorised, but we fully appreciate the process of doing that comes with a time and a financial cost, and with probably minimal risk if you didn't do it. You got regulatory issues if you get an inspection. If you got, I know HIW have done inspections of various health boards in the past and have identified people that they consider to be deprived of their liberty and said, what are you going to do about it? And the health board have to go off and get all those authorisations in place. So there is a regulatory aspect to this. There's an individual sort of professional responsibility and a safeguarding responsibility, and there's that overarching health board public body responsibility to protect people's rights. As to the financial risk or the regulatory risk of whether a health board is willing to accept that, given just the sheer volume, and I think there is generally an understanding that there's a huge volume of cases and it's difficult for public bodies to manage them. But on a case-by-case basis, it's difficult to justify, oh, we didn't make an authorization or application in this case because we just didn't fancy it. So it's a balancing exercise. Any other questions? Has anyone got any examples of going through one of these processes of getting an authorization in a community placement and either had a really good experience or had a really bad experience of, we found it really difficult, what were the problems, where did you see the barriers? Because from what we see, especially for anybody here who's a care coordinator, it's really difficult, and I'm sure Erin covered it, I wasn't here for the whole session, is to get everything lined up, all the ducks in a row at the same time. That's one of the biggest challenges. Lika, sorry, I'm not sure how to pronounce that.
Yeah, it's pronounced Lisa, sorry, apologise for my spelling, okay. But that's how it's spelled. Irina will know. Sorry. I've got a case that's taken forever, and it's been nothing to do with Irina's support, by the way. It's just there's been, I've had lots of different staff turnover within the team, people either finishing, going on maternity, things like that. And as Irina pointed out earlier on, then you think you're just about ready, then actually there's something else that's just come out of date, or we need another best interest, or we're waiting for a member of the family to give to write back, because we're having difficulty getting hold of them. So it's taken an awful long time, and I always panic with this case because of the reasons, again, about Irina saying about how long it takes to get through, and whether there's any charges brought, sort of, or any costs that the health board are liable. So that's my only frustration around it. Sometimes there's cases that actually it doesn't matter how hard you try, there's something that keeps tripping you up all the time. So it's a very lengthy process in one of our cases.
Yeah, to try and help with that, what we're doing, we've got a new case management system at our end, and we've kept that in mind when we were designing it. So what we've come up with is a page that we're working in due course, hopefully, to allow people within the health board to have direct access to. So it's a page that sets out all the stages of applying for community DoLs through the streamlined process, and a bit of like a checklist. This has been done and the date it was done. So it's just a one-stop shop that you can log into and go, right, where are we? Where have we got to? And if you're managing other people who are doing these applications, if you're the line manager, you'll be able to check in and go, right, I can see where we've got to. And you can see if things are about to go out of date. And getting everything within that window can be really, really challenging. So we're going to continue to work in that because we want to be able to help you, because we appreciate, like, health boards don't necessarily have any single system that helps them diarise and sort of manage that process. So if we can come up with something that works for you, then we will try and do that.
Yeah, that's great. And like I said, some of it has been a little bit of out of our control as well. Like I said, getting responses, we've tried emailing, telephoning, and like I said, a change of care coordinator, and then someone else picking it up. And we've got really close a few times, Arena, and then there's been another hurdle, and we're just waiting for that for some information, for one thing to be signed off again. And I'm just hoping that there's nothing else then in between then that stops us moving forward. But it's taken an awful long time.
As I'm sure Aaron has said, the dilemma in these cases is, do you make the application when it's not perfect and risk it getting pulled by the judge, and the MP gets represented, and then anybody representing an individual is going to try and argue for something? That's just what they do.
Absolutely.
They feel as if they're not doing their job unless they make a difference. So you're going to get people who will advocate for something, they'll challenge everything, they'll make complaints about gaps in authorizations and delays, etc. Or do you leave it and you try and get everything perfected, in which case, in our experience, judges, despite the delay, don't really take that much of an issue. They just take it, well, it is what it is. I've been asked to authorize this, I'll authorize this, it's no problem. It's whenever they get pulled from the streamlined process and end up in an oral hearing, that's when the judges and advocates get a bit more critical of delays. So it's a really difficult balancing exercise.
Yeah, thank you.
Okay, and we've got a Q&A at 10 to 4. So unless there's anything else, if you want to come back to the Q&A at 10 to 4, I'm going to try and mop up any remaining questions. Otherwise, thank you very much for coming today. Hopefully this has been of some benefit. I think we've got most things recorded, and we'll work out a way of for you to be able to access that if you want to refer back to it. The handouts, the materials will remain in that folder. I've probably put something like a 6-month expiry date on it, and we will aim to sort of update those in due course. We'd be really welcome any suggestions for training in the future. We've done this session twice. We'll do another one probably next year. If there's something different you'd like to be covered, we're welcome to have some ideas as to what you feel to me most valuable to you. So unless there's anything else for now, shall we close this breakout room? You can go back to the main room if you want, and we'll see you in a few minutes for the final Q&A.
Thank you all.
Excellent. Thanks, everyone.
Hello, thank you for joining us. I think we'll start now. There's around 45 that's joined the group. So this talk is in relation to delayed discharge. I thought I'd take an opportunity just to give some introductions. So my name is Neris Thomas. I'm a solicitor in the complex patient team. And also with us today from the team in this particular breakout room is Megan Edwards, Sophie Balla and Larry Evans. Megan and Sophie are solicitors and Larry is a paralegal in our team. So we are part of the complex patient team, which is a centralised legal team and shared services. And just to give a brief synopsis of what we do, we're often instructed by health boards in Wales in relation to situations which involve Mental Capacity Act, Mental Health Act, deprivation of liberty safeguards and serious medical treatment. There's a team, I think, of around 12 of us now, which includes paralegals and solicitors, and we would welcome the opportunity to assist you in the medium of Welsh, if that would be of any benefit. And also just to touch on how to contact us, so usually we receive instructions via a referral form. A number of health boards have now taken up an electronic route in doing this, which we'd welcome. So if that's something that you would be interested in having, please let us know. We can assist you with that. But ultimately, these referral forms need to set out brief synopsis of the situation, provide the contact details for people that we can get instructions from, confirmation that fees will be covered by whoever's authorised, and within your team to pay for legal costs. And then we usually categorise them red, yellow or green, depending on the urgency and how quickly you wish for us to respond to you. We'd like a takeaway point from this session to be that if a team is not sure what to do when there are queries around capacity, best interest decision, court protection cases, etc., that the health boards come to us as early as possible so that we can assist you as early as we can. Appreciate that some situations won't allow an early referral as maybe a critical and urgent situation that has arisen unexpectedly. But if you have a patient on your ward who's under a DoLs or there are queries around capacity, we'd ask that you come to us sooner rather than later. The quicker that we can offer assistance, the quicker, hopefully, the matter can be progressed for yourselves. So today's session is it should be around an hour and a quarter. Not sure if we will use all that time, but hope that you'll find that what we discuss as useful. Purpose of the session is to discuss from our perspective and hopefully have your input on the issues that can arise when looking to discharge a person from hospital and to see if there are ways of trying to speed that up, which could benefit us all. And a quick reference to statistics around this situation. The Welsh Government provide information that a delayed discharge occurs when a patient who is clinically ready for discharge cannot leave hospital because the necessary ongoing care and support or suitable accommodation for them is not yet accessible. So their statistics represent the number of adults occupying an NHS hospital bed who were clinically optimised and ready to return home or move on to the next stage of care that experienced a delay in the transfer of more than 48 hours beyond the point they were clinically optimised. And for August 2025, the government statistics detailed that on a particular day when the information was gathered, that there were 1,367 beds being occupied by a patient who was fit for discharge. This is a reduction from the same time as last year, it was at 1,619, and does seem to support that there is a general downward trend in the figures in relation to delayed discharges, but it's still a significant issue for health boards. Having those beds available would mean less workload and reduce costs for the health board, plus be available for those who require hospital admissions. You may consider that the situation is more acute in the health board that you work for, and the reasons given for the delay in the Welsh Government statistics are varied, but include awaiting nursing assessment, awaiting social care assessment, awaiting start of new home care package. Appreciate that some situations are out of the health board's control and quick fixes are unlikely. But if anyone in attendance has any ideas or examples of situations where a case has been resolved or a certain approach has been helpful, then please do share at the end so we can all benefit from that. So we're now going to move on to discuss the points that arise around discharge when we are instructed, and Larry is going to assist with that.
Thank you. So just to address sort of the impact on healthcare and the more common issues that can arise in cases that we typically deal with, a lot of the reasons for delayed discharges could be miscommunication between the parties involved. So local authority, health board, or the patient's representative thinks one of the others has directed the matter to court of protection, but no one has actually taken any steps. Another one is the identification of a care provider who can meet the patient's needs and has availability to do so. Identification of a care provider with staff available to provide care in the patient's home. Another one would be poor quality or incomplete evidence prepared in line with the Mental Capacity Act or DoLs, which means it may need to be done again before being able to move forward. And then obviously that delays court process. A lack of direction or ownership of situation, which means the patient's discharge is slow moving. Thinking that a case needs to go to court when it doesn't, or equally thinking a case doesn't need to go to court when it does. The patient and or family members opposing a proposed plan. The patient's needs changing, which may impact the pathway of care that's required. There can also be funding disputes, or lastly, poor communication from ward to ward when an individual has been moved from one to the other, so causing a delay in moving towards discharge. For example, advising that a case is being considered by court protection and that particular evidence is due or options need to be looked into. We're going to concentrate on situations where the patient is under a DoLs. And I think we're heading over to Sophie for that.
Thank you, Larry. I hope I've just spotlighted myself, but let me know if I haven't. Yeah, so as Larry said, we're focusing here on people who are in hospital with a health issue and they need to stay until they're better or improved. So they're placed under a DoLs. And obviously they're assessed as not having capacity to make decisions about their own residence and care. So DoLs is a legal framework which provides protection to people and organisations that have to restrict a person's liberty. If a person has capacity to make decisions for themselves, then no one can prevent them from doing anything they want to do, whether that be leaving or anything else. When they're under a DoLs, the patient can be restricted, albeit the patient's care plan will need to explain why those restrictions are required. When a patient is clinically considered fit for discharge, the following really should be taking place as soon as possible. Number one, nursing needs and social care assessments should be completed to identify what level of care is required and in what environment. Number two, options then will need to be considered and identified. Number three, capacity assessment should be undertaken with information about the options available to the P as well, to determine if the patient can make a decision for themselves. Number four, if a patient is assessed not to have capacity, a best interest meeting will need to be arranged with all the key members of the health team attending, as well as any social care colleagues and the patient as well, if that's possible to do so. We'll need to make sure that the patient's representative is there, whether that's their RPR or family members or IMCA, anybody who is there to express P's voice. This meeting should be minuted and these should be documented so these can be provided to Legal and Risk or anybody who might need them. Number five, a decision maker should be appointed at this point. Obviously, within the best interest meeting, they should be making the final decision. All the pros and cons of all the options need to be considered and the attendees' viewpoints to considered as well. This obviously including the RPR or family members on behalf of P. What are their views? What do they think should be happening? Are they in agreement with the placements? Do they have any concerns? Number eight, a balance sheet analysis will obviously be helpful in that situation to easily see what the pros and cons are. We have provided a copy, which I think is with the documents for you. I think it's towards the end, which is quite useful to see if you haven't seen one before. And finally, for the decision maker to make the best interest decision, obviously with all the information from that best interest analysis, including families' views, P's views, and they make an overall best interest decision, which is what we will proceed with. In terms of the balance sheet analysis then, we really need to drill down in this document and really analyse all the options available. It needs to consider all positive and negative points for each available option. These can be things such as a placement is close to home, close to the patient's preferred area or somewhere they're familiar with, whether they need any areas for smoking, whether they need any specific facilities. These should all be considered in the analysis. The more reasons that we can give in this document, the more rounded the analysis. What's considered a positive or negative will of course depend on the patient and their circumstances in the matter you're dealing with and can obviously differ from person to person. I think at this point Neris is going to discuss transfer.
Thank you. So when a best interest decision has been made for a person to be moved from the hospital environment, the transfer of that person needs to be considered. If it's in court, if the matter is being considered by within court proceedings, then courts and parties of the case often require a document, sometimes referred to as a conveyance or a transition plan. It would be our advice that these are useful in all cases, as it assists everyone involved to understand what will be happening, how the individual will be moving from the hospital to the either home or the placement that's been identified for them. The health board would need to give thought and often co-work with local authority, family members, potential carers and placement to draft up this document. And they would need to decide what steps may be required to ensure the move does take place as easily and smoothly as possible. So the elements of the transfer could involve things such as whether gentle persuasion would be sufficient to get the individual to be moved from the hospital, whether you could show him or her photographs of the proposed placement to the patient, asking family members to visit proposed placement, provide feedback to them, asking proposed placement staff to visit patient and ward to allow them to get to know each other and start to build that relationship in advance, possibly doing short visits to the placement, just a few hours, maybe a full day, depending on the situation, for that person to get used to the surroundings. And at the most serious side of the spectrum would be looking at things like sedation or restraint if it's the possibility that the individual is not going to be in agreement and is going to be extremely reluctant with the moving, and what that would look like. So with sedation, our advice is that if the patient is opposing the move and either sedation, which is not usually prescribed as part of their treating plan, is needed, or restraint, then court authority will be required due to the level of interference with that person's liberty and their human rights. These applications, or this part of the application, can sometimes require a lot of work from the health board due to the level of detail that you have to go to, more so in relation to the restraint. So how many people and what would that look like? And the advice would also be to seek authority from the court for the maximum restraint proposal to be authorised, working on the basis that you would take it through the least restrictive option, but having that power there to go up as far as the health board considers is necessary and clinically advisable to get that transfer carried out, to save you having to go back to court to get further authority should you have sought a less restrictive plan at the earlier stages. Draft transition plans have been added to the pack for your consideration. These are simply documents that have been used in our cases previously, so there is no set template. It's something just to use as some guidance, but ultimately each document needs to be drafted with the particular individual in mind. So sometimes they don't have families, sometimes they have a lot of items that they would want in the property before they go there. So you have to think about it in the round to get the best out of that transition plan. So again, the more detail that can be added, the better. Things such as when will patient know when they're going to be leaving, how long will the journey be, who will be with them on the journey, how will they be taken, when will their belongings be packed, and how will they be taken to the placement, care home or patient's property, who will be in the property to meet the patient, and what arrangements will be made about medication required. As a team, we do deal with a number of cases which are in court protection that have an individual that has been in hospital for a very long period of time. One particular case that I had involved a gentleman being in hospital for around 18 months. They had been fit for discharge for at 3 months stage. He was under a DoLs, but the members of the health board had different views on what was causing his presentation. He was, prior to the hospital admission, he'd been managing the community by himself. The carers had withdrawn package of care due to his behaviour. Due to issue with the diagnoses, the health board team members had different views about where he should go to be supported and what that would look like. Some said placement with mental health support, and others said home with a package of care. He still had home available to him, which was a rental property that was in his name. He had been assessed as having a low IQ, but score was a few points above learning disability threshold, therefore he wasn't supported by that team. There was a lot of going back and forth between mental health and learning disability teams as to who was responsible for the care, which meant that this gentleman remained in hospital and was occupying their bed unnecessarily. Eventually, a bespoke approach was undertaken by the Health Board, where members of both mental health and learning disability teams were involved in case and decisions were made together. He was moved around a number of wards whilst the case was considered in court, as staff struggled to manage his outbursts and aggression. He was very difficult to manage at times, and other times was lovely. A part of a mental health ward was made available to him, which had a lounge area, and mental health trained staff were available to support him. On 2 occasions, because he was still in hospital, the individual had to be taken to A&E due to lymphedema flare-ups and concern about sepsis. But on both these times, the individual then refused to return back to that mental health ward that had been set aside for him. As the matter was already in court and he vehemently opposed the move back, applications had to be filed at court seeking authority to restrain him from A&E in the vehicle and back to identified ward. A restraint plan was prepared by the Health Board, which set out that up to 4 members as trained staff would be with him when returning to the ward, and restraint would only be used as a last resort. The application was approved and he was returned to the ward with no restraint having to be used, because he ultimately agreed when told that the judge had said that that was going to be happening. Eventually, a property was identified for him and a care team could offer 4 calls per day, and the court, based on evidence filed, approved a move to return home with a package of care in place. The package of care is still fragile, but he remains in the community. What I'm trying to emphasize in relation to going through that case is that he was ultimately in a position to be discharged from hospital at that 3-month stage, but because of his presentation and his physical health and the difficulty between the teams coming to an agreement as to where he should go, he was in hospital for a very long time, which then became the Health Board's issue in dealing with this, having to find somewhere for him and finding a team that could support him, and then that whole application, 2 applications to court to get that move back from A&E. So it caused quite a lot of difficulties for the Health Board, cost and time. And in that application for transition and restraint, the Health Board had to prepare a witness statement from a member of the team, setting up presentation, an application form which we assisted with, and we had to file a draft order, a restraint plan, a transition plan, and we needed to notify the other parties and seek their input on that application. Therefore, it was very time consuming on a case where ultimately he shouldn't have been in hospital. So the learning that we feel from this case is that the Health Board teams, if possible, to work together and not think solely within their own role. When in court proceedings, the Health Board is named as a party, and the expectation from the court and other parties is that the Health Board is acting as one. If there are opposing views, these need to be raised quickly, and a plan as to whether an agreement can be reached, for example, getting an independent opinion that everybody agrees to. It took time for key members of the Health Board to be identified to instruct me due to the differing teams involved. There was concern about being in a court case, and therefore people were reluctant to assist. The individual was particularly difficult to manage. Appreciate all of this, but unless a Health Board is planning its plan of action and there is someone identified to push for the individual to be discharged from hospital, the situation can lose momentum, and weeks can become months, and months can become sometimes years. Dealing with the situation proactively and having regular reviews will hopefully result in progress on the person being discharged from hospital. And Sophie's now going to discuss suggested best practices to minimise delays.
Thank you. So, a lot of people do see the Court of Protection as a delay to discharge. Being in the Court of Protection can sometimes cause delays where, for example, there's an application for restraint and it's submitted to the court for the judge to approve, and there can sometimes be a slight delay in approving, depending on when the judge is available. But often we find that the delays can actually caused prior to the court application in terms of gathering evidence. There is obviously quite a lot of information that is needed from the Health Board before an application can go to court, and we appreciate there's a lot of work needed, a lot of documents needed, and we're obviously here to support and help where we can with those. So we thought it was best to discuss that some things that can be done to hopefully minimise delays. These, as we see it, would be Number one, early identification. So recognising potential capacity issues as soon as possible during a patient's admission. If the health board have questions around capacity, make sure assessments have been done as soon as possible. Determine what areas of capacity are needed to be assessed. Is it regarding discharge? Is there anything else that needs to be considered? Have options been considered already, and can these be used within the assessment for P? Number two, proactive planning. So starting discharge planning as soon as possible, involving all parties, and when reviewing options and arranging a best interest meeting, making sure there is somebody there for P. I have said it earlier, but making sure either the RPR is there or family, whoever's supporting P in that role as RPR, they should be invited to that meeting and their views should be included in the best interest meeting minutes. Ensure all options are considered, including a return home if home is possible, whatever options there might be. Hopefully at least 3 options can be considered in that meeting for an option to be considered as in their best interests. Seeking legal advice on the matter as soon as possible if there are any queries. Obviously, like I said, there's a lot of documents that need to be completed, and if you have any concerns or issues about them, you can always send them over to us or whoever's providing you with legal advice, and they can support you in drafting and amending the documents if needed. But the sooner you can get advice, obviously, the better. Identify a member of the team who will lead on discharge to ensure the matter is being progressed. As Neris said, things can go from weeks to months, and we want to make sure that's avoided. So making sure someone's taking the lead, chasing things up, and even if documents are being drafted by other teams, someone in the health board is chasing that up on a frequent basis. If legal is involved at that point, making sure we're kept up to date with the discharge process. Are there any beds being offered? Is there any deadlines for that bed to remain open for? If we find it frequently that placements do offer beds and there's only a week or so before the bed is no longer available, and the longer we have to consider that, the better. Ideally, at least a week or 2, but we appreciate that's not always the case. And we would never want to lose a bed for a patient, so we'd want to make sure the earlier we know, the quicker we can take action and get everything we need in place so we don't lose that bed. Early consideration of the transition as well. So how will that patient be moved from the ward to a placement? What does that look like based on the patient's behaviours? Do the health board have any concerns that restraint or sedation might be needed? Or do we feel that the patient will go quite happily and there will be no concerns? Determining that at an early stage will be useful because, as Neris has said, if we need restraint or sedation and we need to go to court, the more notice we have of that, the better. If we're happy that the patient will go quite happily, then there's other options. So early consideration of how we will get them there. Clear communication as well. So ensuring all stakeholders, including family, are kept informed and involved in discussions, again, including the RPR when it comes to best interest decisions, making sure that they're aware of the decisions being made to prevent them having any concerns further down the line, especially when it comes to a few days before transfer. We don't want the RPR causing any concerns or putting any further delays on that. Timely applications as well to the court. If a court of protection is needed, initiate the process as soon as you possibly can. As we've discussed, there's a lot of evidence that can be required sometimes. Having this to hand, following instructions to legal is so useful. Ensure that the health board are happy with the evidence as well, that there's no disagreements between the health board professionals, especially where you have multiple teams or multiple individuals involved, making sure that they're all content and happy and in agreement with the evidence before legal is even instructed. The same with capacity evidence. Is that agreed between everybody? Is that robust, and is everybody happy with that evidence? We've heard Ileana talking earlier about capacity assessment, so I won't go too much into that, but making sure that we've read through them. As a health board, you've read through the document, the capacity assessment, you're happy with it, you don't think any further assessments are needed, you don't think any further areas of capacity are needed to be assessed. Interim solutions as well. So are there anything in the interim that we can do while we're waiting for a court decision? That can be in relation to moving wards from a ward to a community hospital, or even from the ward to a residential placement in the interim, as I've discussed last time, it's about ensuring that if we're going to court and we have a court application already with the court, if P's solicitor is happy for a move to take place in the interim, that can be done, but we need to consider that all the evidence still needs to be in place, as it would be in court anyway. So we still need the capacity assessments, the best interest assessments, everything needs to be done and robust to agree any kind of interim move. So as well as that, it's making sure that we've done all the assessments, we've got all the capacity assessments, they're documented fully, they're signed fully by everybody who attended any meetings, and if legal are instructed, they're sent over to legal as well for their review. So it's worth noting as well that the health board can lead with applications. It's not always something that P's solicitor needs to bring to court, it's something that the health board can bring to court as well. So it's worth considering that when you're considering any kind of delayed discharge. So the health board can bring a case to the court despite the reason for the delay. Even if the delay is relating to family not agreeing to the plan, the health board still have the right to direct an application to court to bring that patient situation to the judge's attention. So we don't need to wait for their solicitor to do that or the family to do that themselves. With the health board leading an application, sometimes this results in pressure being applied to the other parties or the family for them to explain to the court why discharge can't take place. So we can always do an application to court, and this would be a Section 16 application under the Mental Capacity Act for a decision about P's welfare. Again, there's a lot of information that is needed for this application, which is, again, capacity assessments for care and residence, for discharge, for anything else you might consider is needed, and making sure that they've been done recently rather than on P's admission 6 to 8 months ago. Minutes and best interest meetings, including, again, as I said, RPR views, family views. Is everybody in agreement? We'll need witness statements setting out the patient's situation and what the health board is seeking assistance with. Copies of any nursing assessments, confirmation of funding decisions for future care and current care. In an application, the patient would need to be represented in proceedings as well. If they're under a DoLs, they would usually have an RPR. And because of the application, the way the application is, it means that they wouldn't necessarily get non-means tested legal aid, which means that there's a potential for the health board to need to cover the patient's legal costs whilst that's being considered. Sometimes that's not something that happens every time, but it is sometimes requested, and it's worth for the health board to decide if they want to do this. But sometimes it should be considered that until they're represented, they obviously can't go anywhere. So sometimes the cost of paying the person's legal fees to assist with the discharge could be less than the cost of having them in that bed and waiting for an application to be brought elsewhere. The health board should also note that if P is objecting to being on the ward, a 21A challenge can be brought at any time. We don't need to wait for any of the meetings to have taken place. If they're objecting at that point, that can be brought to court at any point based on their objections. I think that's everything in terms of what we see as ways to hopefully prevent any further delays. I think Nerys is going to discuss quality of evidence now.
Thank you. So it's fully appreciated that many of you are in your roles and you didn't enter into that profession to provide evidence to court. But when a patient is under DoLs or has been assessed to lack capacity to make a decision, it's really important to have quality evidence to support the health board's position. And this information, this evidence is then shared with the court and with the legal representatives of the other parties and family members, and will be scrutinised. We've seen many different versions of capacity assessments, reports, statements, etc. Some that
strawberry glaze. It's a nice little structure you've got inside there. Strawberry flavours. Really
some that are good. Sorry, somebody's
yeah.
got the microphone on. Thank you. So we've seen many different versions of capacity assessments, reports and statements, some that are good and some that are not so good. We're here to help as much as we can, but we don't know the patients like you do. And the evidence has to come from you, and this is on behalf of the Health Board. Your information and knowledge is important and will be taken on board in court proceedings. So the advice would be to make it useful, make it detailed, and make it count so that the matter can move forward and you're hopefully not asked to provide further evidence. It's often the case that court orders say that the judge requires XYZ to be covered in a statement. That is usually the bare minimum. And whilst we send templates out saying, can you provide this information and provide this statement, please feel free to add to that with any additional information that you consider is appropriate and the judge should be aware of. Because ultimately, the more information the judge has about the person who prior to the court proceedings he or she knew nothing about, the better in understanding that individual situation. So a starting point to keep in mind when preparing any documentation is that judges and legal representatives, patients, family members are most likely not clinically trained themselves. Therefore, when you're explaining anything, it needs to be done thoroughly, without acronyms, and in an easy to follow way. A way of explaining this is similar to a maths exam where you have to show your workings out. So how did you get from A to B and why? Judges will also know very little about the patient, as I said, and they're being asked to make a decision on them. Therefore, the more information you can give, the better. Across all health boards, and this is said with understanding that you have a number of demands on your time, the evidence provided in capacity assessments, witness statements and reports, care plans can often be open to criticism. It's appreciated that you are often time short. However, if the task isn't completed as fully as it could be, it's likely to mean that it'll come back to you or go to somebody else in the team to be redone. Therefore, if being asked to provide evidence, the advice would be that this is done as well as you can to ensure that that does progress the case. In relation to, in the context of this particular training session, so discharging patients from hospital, there does need to be strong evidence filed. Some points which may help, and I apologise that we're repeating some of these to you, but we're trying to stress the importance really. With the capacity assessment forms, the templates used by most health boards offer very limited space to provide answers to the queries. Those that have seen the form, you will see there's just a number of boxes, which doesn't suggest that much information is required. But from our perspective as legal representatives from the health board, whenever we get those, our hearts tend to drop because it's usually the information is so limited. It doesn't assist us in being able to say, yes, this has been done thoroughly, and this is a strong capacity assessment that we can rely upon. The advice would be that, yes, fine, use those forms, but please consider that you can add additional pages, and so that you can give the information, explain what questions were asked, what relevant information was discussed, how steps were taken to try and assist to get the best out of the individual during the assessment, and so on, to try and give the health board the best chance possible that evidence can be relied upon, and we don't have to repeat it or possibly look at getting an independent expert to provide a report. Another one is the balance sheet analysis. So whoever is tasked with looking for options, please consider all the different care options and then give reasons as to why they may not be appropriate. If there is a home, and irrespective of the unlikelihood that the individual can return there due to needs or presentation, it should feature within the balance sheet analysis. The court is always going to look at a least restrictive basis, and naturally most people want to return to their home. So we often get documentation where home doesn't even feature in that analysis, but it needs to be there. If it's the case that you're going to rule it out, that's absolutely fine, but it does need to feature so that you can see that that's been considered. And in relation to witness statements, these are very important documentation. These need to tie in all the different other reports, assessments, documents that may be filed. For example, the capacity assessment, the historical presentation, current presentation, needs assessment, options, best interests. A statement should ideally take whoever's reading that through the situation as it stands. And at the end of that statement should be in a better position to know what's happening with that individual. Again, we have templates, we can assist with this, but we're providing this information to yourselves, as we appreciate you may not be accustomed in providing this evidence, and just to give you an understanding of what's expected and what would be helpful. Another example of a particular case that I was involved with, which involved the health board taking control of a discharge situation with a positive result. It involved an elderly lady who was in hospital for pneumonia and a chest infection. She was considered fit for discharge for 2 months, after 2 months, but was still in hospital. The family wanted her home, but there was a safeguarding concern in relation to a return home, and a placement was identified. A placement was identified, and the lady was under a DoLs. So the health board was proposing an interim move so that the lady could be moved to the care home while safeguarding being investigated. The lady's daughter was not agreeable to long-term move or being in a care home, but did agree interim move pending long-term decision being considered by the judge. Whilst the individual said she wanted to go home, she had dementia and referred to home as being with her mum and dad, but she was in her 80s and therefore her parents were no longer alive. A health board team said that the individual would follow care team's guidance and wouldn't physically oppose a transition, therefore we weren't looking at sedation or restraint to bring about that transition. An application was made to the court on behalf of the health board, therefore the health board started the whole court process, and that was under section 21A of the Mental Capacity Act, asking for the judge to consider long-term option. Daughter had agreed to that interim move on the basis that the application was lodged. So ultimately, through negotiation, it was decided that if the health board made an application asking for long-term option to be considered, the daughter would agree for her mum to be moved to the interim placement, which could potentially have become a long-term placement, pending that long-term option being looked into. So thought had to be given of the potential impact of the two moves, i.e. one to the care home on an interim basis and then possibly to home afterwards. But the outcome was that care home could be long-term option if judge approved, and it was better for the lady to be out of hospital setting pending decision on long-term plan than remaining in hospital until long-term decision made, as time frame was unknown for this. The proposed placement had been put on notice of the move and had indicated that they would put an urgent authorisation in place once the lady was with them, and then have a standard authorisation. This ensured that there was a legal framework around the deprivation of liberty, and court case could continue to consider long-term option. Just for note, a proposed placement can put a standard authorisation in place 28 days in advance of the person moving there. Therefore, the legal framework for any restrictions on liberty can be in place prior to a move, and it can be a useful tool in protecting an individual's human rights by getting those steps actioned in advance of an actual move. So from my perspective, lesson learning from this case was that leading with the application resulted in the lady being moved out of hospital quicker than what it would have taken if she was waiting for that long-term option to be decided and the safeguarding matter being resolved, which meant the bed was available for somebody else that actually required it. And the health board was able to set the narrative, i.e. the interim move was better than waiting for a long-term decision. An interim placement could be long-term option. Therefore, the individual had insight into what it was like to assist with wishes and feelings, which is something that's usually sought as part of the court process when looking at options. And so the health board could control the momentum to achieve the goal of the discharge. And just to flag as well, it is generally accepted by judges, legal representatives and advocates that hospital is not the right environment if there is no clinical reason for being there. And that's because of lack of mental and physical stimulation, lack of comfort and belongings around the individual. Sometimes there are restricted visiting times, therefore limited contact with family and friends, potential risk of getting other illnesses going around the hospital, and a lack of access to outside area. So this means that if the health board keep discharge planning under review for all patients, it will not be criticised for seeking to move the patient on when considered fit for discharge. Where the person is to go can be the problem, but we find that if the person's case is regularly reviewed, progress is likely to be made much quicker. So ultimately, it is an open door in the sense of when a health board is saying, look, it's not right for this person to be in hospital any further, that is there is. I haven't experienced anybody saying, yes, you should stay. It's sometimes the problem does become, where does she go, or where do they go? However, it's a case of finding those options, but at least we have that argument to put forward when trying to move. So finally, the advice would be identify who is leading with discharge planning. If in an MDT meeting for an individual, and you don't know who's leading with that discharge planning, ask for that person to be identified. This puts the matter in forefront of the discussions for the health board. Number 2, consider discharge options at an early stage. The intention is that a patient is to come into hospital for a specific reason and then leave when fit for discharge. If a person is detained under the Mental Health Act, discharge planning is considered at the outset of that section. It obviously doesn't apply to hospital admissions, general hospital admissions, but changing that mindset, should it not be there, is going to be a positive for the health board and the individual. We're not talking about getting people out of hospital when not appropriate, but are highlighting that sometimes discharge isn't considered until the latter stages of a person's time in the hospital. But if being considered at an earlier stage may lead to an earlier discharge date as team have been proactive. Number 3, keep discharge planning under regular review. As I've said before, weeks can turn into months very quickly, but if there is a diary or a reminder to review it every 1, 2, 3 weeks, every month, whatever is appropriate in that particular case, then our experience is that means that the health board is being proactive and support and getting to that end goal of having the discharge quicker. And fourthly, if there are any queries, please do come to us as soon as possible so that we can assist you with those when they arise. So that's everything from me. I don't know if anybody has any cases or any questions that they wish to raise. We're unable to talk about specific cases, but we can happily give advice where we can. I can see a hand up.
Hi. There's 2 things really. One is what about when the family flat refuse? If the patient is looking like they will need care support and the family flat refuse to engage. We've had situations where the family are saying, well, if we don't,
that usually would move quite quickly. Usually when I have gone with like previous partners, that's probably been that attraction that
Sorry, somebody's gotten their microphone on. Sorry, carry on, Diane.
It wasn't me, I didn't start talking.
Oh, sorry, whoever was talking.
Christy was talking just then.
Yeah, it was just really whether family are objecting to every suggestion put forward by, the staff. They obviously need care facility. The family, they're not perhaps able to go home, but the family are blocking it every which way.
Is the person under a DoLs?
Yes.
And is
they were, this is a while ago, but they were under a DoLs, but the family were trying to block every which way, and then said to the staff, one of the staff, well, if they stay here, we won't have to pay anything.
It depends on the situation. It might be, if you were looking for them to return home and that was with the family, I think that would cause difficulties if they're not in agreement with that. But if it's a case of trying to move, look at best options and the family are just not engaging with it, an option would be to take the matter to court to say, you know, the family don't agree with the proposals being made. I think that would be dealt with quite quickly because of the expectation that, you know, the person has to be discharged from hospital and somewhere has to be found in their best interest to go to. So unless the family really had strong evidence to support why they were saying no to everything, then I think the judge would deal with that quite quickly.
Right. And sorry, just another question that's just a query about if the patient's transferred for any reason, not necessarily a delay going on somewhere else, but is transferred maybe for a specific treatment and coming back or whatever, with an ambulance, and obviously they use lap straps, whose responsibility is it to say that's in their best interest, or is it just taken that they can use that? Because it is a restriction, and I've just thought I'm not sure whose responsibility is to say, is it the ward because maybe it's part of the treatment, they'll say it's in their best interest, or do the ambulance have processes in place? The ambulance service.
I would say it's for the ward because they have to consider best interest in the sense of the whole move. You know, it does involve the move as well and what that would look like. So I would say it's for the ward to make those decisions.
Yeah. Yeah, and just note it that it's in their best interest that a lap strap or whatever.
Yeah, absolutely. I mean, I think it's difficult with those kind of things. I mean, if we all, you know, went into a car, we have to wear a seat belt. So I think it's quite an easy argument to say that, you know, to put forward that a lap belt obviously is required. If we're talking a number of them and it's, you know, for a long period of time, then that may need to be explored a bit further. But if we're just talking about a journey in a vehicle, then I think that's quite justified.
Yeah. Okay. Thank you.
Thank you. Diane?
Yeah, lovely, thank you. That was really interesting. Thanks all of you for that. And I thank you also for raising how long patients are staying in hospital when they are delayed. And you know, and what's interesting is you're absolutely right. As somebody is delayed as soon as they are in hospital once for 48 hours, once clinically optimized. When you then went through actually the good practice with regards to as soon as they're clinically optimized, we do the nursing and social assessments, options, MCA, BIM, etc. You can just tell that for the majority of our patients, that can't be done in 48 hours. So we have raised this with Welsh Government to say that's just not doable. So we have to keep thinking about this. With regards to court protection delays, we've also had discussions with Welsh Government because about 12 months ago, there was just one code for delay around for court protection. We've now asked them to separate that out so we can identify how long is it taking pre-application, how long is it taking post-application, because earlier on today, I think Gavin might have said, actually, it's not court protection that makes the delay, it's the person that's delayed in hospital ends up going to court protection. So it's the delay in us sometimes just not doing anything quick enough. And because we are dealing with, often these patients are elderly, frail, comorbidities, very complex family dynamics as well. Sometimes we just don't do anything for too long. And then the 21A application comes in, and then the disputes, the DoLs, etc. But I also wanted, it was interesting what you were saying about health boards initiating the application, because one of my questions was going to be around the initiation of court protection, because we are often on the back foot from a health point of view. So we either wait for the RPR to do the 21A or waiting for the local authority to go to court. But we've been talking for months that we have got to get better at initiating our own applications. But the key bit for me, though, and you sort of touched on it earlier on, my other question was, but actually, do we need a place for them to go? Because I would love to start getting better with making the applications, which will then force the hand of local authority who are commissioning the care to get a move on, because we all agree that state is not the right thing for the person. But that all the other cases I've been involved in, we've always had to have a destination for the person. And that's sometimes the sticking point. So if we make the application, we may not have a destination.
No, but it does add the weight. So ultimate, starting point is always try and work with the other public organisations to try and move it forward. But if that's not happening, it is possible for the health board to make that application themselves. And you can say, look, we've been trying to have discussions with local authority to identify somewhere. Ultimately, they're in hospital. They shouldn't be here. It's detrimental to them. We want the local authority to provide evidence of what's available to them. And you're forcing the hand. I mean, sometimes it can. It depends on the relationship you have with the local authority, and obviously we're not trying to alienate them, but it's also giving some power to the health board to try and control the situation. So I think if there's evidence to show that you've tried to move things forward, given them a bit of time to try and find somewhere, but ultimately it's not going anywhere, then I think the health board is completely justified in making that application. And ultimately what we're saying in the documentation that goes with that application is we've done X, Y, Z, they're ready for discharge. There's no, the local authority hasn't found anywhere as of yet. We need that evidence from the local authority and take it from there.
Yeah. Okay. And controlling the momentum, was a phrase that was mentioned. It was just, that's just really good to remember, isn't it? That would be helpful. Thank you ever so much.
Thank you. Vicky, you've got your hand up.
Hi, Nerys.
Hello.
I just wanted to ask, please, do we incur a cost by approaching your team, the complex care team? Is there a cost implication if we come willy-nilly for advice?
If it's a quick query, then no. We're more than happy to help. If it's more detailed, really. So that depends on your situation. So it's hard for me to give a definite answer for that. I mean, I had, not to do with discharge, but I had a mental health query yesterday, and I answered it quite quickly and haven't charged for that at all because I could answer it very quickly. So it does depend on the situation. Ultimately, we're shared services and we're here to assist you, but obviously if it's something that requires a bit more time from us, then we would need to charge for our time.
Another query is that quite often I've been labelled as being a care coordinator due to being a discharge coordinator. However, getting the professionals at a round table meeting when you've got consultants in various different specialities disagreeing and trying to get everybody to coordinate that doesn't give me a lot of clout because I'm a nurse at the end of the day, and I'm trying to get all the higher professionals involved when they just pop me off saying, well, it's not for us, it's for somebody else, and it's always somebody else that should be doing it. And the only consistent factor is a discharge coordinator who's trying to get everybody on board. I'm not quite sure where I can go with that, because what I've been asking in the past is for the director to say, sorry, but you've got to do this, rather than fob us off.
That's what the advice would be. I've been in cases similar to that where it is hard to get. I do appreciate health boards, the teams have lots of different competing demands on their time, but ultimately we have to deal with an individual when that is something that we're, someone that we're responsible for. So I've had cases where this happens, where members of the MDT won't attend, and my advice to that person who's seeking advice from you at the time is to raise it with senior management, because effectively you're not able to do your job. You need other people to be involved in those discussions, and then the umbrella organisation, as in the health board, has somebody that's occupying a bed and steps aren't being taken to get them out of the hospital if ready for discharge, and that is an issue for the health board that they need to address. So my advice, rightly or wrongly, would be to take it up to line manager level and get people to turn up to those meetings so that we can progress the case for that individual. Anyone else? Anyone got any good examples, ways, strategies that you've moved cases forward? Tips? Share with us all. Diane?
I can share. It's not a good example, but it's a bit of a frustration really with regards to quite a few of the cases I've had. We've had patients who are absolutely objecting to move to a care home, which has been the outcome of the best interest meeting, the balance sheets be done, etc., etc. These are all local authority commissions placements, and court protection proceedings have happened. It takes a long time. Not that that's obviously that the whole thing just took a long time. Both patients, one was a husband and wife, and the other was just a single chap, were in hospital for over 12 months, and the transition documents were done in preparation. All three of them went so happily to the care homes. And then when you check up afterwards, they've really settled in, they love their new surroundings. And, all three cases, I had to go back to say, surely we could have done something different 10 months ago. But because as soon as patients are heard to object, that's the key bit. And I think you mentioned earlier on the transition document, could some gentle persuasion be made? It's almost as if now we're unable to do any gentle persuasion to persuade them to go into the care if that is the right outcome for them. It feels as if court protection is mentioned very early on. Which is the right thing if that's what's needed, absolutely. But sometimes it feels as if, is there something else we could have done? Then when you get into that, oh no, this patient's now court protection, and it's in the hands of somebody else, it does feel as if, okay, all bets are off now, and now we just have to wait for this, when the reality was for those three cases, they were so happy with being with transferring into the care home.
Yeah, I think it's a societal point as well, though, isn't it? I mean, if anybody was told you're not going home, where do you want to go? Everybody's going to say home, and so I think it's quite a hard situation to resolve itself, really. I don't know whether any additional work could have been done in just showing what it looked like, but ultimately, if they have the idea that they want to return home, then it's
I get it. Absolutely get it. But you just feel as if somebody is stuck in a hospital environment for nearly a year. When they really didn't need to be. That's the bit for me.
Yeah, no, absolutely. It is. Does anybody have any questions or anything else to add? I'll take your silence as no. Well, thank you very much, everybody. I hope that was helpful. And as I say, please do get in touch if you have any queries following today. But then now, if we can just return back to the main link, I think Gavin's just going to summarise. Great. Thank you very much.
We're going to look at some of the remaining questions. So what we've talked about today is what the court protection is, what its powers are, what it's there for, what it can do. We've talked about what all the different roles from IMCAs and RPRs, judges, lawyers, maybe you in your job and what your input in a court protection case is. And a reminder that court protection is the end point of a process that quite often doesn't need to go to court, and good IMCA compliance can often prevent the need to go to court, but there are certain situations that need to go to court, and we've talked a bit about deprivation of liberty being one of those, where there's a need for public bodies to protect individuals' rights that are enshrined in the Convention. So we've looked at the importance of identifying options and commissioning options, and the same applies to medical treatment options, identifying what those options are and identifying what the information is that's relevant to those options, what are the pros and cons, what are those material risks and benefits of options, so that people can do capacity assessments. And then we've talked about what we do after that, and in the breakout rooms you'll have talked about those processes in different scenarios. And I want to bring back, there was a really interesting question that was put earlier from somebody who was talking about, in the context of somebody with a learning disability and perhaps needing a medical procedure. And there was an initial concern that the person may have lacked capacity, but through various assessments, haven't been able to establish that the person lacks capacity. Important first principle of the Mental Capacity Act is you can't determine that somebody lacks capacity until you've taken all reasonable steps to support to make that decision themselves. And there has to be an impairment that is causing the person to be unable to make a decision. So if you've done that and you've done your assessments and you just can't prove that they lack capacity, so you're working on that presumption, what do you do about it? There's two things. One is two main issues. If there's doubt about whether somebody lacks capacity or not, and you're just not sure, what do you do about that? You can get second opinions, of course. Ultimately, the Court of Protection is there to answer just that simple question. It can be asked just to determine, does this person lack capacity or not? And so you could make an application just purely, does this person lack capacity for this decision? Because if they don't, then we've got a best interest plan and we're happy and there's no dispute about the best interest plan. We can go ahead with that. It's just that capacity assessment. And if you get an answer of, yes, the person does have capacity, well, then they are the decision maker. Now, there's always going to be cases that are difficult. There's always going to be cases that you're going to need support on to work out whether that person has capacity or not. But to take Steve's example, where the conclusion was reached that the person did have capacity, but there was concerns about actually supporting them to make the right decision, the sort of objectively right decision, which is to have the treatment. How do you do that? What do you do in that situation? My thoughts are, I'd be really interested in other people's views on this, but my thoughts are, well, let's think about what support is available for people with learning disabilities. Let's look about what the support is in order to help that person through that process, through that decision-making process. They have capacity to make the decision. Don't forget, capacity is literally that, take that word literally. Somebody has the capacity to make the decision. But they still have to actually make the decision, and they still might need support to make the decision. So there isn't anything that's preventing them from making the decision, but that's not to say that they might not need a bit of support in order to do that. You can have somebody who is maybe not the brightest person in the world. They have capacity to make a decision, but actually they might need support, some education in order for them to be able to do that. So you always have to think about what support. And we know that learning disabilities is a particularly challenging area where we know people with learning disabilities have higher mortality rates. We know that all the health boards have a need to focus on their learning disabilities teams and provide support to clinicians who wouldn't necessarily or regularly come across people with learning disabilities. So having that infrastructure in place, so you have LD teams who are there, able, willing to support in the best way possible, especially if the person needs to come into hospital, and needs to be planning around that as to how you get somebody with autism, learning disability, whatever other condition it might be, who may find admission to hospital and staying in hospital quite distressing, quite confusing, and may cause difficulties in terms of managing behaviours, for example. How do you actually go about planning that? How do you make it the less restrictive? How do you get the right support? I remember years ago we had a lady, she was a psychiatric patient who needed open heart surgery. And the planning that we went through in order to help her to have that, so getting her from hospital into the acute hospital for the heart surgery, and the detail in the planning to get her from A to B in the least restrictive way. They planned a route to get her into the hospital through a back entrance where there wouldn't be any other people around. Got her into her room, set it up in a way that would be suitable for her. Made sure it was a quiet area. Made sure there was access for her to go out and have a smoke that she wanted, because that would be a trigger for her if she wasn't able to have a smoke. Having supportive mental health teams and mental health staff with her all the time to provide that continuity of care that she would have been getting in the hospital that she was in. So really coming up with a plan that wouldn't necessarily be what the average person would get, but really tailoring it to that individual and their needs, and trying to think through all those scenarios and possibilities, and really trying to put that in place. Steve, in your particular situation, I mean, it's difficult to advise in a particular case, and it might be something that's worth a chat at another stage. But what struck me is the concern that the person may only consent to it at a point where it's maybe becoming a bit more risky and they're only in extreme pain. And there may be an element there, and this is something about capacity assessments that people really struggle with, and I get that, is that ability to weigh up. So is there an impairment that's actually impairing their ability to weigh up? Are they, and that can be a really tricky one to think about, because somebody may value things in different ways. They may have different weighing up in terms of, you think of it as a seesaw and weighing up but things that they value. You and I may think of something one way. We would put a lot of value of avoiding pain, whereas somebody else may put a lot of value on something else, which is avoiding being in hospital and the distress that might cause them being in hospital, and are willing to tolerate more pain in order to avoid that. So that could be a really difficult one to understand. Is that an inability to weigh up, or is that they're just weighing it up differently because they value things differently than you or I might? So that's really difficult. But if you've got an understanding of the individual, and if they are assessed as having capacity, and you understand what their values are, then you can think about, well, how do you be supported? We know that individual values avoiding the distress of being in hospital, and they're willing to tolerate pain. Okay, well, how can we deal with this? Can we minimize the pain? Can we reduce the impact of being in hospital? Can we come up with a plan? Can we do the surgery or whatever it is as an outpatient procedure? Can we do it? Can we get them in and out of hospital more quickly? And we've done it before. We've set up the recovery room post-surgery in a different way. They're not just lumped in with everybody else. We've carved off an area and created a recovery room that's more private for them, that would be more in keeping with meeting their needs. So all those those planning, and again, that takes time, and that takes sort of MDT input on how to plan all these things. But quite often when people apply their minds and look at innovative ways to cater for individual needs, there's quite often a solution out there. But I appreciate every hospital is different and everybody has different resources available. And that's where the advice of people like yourself, Steve, specializing in learning disabilities, can help coordinate that and really get people to think differently and make adjustments where they might not ordinarily be willing to do it. We've arranged surgeries for people before where they've carved out an entire morning surgery theatre time. Usually they'll be in and out, and you would get a slot, and you've got an hour slot, whereas actually carving a whole morning for that surgery allows for something to not go according to plan, and allows the individual to maybe take a bit longer getting into hospital, or there's time built in so that you're not forcing them into sedation. You get time to calm them down, get them comfortable, get them support from family or whoever it is. I've seen plans before where went right down to the detail of what do they have for breakfast, what drinks do they have, do they drive to the hospital in a particular way, going past places that they're familiar. So that level of detail can quite often be necessary. Steve, hopefully that sort of answers your question as best I can in a general sense, but of course happy to pick it up with you outside of that. Anna, have you spotted any more questions that we haven't?
Sarah Llewellyn, I think, had a question from the serious medical treatment, that if we could perhaps address it now, Sarah.
Yeah, no, if I could, that would be brilliant. So currently, we're working on a case in Empowers at the minute with this gentleman. Obviously, we can't give too much details of the case, but this is a gentleman who's got a suspected malignant tumour. Unfortunately, due to his mental health diagnosis, this is impacting his ability to make decisions around whether to have surgery to confirm or deny whether this is a malignancy. So I just reflecting on what we were discussing, or on what you were saying in the medical treatment breakout room, and I was curious really as to whether if it does actually need to go as far as a court of protection at this point.
Yeah, so
I know it's difficult without knowing the ins and outs, isn't it?
Yeah, we're often asked, do we need to make a court application? And we're often asked, can you please make a court application? And as I said earlier, usually we try and let's go right back to the start and think it through. I'm a firm believer in the Court of Protection, or sorry, the Mental Capacity Act processes. And if everything is ticked off in the right order, with the right information, and it's all done in a robust way, then usually you don't need to, because you can come up with a plan that maybe minimizes the restriction or does it in a particular way, that maybe establishes that the person lacks capacity, that the whatever options that you were thinking about actually really aren't options, and we've only got 2 options, not 3. So doing all these processes that we've talked about today can quite often come up with a fairly obvious solution. And don't forget, in terms of options, there's always the option of not doing anything. And if the option of not doing anything means death, then there's probably a starting point of, well, maybe it is in their best interest to have treatment. I think cancer is a particularly difficult one, because you've got the diagnosis stage and then you've got the treatment stage, and you've no idea what you're dealing with in terms of what the treatment is going to be, unless you know what you're dealing with. So I think it's usually, I'd say in any cases of, I'm trying to think, how would a judge approach this? I think the starting point would probably be, any judge is going to be keen to at least get a diagnosis and know what they're dealing with. So I think if there was a plan,
reflecting on,
if there was a plan that even needed some restraint, and it really does depend on the level of restraint that would be needed. And I've certainly heard the argument before, but what's the point of having a diagnosis when realistically the treatment is always going to be chemotherapy, that necessitates at least, 8 sessions, for many hours a day, every 3 weeks or something like that. I mean, that'll be fairly standard course of chemotherapy, where somebody has to sit in a chemo chair for several hours. This person could never do that. It would be impossible to keep this person still and compliant with that treatment for several hours. If that's just not possible without literally tying them to a chair and immobilizing them, then you're really straying into, really, is that a viable option? Can we actually do this? How could you physically get chemotherapy drugs into a patient who is that non-compliant? But of course, it's very difficult to think, well, how do we make adjustments for people in order to minimize the impact of that treatment? And I can think back to the case of the young man who needed a kidney transplant, and a lot of the clinicians took the view, well, we're not doing it, we couldn't do it. He's got, I can't remember if it was a learning disability or I can't remember what his underlying condition was, but they felt his behavior would be too challenging, we just couldn't do it. And that was robustly challenged. And the doctors were put in the box and questioned as to why they could not make reasonable adjustments in order to accommodate his needs and come up with a plan that worked for him. And lo and behold, the judge said, no, I think you should come up with a plan and try this. And they did it, and it was fine. In most of the cases that we take to court, because the trigger being there is anticipation of needing quite significant restraint in order to do it, 9 times out of 10, if not more, that restraint is never needed. So I usually think of it this way: come up with a plan that of how you're going to do the treatment, have a line that you're not willing to cross in terms of you've no more than transient restraint, give it a go. And if you can't do it, if you can do it and it goes through fine. And if you can't do it, at least you know where you stand and you know what level of restraint you're going to need to do in order to actually get this across the line. And then you could maybe think about going to court, because you've got evidence, good evidence based then of saying, well, we're going to need this level of restraint. We've tried it. You'd be amazed at the number of patients who say no. But whenever you provide them with the right support and the structure of a plan of what's going to happen, actually that restraint maybe isn't needed as you'd expected. I've got a patient at the minute. I'm saying it's not my patient, but a case involving a patient, and that's exactly what happened. She was really difficult over the past few weeks to come up with a very robust plan, and actually now she's fully compliant with the treatment. So we haven't gone to court on that one, and it seems to be, touch wood, it's working out quite well. So always tricky though.
Oh, that's really helpful. Thank you.
Any other questions?
Yeah, so there's a few in the chat. So there's one from Samantha Morgan, which is third from the bottom, about responsibilities for caring for somebody.
Section 117 aftercare. So with section 117 aftercare, section 117, that's the Mental Health Act, and what that says is that there is a joint responsibility or joint duty between local authorities and health boards to plan and procure, I can't remember the exact wording of the act, aftercare services for people who've been detained under the Mental Health Act. And that's pretty much all it says. It just says it is a joint duty. It doesn't say how that duty should be split. It doesn't say it's 50-50. It doesn't say it has to be paid for 50-50. So it pretty much leaves it down to local arrangements as to how that works. I know some health boards and local authorities have come to some agreement around a basis of, well, if there would have been otherwise, but for the 117, there would have been continuing healthcare, then the health board will lead on it, for example. And that's just an arrangement, but it's entirely up to health boards and local authorities what arrangements they come up to. So as to who takes ownership of care planning and who takes ownership of maybe making an application to court, for example, if there's a dispute over something, that does very much come down to what the local arrangements are between the public bodies. There's no strict rule on that. The general rule of thumb that tends to get applied between local authorities and the health boards, and certainly amongst the lawyers, is generally whoever is the lead commissioner tends to lead on the evidence and leads on making the applications. And that's a bit of a swings and roundabouts approach, whereby if it's a local authority in one case, then they go for it, and if it's a health board in another case, then they lead on it. But to say it's not a strict rule, it's a general principle and rule of thumb that we usually go by. I would say in most cases, Hannah, if we're in front of a judge and the judge was, and we were saying, oh no, that should come from the local authority, and the local authority said it would come from the health board, the judge would probably direct it towards whoever was the lead care coordinating, and probably say something along the lines of health board to file the evidence in conjunction with the local authority if required, but would place the responsibility on the health board to file the evidence, and then it's up to the health board to go away and liaise with its colleagues in the local authority. The expectation being that there is collaborative working between local authorities and the health boards because of that joint duty in section 117, but also the responsibilities for locollaboration under the Social Services Wellbeing Act. So to answer your question, who should take ownership of the person's care needs, that's entirely up to local agreement, I'm afraid.
Yeah. And you've mentioned housing as well, Samantha. That's probably something that we'd usually expect as the local authorities, purely because they've got the infrastructure with which to explore that. So there are certain things where one public body is going to have, as I say, that kind of infrastructure to support, to explore something that the other just simply wouldn't. So there may be reasons within that as well why one public body is going to need to be the one to explore X point, even if actually most of the rest of the exploration falls to the other public body for some reason.
Yeah, identifying the options. So going back to what we talked earlier about identifying the options for accommodation for somebody 117, usually that is local authority, that it's their brokerage systems that are being used, it's their properties that are being used. So usually my understanding is that those arrangements are local authority deal with the housing staff and the health board deals with the mental health part, the nursing care or that's needed. But I don't know of any health boards that would have sort of brokerage procurement arrangements in place to identify supported living placements, for example, for in that scenario. I think those systems are usually local authorities. That's my understanding.
Yeah, the difficulty I think we have is the capacity assessments at the moment around her care. The place she's living is, as I said, really not suitable, and she's actually fallen now and fractured her ankle because of the way the housing is, but she's also not engaging for capacity assessment. So I think the question was, does this fall within the Social Services and Wellbeing Act? Therefore, the authority take the lead around the capacity assessments, whether she has capacity to consent to move in, etc., or whether, because she's coordinator within the CMHT, whether that person takes the lead on the capacity assessments.
In circles, parties will then say, "Oh, but we need a psychiatrist to do the capacity assessment. We don't employ psychiatrists." They can access the psychiatrists, but whether or not, and it's about what's the plan? What is the plan? Who wants to do what? Who is saying that this person needs to go somewhere that they don't want to go? And what's the evidence for that? You can't do it unless you can prove your case.
Yeah.
So that joint duty is sitting there, and it is, there is no hard and fast, it's someone else's responsibility because of that joint duty. Under the Social Services Wellbeing Act alone, just looking exclusively at the Social Services Wellbeing Act, the duty to generally assess needs is the local authorities, and then to meet needs is the local authorities, unless it falls under an NHS Act. So that tends to be, well, if it's continuing healthcare, but then of course there's arrangements in place between local authorities and health boards about doing assessments of their for C&C as well. So again, it's really tricky whenever there isn't actually any legislative framework for saying whose responsibility something is. It's very much an expectation that should be sorted out between you. It doesn't bode well when we end up in court of protection, and it does happen quite a lot, where we're in the court of protection and the major issue and dispute is actually between a health board and a local authority. It does not look good to judges or the public, because these are public proceedings, and they can be reported on. There could be observers there. There's blogs that report in these cases quite regularly, and it doesn't look well whenever local authorities and health boards are at each other's throats saying it's not us, it's you, and pointing the fingers at each other. And that's where usually it just takes some leadership, some seniority within the organizations to say, right, hold on, this is ridiculous. We should not be doing something. We shouldn't be arguing amongst ourselves that impacts on patient care. We should be capable of coming to some agreement as to who's doing what here and work collaboratively together. As lawyers, it's difficult for us to achieve that, and that really takes somebody within the health board to take responsibility for that and try and work with colleagues in local authorities to come to some outcome that doesn't really impact on patient care.
And also, just to follow on from that, I went to a talk quite recently on that exact point, really, about patients who are difficult to assess and who don't engage with capacity assessments. And one of the suggestions made there was about it being a sort of a collaborative approach to try and essentially sort of piece together enough evidence on capacity that enables the judge, because really you're trying to get over that threshold of the judge at least being satisfied on a sort of interim basis that there's enough grounds for them to reasonably believe that they may lack capacity in the first instance, at least, because it may be that the decisions they would take would grant you better access to them or more engagement with them that might better inform your view on capacity after that. But to get to over that sort of initial hurdle, one of the suggestions was that be a sort of collaborative approach, really, of what discussions everybody has had with them, which lends itself to their views on that person's capacity, to try and put together evidence of their capacity, where you've got somebody who otherwise is not going to sit down and engage with an assessment, a one-off assessment from someone they don't know, but actually to gather views on capacity from those who might have had better engagement with the person as they've gone along, and then in trying to have those conversations with them about what is relevant to the decision that's being made now as well.
I spotted another question from Simon Lee. If P is subject to a DoLs authorization in a care home and is admitted to hospital and subject to a DoLs authorization there, do the care home suspend their authorization or does it end? Whose responsibility is it to inform the social services supervisory body that a DoLs authorization has been granted in the hospital, or do they just remain subject to both? Right, Simon, this is going to be a real test of my memory of the schedule in the Mental Capacity Act. But there is certainly a section in it that talks about a change of destination, and that I think is appropriate. I think that's more appropriate when, for example, you've got a care provider who is responsible for pay, so they're the managing authority, and they maybe move somebody sort of internally within their organization, maybe move to a different building. Quite often people with acquired brain injuries would go somewhere and there might be 3 stages, you step down within that facility. But whether you consider that's all one place and actually the DoLs just stays as it is, or whether they need to inform the supervisory body of a change, I think it might probably trigger this is a change of where the person is being deprived of their liberty, because it could be less restrictive, it could equally be more restrictive. So you probably need to tell the supervisory body of that, but I think that would probably count as just a change of I think it's called destination, or change of where it is. Don't forget, if it's an admission to hospital, a DoLs authorization can be in place and up to 28 days in advance. So if you anticipate that that person is going to go back to the care home, if we start from the person hasn't been in the care home yet, they're just in hospital and they're going to be discharged to care home. If you anticipate that they're going to be transferred to the care home within 28 days, that's the point at which that care home should be applying for a DoLs. As soon as they know that that person is going to be there, and then they should be applying for that, and that DoLs ideally should be in place before they go. So by the same token, if somebody is in a care home and go into hospital for an acute reason, and it's anticipated that they're going to go back to the care home, I don't see that there's any reason why that care home needs to terminate that DoLs authorization. I think that can just sit there in anticipation that that person is going to go back there again. Unless there's a significant change of circumstances that might warrant a change of the conditions or a change of, anything in the DoLs, I think you could probably just leave it there and they go back there again. So you could have a DoLs in 2 different places, in my view. Hannah, do you have any different views on that? I think you could have one in hospital to cover the time in hospital, although the time it takes to actually get a DoLs in place, but certainly an urgent could certainly be in place in a hospital, and one for where they're going to go to. It's not technically impossible, and I think it's absolutely correct procedurally to have one in place in a hospital and where the person is going to go to. And I talked earlier about that continuity, and if there's no objections, do you need to go to court? If P is objecting going back to the care home, I don't think you do if you've got one in hospital and one at the care home. But it's an interesting question, and I don't know the particular wording of the schedule off by heart. I'd have to check that out. But
my recollection is I think that you can sort of suspend the one for 28 days during the hospitalization, and then it just sort of comes back in then when you go back without you having to really do too much in the way of paperwork.
You can suspend it if they're detained in hospital under the Mental Health Act, because that's the suspension. But if they're just admitted for either fallen over and broken an arm or something, but they're going to go back to the care home, I think it can just be left in place. Simon, if that doesn't help you and you want a bit more advice on that, come back to us. I would need to get out the schedule to the Act and just double check that.
Yeah, that's fine. I think Bev from Betsy Cadwallader DoLs has emailed you.
Yes, she did.
More specifics, because I think it came to mind because there's an existing 21A in the care home and the gentleman's been admitted to hospital, and I think it's whether he can return and the 21A continues. I don't have full details, but she's emailed you. I'm sure he will respond directly.
I would not. Yeah, I wouldn't. I wouldn't worry too much about discharging somebody back to a care home that they came from, unless there's reason to believe that's no longer in their best interest.
Yeah.
And don't forget, it's not about best interest about where they live. It's about best interest whether or not they should be in hospital. And that's something that I think we're not. I'm sure it was probably touched on in the breakout room about delayed discharges. Is that I don't think we're very good, and I say we collectively within health boards, of evidencing why it's not somebody's best interest to remain in hospital. So all those risks associated with being in hospital, loss of mobility, loss of muscle mass, infection risk. We know that people that are sort of confined to bed in a hospital can lose muscle mass at a rate that is just exponentially different to anyone else. That they are put at significant risks. But we sort of know that in principle. But in individual cases, actually, it's quite difficult to get that evidence from a witness who's prepared to evidence that. And the counterpoint then that those representing P will always take, and the judges sort of tend to default to, is I don't like moving somebody twice. Therefore, they are where they are. I don't want to move them to an interim measure care home and then potentially move them again, because everyone is aware of that a potential step deterioration of moving somebody more than once. But we're not producing the evidence to counter that. So I'd be really encouraging of anybody who has somebody who is considered to be clinically optimized in hospital, think about where you're going to get your evidence that it is detrimental to this person to be in hospital. Irrespective of where they go next, care home or home, doesn't matter. Being in a hospital is manifestly not in their best interests. It's going to cause them harm. They're going to lose mobility. It's going to increase their falls risk. It's going to put them at risk of infection, everything else. Let's really think about how we can evidence that better, because we're armed with that evidence. We will be in a much better position to help you make applications to get people discharged from hospital on an interim basis, and leave that decision of home versus care home to quite often as local authorities and those representing P, and that might not involve the health board at all. So let's try and work on that, and getting that evidence and helping get people discharged from hospital as quickly as possible.
Agreed. Thank you.
Any more questions before we bring the day to a close?
I just ask, sorry, a really quick one.
Sure.
So, person with a learning disability has gone to their GP. GP's done capacity assessment on having bloods taken and said that the person lacks capacity. But in order to have the bloods taken, the person needs to be in a clinical hold. Does the GP need to then do a capacity assessment around the restraint to take the bloods, or does that fall within the capacity of taking bloods, if that makes sense?
Well, if you think about it, in order to take blood, you're going to need to do the restraint. So the taking the blood includes the need for the restraint. So the capacity assessment is kind of the package, isn't it?
Yeah.
Because you can't do it any other way. As to who's responsible for that, it's quite often quite challenging when you get GPs who are essentially the decision maker. But we know from experience, a lot of GPs, if it becomes a capacity issue or if it becomes a best interest issue, they tend to sort of send that to the health board. And as well, hold on, this is a primary health issue, it's not a secondary health issue, but what's the health board's role in this? And you've got, it's particularly relevant in screening, for example, and who is the actual decision maker and who's doing the screening, who's the person who needs the Section 5 defence, or can they rely on the capacity assessment and the best interest decision made by a GP, or do they need to do it themselves? So it's certainly not straightforward in those situations now. One more from Steve.
Thank you.
Hi, the blood test one is a very familiar tale for us community nurses. I've arrived at the point where I believe my client has got capacity, but I still want to put together a contingency plan in advance of the point where he requires urgent treatment, because that might happen and could happen at any time. this has gone on for probably a year now since he first was referred to me. So, the idea that he requires urgent treatment now doesn't stand up, because he's gone for a whole year without any problems. Yeah. But it could change at any point. That's the thing. So I want to explore the idea of putting together a contingency plan and getting the court to look at it and approve it in advance of the point where he loses his capacity due to impaired decision making.
Yeah, I understand. So that idea of anticipatory declarations, I've put an article in the chat. I've listed a few articles that I thought might be helpful, and one of those is on anticipatory declaration, and I can come back to you with some other advice around that. But my general thoughts, and I touched on this earlier, is if you think somebody has capacity, then come up with your plan.
Yeah.
The contingency plan. By all means, come up with the contingency plan and put that to the patient.
Yeah, I listened with interest to your
capacity,
comments.
Yeah, for them to have capacity, they need to understand one of the things they have. One of the relevant information is that they may end up in that contingency situation. So what do they want you to do in that situation? Do they consent to all the things that are in the plan? Do they consent to the use of restraint? Do they consent to maybe being taken to ITU or whatever it is that you have in plan to manage that situation? Do they consent to the operation in those circumstances? If they really have capacity, then they can just make a decision at the point at which they have capacity. And if they say, no, I don't agree to that, then you're into the realms of advanced decision to refuse treatment, and you want to be able to support them to actually make that advanced decision to refuse treatment. If they consent to it, get the care plan signed off, they've consented to it. So whenever it comes to doing it, and if you think they lack capacity at that point or whatever, then you've got the sign-off consent. Don't forget, you can consent to a deprivation of liberty. And this happens quite regularly. People maybe don't think of it this way, but if I'm going for a medical procedure and it is anticipated I may have an ITU stay afterwards, well, it's very common for people that an ITU, you're having delirium when they come around from an anaesthetic, and they would technically be deprived of their liberty in those circumstances. But you consent to that. You're consenting to go into ITU. You're consenting to the care and treatment that you're going to need as part of that post-anaesthetic plan. So you can consent to deprivation of liberty, okay? And you can consent to that in advance. It's just about thinking through that plan, evidencing it, talking them through with the person with the right support, considering that capacity again if you need to, and getting them to sign off on whatever that plan is. That would be fine, yeah.
Yeah, I think I anticipate that being not as quite straightforward as you describe it. I think it's going to be very, very difficult.
The courts are very reluctant to make anticipatory declarations when there are lots of unknowns, especially about when and what circumstances the person may lack capacity. It's more common whenever you've got an absolute dead cert, this person is going to lose capacity once we do something, and can we have a decision about what to do in those circumstances. And I think one of the cases, there's a whole series of them, and I think I've put an article which links to some of those cases, and it talks about actually this is where Section 5 comes in. So Section 5 of the Mental Capacity Act gives you that defence to do things that if you have a reasonable belief they lack capacity and a reasonable belief it's in their best interest. So rely on that. Actually, that's a lot better, almost better than going to court, because it gives you that flexibility as long as there's some structure and guidance for those who are working with the individual as to how and when you to make those decisions about whether they have capacity or not.
I think what I've got from that is I should go ahead and make a plan, make all the adjustments, that required to make it as smooth as possible on the day when he requires the treatment, and on the day we will be relying on Section 5. I don't think we're going to get. We're not going to get his consent.
I can't give you specific legal advice in any scenario.
No. But that's what I'm thinking.
Broad principles. But absolutely, come back to this if you run into any problems, and we can advise.
I don't think we're ever going to get his consent to any plan, because he just freaks out as soon as you even start talking to him about anything to do with his health. He just runs out the room screaming and shouting. It's just not.
So if you think that back then to capacity, if he's doing that, is that an inability to weigh up? Is his condition preventing him from even being able to weigh it up?
We've tested it. We've tested his ability to weigh up by using other things that aren't related to his health. We've talked about things like safety and the ability to anticipate risks. So one of the things he used to do was chop wood. And we said, if I was chopping wood, what sort of shoes would I wear? Oh, you'd have to wear steel toe caps because you could cut your feet off. So he understands that.
He just can't face making that decision. He's unable to make the decision. It's whether it's related to his condition or not. That's a really tricky one, and it's something I'm happy to talk to you outside of today. We'll wrap it up there.
Yeah,
thank you everyone for a really good day. Hopefully you've had some benefit from this. Don't forget, the materials are there for download. Feel free to use them. We've tried to make them user-friendly for you as practitioners. There is any number of guidance documents on the internet, especially from some chambers and some. I've put some articles on. That's a great website I've linked to that has very up-to-date articles about new cases that are coming out and some themes that are particularly relevant at the minute. But just go back to the underlying theme, really, when it comes to court of protection, is don't be scared of court of protection. Think about IMCA compliance. Good IMCA compliance will probably help you avoid going to the court of protection, or if you do go to the court of protection, it should make it a fairly swift process. Court of protection is supposed to be a swift process. What causes the perceived delays in the process is actually the poor initial IMCA compliance. So the better you can get it right in the first instance, the better and easier it will be to get through the court of protection process. We're here to support. Yes, we are. We need to be instructed by health boards. We are a sort of a service that is a pay-as-you-go, in the sense that we are not centrally funded, so we are on a sort of paid case-by-case basis. But we've got a whole team here and we're split into teams that cater for particular health boards. We're very familiar with how you work and your local needs. We can cater for things in Welsh language. And I've put a link in. Actually, I've just seen very recently there was a judgment done in Welsh. So we can cater for that, as can the courts. So look, I encourage you all to seek out that support within your local health board. Come to us for legal advice if you need it. We will help in any way we can. And our aim really is to help you act in the best interest of the patient. So we're all, the unique thing about court of protection is everyone is seeking the same thing. It's not that adversarial a process. Sometimes it can be, but everyone is really trying to arrive at that one ultimate outcome, which is whatever is in the best interest of the patient. So, diolch yn fawr, thank you very much for today, and that'll do. Thank you. Cheers, everyone.